ಬನ್ನಿ ಬನ್ನಿ.
ಮತ್ತೆ 4 ಗಂಟೆ ತನಕ ರಿಯಾಕ್ಷನ್ import ಅಂತ ಕನ್ನಡ ಪಾಸ್ ಅಂತ ಕೇಳ್ತಾರೆ.
ಸರ್ ಹೆಸರು ಹಾಕಿದ್ದೀನಿ ಸರ್.
ಸ್ವಲ್ಪ ಚೆನ್ನಾಗ್ತವೆ. ನೀನು ಚೆನ್ನಾಗಿ ಫೋಟೋ ಹೊಡೆದು ಒಳ್ಳೆ ಪಾಸ್ ಎಲ್ಲ ಕೊಡ್ತೀವಿ.
ಸರ್ ಚಿಕ್ಕ ಚಿಕ್ಕ ಆರೆಂಜ್ ತರಿಸ್ಕೊಂಡು
ಮಾಡ್ಕೊಡ್ತೀನಿ. ಇಲ್ಲ ಸರ್, ಅವ್ರು ಡಿಸೈನ್ ಮಾಡಿರಲ್ಲ ಸರ್, ಅವ್ರನ್ನ ಕಿಂಗ್ ಚಾರ್ಲ್ಸ್ ಫೋರ್ ಬೆಂಗಳೂರಲ್ಲಿ ಇಂಡಿಯಾ. ಮತ್ತೆ ಕೋಲ್ಕತ್ತಾದಲ್ಲಿ ವೆದರ್ ಸರಿ ಇಲ್ಲ, ಗವರ್ಮೆಂಟ್ ಸರಿ ಇಲ್ಲ. ನಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ ಸರ್, ಹಿಸ್ಟಾರಿಕಲ್ ಇಂಡಿಯಾದಲ್ಲಿ ಡೆಲ್ಲಿನೇ ಕ್ಯಾಪಿಟಲ್ ಮಾಡಬೇಕು.
We should greet each other.
Yes.
Yes.
In the KEA competitive examination, the petitioners are succeeded, my lord. After succeeding, they have selected in the final list also. After selecting the select some unknown persons has given the false complaint. Their academic certificates are false. Before starting the investigation, they have removed from the final list. And after thorough investigation, all the academic investigations, all the academic certificates
ಏನ್ ಮಾಡು
KET, all the academic certificates are genuine.
ಹಾ
Report.
ಏನ್ ಹೇಳು
KE ಏನ್ ಮಾಡಿದ್ದಾರೆ KSAT ಅವರು ವಿತೌಟ್ ರೆಫರಿಂಗ್ ದಿ ಕವರ್ಡ್ ಬೈ ಜಡ್ಜ್ಮೆಂಟ್ಸ್ ಅಂತ ಹೇಳಿ ಮಾಡಿದ್ದಾರೆ. ಬಟ್ ಕವರ್ಡ್ ಬೈ ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ದೇರ್ ಸರ್ಟಿಫಿಕೇಟ್ಸ್ ಆರ್ ನಾಟ್ ಜಿನೈನ್,
ನೆಕ್ಸ್ಟ್
ಫೇಕ್. ನಮ್ದು ಜಿನೈನ್ ಅಂತ ಅದಕ್ಕೆ ತರ್ಸಡೆ ಮೇಲೆ
ನೆಕ್ಸ್ಟ್
ಆಯ್ತು.
Recovery matter is pending. They have initiated the recovery.
ರಿಕವರಿ
In 2004, service has been absorbed.
week after next.
My lords,
Sir.
petition is suspended, my lords. KPSC has not granted interim order. Subsequent to that, my lords, Vigilance Authority has also issued notice. Regarding the notice, my lords, he has to appear today at 2:30, my lords.
Aye.
The lords should take up the matter tomorrow, my lords.
ಯಾಕೆ ಏನ್ ಅರ್ಜೆನ್ಸಿ ಅಪಿಯರ್ ಆದ್ರೆ ಏನಾಗ್ತದೆ
My lords, the urgency is, my lords.
Next.
Lords, in appeals against adjudicating authorities order under PMLA Act, I made a submission that adjudicating authority did not consider any of the materials I placed and matter should be remanded so that, my lords, my right of a first adjudication and a first appeal is preserved.
ಅರ್ಜೆನ್ಸಿ
My lords, now appellate authority is initially taking a view that it will consider the question of remand, turned around and said, I will not consider question of remand, argue on all other issues day after tomorrow. I'll be denuded of my right of appeal, my lord, so I'm moving a writ for tomorrow, my lords. Because adjudicating authority considered no issues. It in fact says you have not placed any material.
ಬಟ್
I placed all the material on record.
ಬಟ್ ಅದರ್ ಅಥಾರಿಟಿ ವಿಲ್ ಕನ್ಸಿಡರ್
No, my lord, in
ಸೆಕ್ಷನ್
the,
8 ಕಡೆ ಏನಿದು
my lord, section 8 is confirmed in a complaint.
ಹಾ
I'm in appeal against that complaint.
ಅದೇ
In the complaint, my lords, I placed all the materials.
ನೆಕ್ಸ್ಟ್
None, my lords, the hearing is day after tomorrow.
ಆಗ್ಲಿ ಅದು ಆರ್ಗ್ಯೂ ಮಾಡಿ
Lord, if they-
Tomorrow, my lord.
ಏನ್ ಅರ್ಜೆನ್ಸಿ
Grateful.
Thing is not settled, my lord.
ತಳಿ ವೀಕ್ ಆಫ್ಟರ್ ನೆಕ್ಸ್ಟ್ ಹಾಕಿ
Your lordship, it's a fresh matter, tax matter. There's threat of recovery. I had already moved a memo last week. It was not posted yet. So I'm praying it be posted tomorrow.
ಯು ಹ್ಯಾಡ್ ಮೂಡ್ ದ ಮೆಮೋ
I've moved the memo last week, but it was not posted today.
ಯಾಕೆ ಬಂದಿಲ್ಲ ನೋಡಿ.
My lord, this is a DRIT matter, my lord. I have withdrawn the writ petition earlier. I filed with a leave of this court to file a fresh writ petition. This is an education institution. The bank is trying to take the physical position, my lord. Exams are going on. About 1,050 children are studying, my lord.
ತೊಳಿ ನಾಳೆ ತೊಳಿ
Much.
Service matter.
ಹಾ
My lord, service matter, post-retirement, disciplinary
Week
proceedings.
after next.
My lord, a date.
ಬರುತ್ತೆ.
Not it's a fresh matter, my lord, matter pertaining to seniority of superintendent of police. Not seniority is quashed. Entire promotion in the state pertaining to superintendent of police and UISP is stalled. Not a fresh matter, may I request for tomorrow,
ವೀಕ್ ಆಫ್ಟರ್ ನೆಕ್ಸ್ಟ್ ತೊಳಿ Next.
day after tomorrow, my lord.
Transfer matter, my lord.
ಟ್ರಾನ್ಸ್ಫರ್
Yes,
ಯಾವಾಗ ಆಗಿದ್ದು ಟ್ರಾನ್ಸ್ಫರ್
my lord, the tribunal, my lord, has held against me, against the final.
ಟ್ರಾನ್ಸ್ಫರ್ ವಾಸ್ ಡನ್
My lord, January 2025.
ವೀಕ್ ಆಫ್ಟರ್ ನೆಕ್ಸ್ಟ್ ಹಾಕೊಳ್ಳಿ
It's fresh matter, my lord.
ನೆಕ್ಸ್ಟ್
My lord, one more matter, my lord. Sub-registrars, your lordships had heard this matter, my lords. Now there's an interim order passed. It is not compliant, my lords. Now we are nowhere, my lords. Neither there nor here, my lords. It's been going on since October.
ಅದು ಯಾವಾಗ
My
ಬರುತ್ತೆ
request.
ಮ್ಯಾಟ್ರ್
There's no date fixed.
ನೋ ಡೇಟ್ ಫಿಕ್ಸ್
No date fixed. My request. my lord.
ಏನ್ರಿ ಯಾಕೆ ಕಂಪ್ಲೈ ಮಾಡಲ್ವಾ ಆರ್ಡರ್ ಜಸ್ಟಿಸ್ ಸೋಮಶೇಖರ್ ಏನ್ ಬರ್ದಿದ್ರು ವೈ ಆರ್ ಯು ನಾಟ್ ಕಂಪ್ಲೈನಿಂಗ್ ಅನ್ಕೊಂಡು ಆರ್ಡರ್ ಇತ್ತಲ್ಲ ಅದರಲ್ಲಿ ಬ್ರದರ್ ಜಡ್ಜ್ ಸೋಮಶೇಖರ್
AG is appeared before the court and submitted. We have fully complied the order passed by this court.
ಕಂಪ್ಲೈ ಮಾಡಿವಿ ಅಂತಾರೆ
My lord, if
Sorry,
it is
next week.
Very well.
Pending matter, my lords. Penalty is imposed without second show cause notice, my lords.
ಪೆನಲ್ಟಿ
Is imposed without second show cause notice, my lords.
ಟ್ಯಾಕ್ಸ್ ಮ್ಯಾಟರ್
No, my lords.
Huh?
Service
ಸರ್ವಿಸ್ ಮ್ಯಾಟರ್
case it.
ಯಾವಾಗ ಆಗ್ತದೆ ಎಲ್ಲ ಅಲ್ಲಿ ಮೈಕ್ ನಲ್ಲಿ ಮೊದಲೇ ವೀಕ್ ಕೇಸು ವೀಕ್ ವಾಯ್ಸ್ ಹಾ
Yes, my lords.
ಮಾತಾಡ್ಬೇಕು
Yes, my lords.
Ah.
Penalty is imposed without second show cause notice,
ಯಾವಾಗಮ್ಮ
my lords.
ಯಾವಾಗ ಆಯ್ತು ವೆನ್ ಇಟ್ ಹ್ಯಾಪನ್
2023 matter, my lords.
23 ಕಾಲ್ ಆಫ್ಟರ್ 4 ವೀಕ್ಸ್
Another one matter infractions.
ಹಾ 15 4 ವೀಕ್ಸ್ ಓಕೆ ಎಸ್ ಹಾ ನೋಡು ಈ ರೀತಿ ಬರ್ಕೊಂಬಿಡಮ್ಮ ಪ್ಲೀಸ್ ಮೆಮೊ ರೀಡ್ಸ್ ಆಸ್ ಅಂಡರ್ ಓಕೆ ಇದು ಎ ಜಿ ಹೆಸರು ತೋರಿಸ್ಬೇಕು ಓಕೆ ಹಾ
My lord, in this subsequently, we have obtained a report who are all.
ಈ ಕಡೆ ಬನ್ನಿ ಮೈಕ್ ನಲ್ಲಿ ಮಾತಾಡಿ ಎಲ್ಲರಿಗೂ ಕಾಣಂಗ್ ಹೇಳ್ಬೇಕು, ಎಲ್ಲರೂ ನೋಡ್ತಿರ್ತಾರೆ, ಜನ ನೋಡ್ಬೇಕು. ಕೋರ್ಟ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಅನ್ನ, ಜಡ್ಜ್ಗಳನ್ನ, ಲಾಯರ್ಸ್ ಎಲ್ಲರನ್ನು ನೋಡ್ಬೇಕು.
My lord, as per the directions of this honorable court, survey was conducted, my lord.
ಹಾ,
Some of the persons have obtained a kata from the panchayat and they are in possession of the property by constructing an houses, my lord. We have obtained a report from the concerned panchayat, my lord. We'll furnish that, my lord. Weeks accommodation has to be granted to us, my lord.
ಯಾವ್ದಕ್ಕೆ ಏನ್ ಮಾಡ್ಲಿಕ್ಕೆ?
ಸರ್ವೆ ಕಂಡಕ್ಟ್ ಮಾಡಿದೀವಿ. ಸರ್ವೆ ಕಂಡಕ್ಟ್ ಮಾಡಿ ಇದಾದ್ಮೇಲೆ ಪಂಚಾಯತಿಯಿಂದ ಖಾತೆ ಮಾಡಿಸ್ಕೊಂಡು ಪೊಸಿಷನ್ ಅಲ್ಲಿ ಇದ್ದಾರೆ 23 ಗುಂಟೆ ಜಾಗದಲ್ಲಿ. ಅವ್ರಿಗೆ ನಮ್ಗೆ ಅದು ಹೆಸರುಗಳೇನು ಗೊತ್ತಿರಲಿಲ್ಲ. ಆ ಕಾರಣಕ್ಕೆ ಪಂಚಾಯತಿವರೆಗೆ ಇನ್ಸ್ಟ್ರಕ್ಟ್ ಮಾಡಿದ್ವಿ. ಪಂಚಾಯತಿಯವರು ಪ್ರೊವೈಡ್ ಮಾಡಿದ್ದಾರೆ ಲಿಸ್ಟ್. ಒಂದ್ 4 ದಿವಸ ಕಾಲಾವಕಾಶ ಕೊಟ್ರೆ ಅದನ್ನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತೀನಿ ಸ್ವಾಮಿ.
ಕಾಲ್ ದಿಸ್ ಮ್ಯಾಟರ್.
ಲಾರ್ಡ್ಶಿಪ್, ಒನ್ ಹಂಬಲ್ ಸಬ್ಮಿಷನ್.
ಹಾ.
ಇದ್ರಲ್ಲಿ ಏನಾಗಿತ್ತು ಅಂದ್ರೆ ಸ್ವಾಮಿ, ನಾವು ಕೇಳಿದ್ದು ರೋಡ್ ಕೂಡ ಒತ್ತುವರಿ ಮಾಡಿದ್ದಾರೆ, ಸರ್ವೆ ನಂಬರ್ 71. ಸೊ ಅದು ರೋಡ್ ಒತ್ತುವರಿ ಮಾಡಿಲ್ಲ, ಯಾಕಂದ್ರೆ ಅದು ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ನೋಟ್ ಆಗಿಲ್ಲ. ಕೈಂಡ್ಲಿ ಅದನ್ನು ಇದ್ ಮಾಡಿ ಸ್ವಾಮಿ, ಯಾಕಂದ್ರೆ
ಸ್ಕೆಚ್ ಹಾಕಿದೀವಿ ಸ್ವಾಮಿ, ಒತ್ತುವರಿ ಆಗಿದೆ ಅಂತ.
ಇಲ್ಲ
ನೆಕ್ಸ್ಟ್
ಎಸ್ ಮ್ಯಾಮ್.
next. Okay. At the request of the DGA, finally.
Yes, ma'am.
Finally, first stop. Next. Yes,
Petition, kindly grant 1 week, my lord.
1 week. 2021 matter. ಕೊಡ್ಬೋದಾ? ಕೊಡ್ಬೋದು.
Penalty order ಆಗಿದೆ. That has been changed.
ಆರ್ಡರ್ ಆಗಿದೆ ಆಲ್ರೆಡಿ after 2 weeks.
Series of other batches were also there. 2 of them have been disposed. I think 3 or 4 of them have been disposed of. ಅವರು ಕೇಸ್ ಟು ಕೇಸ್ ನೋಡೋಣ ಅಂತ ಹೇಳಿದ್ರು ಕೋಆರ್ಡಿನೇಟ್ ಬೆಂಚ್.
Matter pertaining to, my lord, departmental proceedings initiated against petitioner.
Are you ready in the matter?
Yes.
ಕೊಡಿ. ಆರ್ಗ್ಯುಮೆಂಟ್ ಆದ್ಮೇಲೆ ಮತ್ತೆ ಟೈಮ್ ಕೇಳಕ್ ಕೊಡಲ್ಲ. ಕೊಡಿ. Which is your matter? Let us see all
There
the
are
connected matters, na?
Batch of matters are there.
Are you ready in the matter? Again, we are asking.
In the case where Satish is arguing, Lord, 6133, if it is, Lord, I am ready. Other
No,
cases,
ಎಲ್ಲ ಅಷ್ಟು all matters.
ಇಲ್ಲ, other cases ಅಲ್ಲಿ 2 ಕೇಸ್ ಅಲ್ಲಿ ನಮಗೆ ನೋಟಿಸೇ ಆಗಿಲ್ಲ.
ಯಾವ್ದ್ರಲ್ಲಿ
I
ಆಗಿಲ್ಲ?
think 3.1
and 3.2.
Shri, no, Shri Arbatti is requested to accept notice for. So and sorry, copy ಕೊಡಿ.
There are about 5 matches, my lord.
ಕೊಡಿ.
Lordship could give me 2, and there is one more colleague of mine, my lord, Mr. Prasanna Shetty.
ಅವ್ರಿಗೊಂದು ಸ್ವಲ್ಪ ಇವ್ರಿಗೊಂದು ಸ್ವಲ್ಪ ಕೊಡಿ. ಕಾಪಿ ಕೊಡ್ಬೇಕು ಅವರಿಗೆ. Petitioners to serve copy of the petition along with all the documents on the learned panel council appearing for the Lokayukta and file acknowledgement in the registry within 1 week, failing which petition stands, respective petition stands dismissed. Yes. Call 2 weeks. Call out. Haladi ಅವ್ರ ನೇಮ್ ಡಿಲೀಟ್ ಮಾಡೋಣ. ಹಲಾಡಿ ಇಲ್ಲಲ್ಲ ಈಗ.
Retired from the panel.
2 ಇದೆಯಾ?
3.1 and 3.2, my lords.
3.1, 3.2. ಒಂದು ನೀವು ಒಂದು ಇವರು ತೊಳಿ.
Prasanna Shetty ಇಲ್ಲ.
ತೊಳಿ.
31 also.
3.1 ಇವರು 3.2 ಅವರು. Okay. Permitted to retire.
Please.
Yes. Call after 2 weeks. Same order, petition to be, ಅವ್ರಿಗೆ ಒಂದ್ಸರಿ ಕಾಪಿ ಕೊಡ್ಲಿಕ್ಕೆ ಹೇಳಿ. Yes, next. ಉಮೇಶ್ ಮೂರ್ತಿ. ಏನಿದೆ?
An application for early hearing, my lord.
Early hearing,
In fact,
ಏನಿದೆ
my lord,
ಕೇಸ್ ಏನು?
This is a seniority list, my lord, Department of Forest. In 1999, the final gradation list has been attained the finality. Subsequently, without.
ಗುರುಮಟ್ಯಾರಿಗೆ.
Please to forgive me.
ಹೇಳಿ.
This matter had come up last time also,
Ah.
and before several benches and before your lordships also.
Ah.
One and the only point involved in this case is the seniority, final seniority list once published cannot be altered.
Except with the leave of the court, with the orders of the court.
Please, that's all the my lord, point involved in this. And my lord, on the previous occasion, the government had taken a contention that there is a court order. I have made a search. There is also a direction 1 year ago to produce that court order.
ಇಲ್ಲ.
No, there is no court order. My instructions are there is no court order.
Are you ready in the matter? Ready?
No, date may be fixed. We are the respondents. Respondents,
You are not ready.
please. They have filed early hearing. We engage the senior counsel. Last occasion also is coming.
Early hearing application is allowed. Allowed. First off, call these matters in the 2nd week of April. for final hearing at the request of other side. Finally.
May I make a submission, my lord?
Ah.
My lord, I appear for respondent number 16. My name is not reflected in
No,
the
no,
cause list.
name of madam to be shown. What?
Please.
Of the second ಆಗಲ್ಲ third week ಹಾಕೋತೇವೆ ongoing matter ಇದೆ ಒಂದು KPSC ದು. ಆ ಕಾರಣಕ್ಕೆ.
Before we can make a further request,
Ah.
a particular date may be given, my lord. If it's convenient, your lordship.
ಅದು ಗೊತ್ತಾಗಲ್ಲ ಅದು. ಯಾಕಂದ್ರೆ ಎಷ್ಟೋ ಮ್ಯಾಟರ್ಸ್
ಹೌದು, ಹೌದು,
ನೋಡ್ಕೊಂಡು ಮಾಡ್ತಾರೆ.
Please,
ಅದು
madam.
ಬರ್ಲಿದ್ರೆ ನಮ್ಗೆ ಹೇಳಿ ನಾವು ಇಲ್ಲಿ
Please, madam.
ರಿಮೆಂಬರ್ ದಿಸ್
Please, minutes,
Yeah.
please. minutes.
The
What
same,
point
my
two?
lord. Three matters are same.
Actually, his name is Raghu, my lord. He's a wrongly.
ಅವ್ರು ರಾಂಗ್ಲಿ ಮೆನ್ಷನ್ ಮಾಡ್ಯಾರ ಅಂತನಾ? ನೋಡಿ ಅದ್ಯಾವ್ದು ರಘು ಅಂತ ಮಾಡೋದಿತ್ತಂತಲ್ಲ ನೀವು. ನೀವೇ ತಪ್ಪಾಗಿ ಮಾಡಿ ಹಿಂಗಾಗಿದೆ ಅಂತಾರ ಅವ್ರು. ಸರಿ ಮಾಡಿ.
It will be rectified.
Umesh Murthy, Lieutenant Counsel Umesh Murthy agrees to rectify the name of Mr. 14th respondent as Raghu. Raghu, in the place of Raju. Raju, leave granted. Leave granted. Okay. In view of that, office objection does not survive. Sari madikodi. Next.
Point one, my lord. Service is awaited. In 5 minutes, the government was called upon to provide. The government was called upon to provide its say in the matter, because we have also not sought for indulgence of this honorable court in relation to Rule 214 of the KCSR.
Retired employee, no?
Yes. In your lordships are aware, there's an additional layer of inquiry, preliminary inquiry conducted under Lokayukta Act, apart from the disciplinary inquiry after the interestment order. So there is an additional time, my lord, which is spent, my lord, in the proceedings, my lord, arising out of, my lord, investigations conducted by the Honorable Lokayukta or Uplokayukta. So, my lord, we have sought for, my lord, orders in relation to Rule 214. My lord, the AG was called upon, my lord, in the earliest stage.
Ondsari to entrustment ಆತು ಅಂದ್ರೆ.
Yes.
Additional ಮಾಡ್ಲಿಕ್ಕೆ ಬರ್ತದ enquiry ಮತ್ತೆ?
My lord, after, no, my lord, what I am trying to say is, my lord, in general course, my lord, if a misconduct is found prima facie, my lord, directly, my lord, show cause notice, my lord, thereafter articles of charge, if the disciplinary authority finds fit. In the, under the proceedings under the Lokayukta Act, there is a notice, there is comments called upon, then investigation if required, then, my lord, 12-3 report, then, my lord, inquiry. So, my lord, there an additional time which is spent, my lord, in relation to the proceedings under the Lokayukta Act. For that purpose, my lord, we have sought for indulgence of this honorable court in relation to Rule 214. My lord, we had also represented to the government. Government has not responded. And, my lord, there is a law commission set up by the government, my lord, in relation to advise, my lord, on the aspect of Rule 214. In cases where more time is spent in the preliminary investigation and inquiries, my lord. For example, my lord, the mining cases. My lord, the misconduct in relation to mining cases took place somewhere between 2000 to 2005. The report of the Honorable Lokayukta came only in 2007 and 2011. By the time proceedings were initiated, it was about 2015. So, my lord, in those kind of cases, there is one more batch of forest related misconduct cases, my lord, where again the government had my lord, sought the recommendation of the law commission. So, my lord, in those circumstances, we have sought for, my lord, a clarification or, my lord, a reading down of Rule 214 in so far as, my lord, those kind of proceedings are concerned. So, my lord, this on the coordinate bench earlier.
214 is by the government itself. Government is the author.
Yes.
214.
Yes.
You requested them to do something.
Do something.
There
And
is no response from the
there
government.
is no response. And also, my lord, they have also, my lord, sent, my lord, a representation to the law commission
Saying
requiring, my lord,
what kind of modification should
yes,
happen.
Yes, yes. So, my lord, more or less, the government would be, my lord, supporting our writ petition here.
What happened to, see, you sought for opinion of the recommendation at the hands of the law commission, state law commission, now headed by Honorable Justice Inchigiri. What have you done? When did you send that representation to the government? ಲೋಕಾಯುಕ್ತರು ಕಳಿಸೋ representation you respond ಮಾಡಲ್ಲಪ್ಪ? ನೀವೇ ಅಪಾಯಿಂಟ್ ಮಾಡಿದ ಲೋಕಾಯುಕ್ತ, ಅವರಿಗೂ ರೆಸ್ಪೆಕ್ಟ್ ಕೊಡಲ್ಲ.
Government has interest under 14A lordship.
See, when the report was sent to the government, ಎಲ್ಲದಕ್ಕೂ ಕೋರ್ಟಿಗೆ ಬರಂಗಾಗಿದೆ ಈಗ. ನಾವೆಲ್ಲದನ್ನು ಮಾಡ್ತೀವಿ, ನೀವು ಮುಂದೆ ಎಷ್ಟೇ ಯಾರ ಮಾಡಿಕೊಡ್ರಿ ಎಂತಾದಾರ ಮಾಡಿಕೊಡ್ರಿ. ಲೋಕಾಯುಕ್ತ ಕಳಿಸುವಂತ ಲೆಟರ್ 214 ಅನ್ನ ಇಂತಿಂತ ಸರ್ಕಮ್ಸ್ಟೆನ್ಸ್ ನಲ್ಲಿ ಡಿಲೇ ನೀವು ರಿಲ್ಯಾಕ್ಸ್ ಮಾಡ್ಲಿಕ್ಕೆ ಒಂದು ಪ್ರಾವಿಷನ್ ಬೇಕು ಅಂತ ಕೇಳ್ತಾ ಇದ್ದಾರೆ. ಗವರ್ಮೆಂಟ್ ಈಸ್ ದಿ ಆಥರ್ ಆಫ್ ದೀಸ್ ರೂಲ್ಸ್, ಮೇ ಬಿ ಅಂಡರ್ 1978 ಆಕ್ಟ್ ಆರ್ ಅಂಡರ್ 309 ಲಕ್ಷ್ಮೀನಾರಾಯಣ 309 78 1978 ಆಕ್ಟ್ ಪೆರಾಪ್ಸ್ KCSR ಸಂಬಂಧಪಡುವಂಥದ್ದು ಈಗ 78 ಆಕ್ಟ್. Are you not going to respond to the Lokayukta also? When was it sent, Mr. Arbatti? You that
11th June 2020.
11/6/2020. We are shortly in June 2025. What has happened?
We have written letters to the government to the.
When did you send the letter? Your letter is dated 11
June 2020.
11/6/2020. ಒಂದು ಕಾಪಿ ಕೊಡಿ, ಏನಂತ ಇದೆ ನೋಡಿ, ಏನ್ ಬರ್ದಿರಿ ನೀವು? ಹೋದ್ರಿ, ಏನ್ ಬರ್ದಿರಿ?
And what we have
Operative portion.
we have sought for the proposed amendment. If a recommendation under section 12(3) of the Lokayukta Act is forwarded by the Lokayukta Uplokayukta against retired government servant, in such cases, the departmental judicial proceeding shall be deemed to have been initiated against such a delinquent official on the date when the notice was served on him from the Lokayukta institution, directing him to submit his comments to the complaint filed against him, or to exclude the period from the date of forwarding the report under section 12(3) of the Lokayukta Act till the date.
Consideration takes place. ಅವರಿಗೆ ರಿಪ್ಲೈ ಮಾಡ್ತಾ ಇಲ್ಲ ನಾನು. 11/6/20. ನೀವೇ ಅವತ್ತು ಲೆಟರ್ ಕಳಿಸಿದ್ರಿ ಲಾ ಕಮಿಷನಿಗೆ.
ನಾವು ಇವರು ಒಮ್ಮೆ ಅವರಿಗೆ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕ್ಬೇಕು, ಅದಕ್ಕೆ ಪ್ಯಾರವೈಸ್ ರಿಮಾರ್ಕ್ಸ್ ಕಳಿಸಿ ಅಂತ.
ಲಾ ಕಮಿಷನಿಗೆ you said we have sent letter to the law commission.
But I stated so.
They have sent letter.
They have,
When
they have
sent
sought
that
for
letter?
recommendation of the law commission.
When they have sent it?
In
Government in.
ಎಷ್ಟು ವರ್ಷಕ್ಕೆ ಕಳಿಸಿದ್ರು?
there, that was March, before March 2020.
How can that be?
Not based on my representation. They have also independently sought not the suggestions of the law commission. That is why I submitted not.
When they sent to law commission is a March date.
Prior to March 2020.
ಹೇಳಿದ್ರೆ ಏನದು? ನಿಮ್ ಲೆಟರ್ ಜೂನ್ ನಲ್ಲಿ ಕಳಿಸಿದ್ರು.
June.
But ನಿಮ್ ಲೆಟರ್ ಗಿಂತ ಮೊದಲೇ ಅವ್ರಿಗೆ ಹೆಂಗ್ ಲೆಟರ್?
They have independently sought. They have independently sought the indulgence, the recommendations from the law commission for the modification of Rule 214 or amendment of Rule 214. In cases of this kind.
We'll call this matter on witness day.
Next week, lordship, in the meantime, I'll secure instruction, lordship, whether they sought in opinion from the
Law commission, now you have got a good chairman of the law commission. Honorable Justice Hinchigiri Saab is there. Why can't you do all that?
next week, lordship, in the meantime,
Week after week, everything becomes weak. Barkadi. Learned panel council appearing for the Lokayukta submits that in March 2020, the government had solicited opinion of the state law commission as to intended amendment of the provisions of Rule 214 of KCSR to the extent it prescribes period of limitation with no power to condone. Alilla, with no power to condone. As the law now, as the rule now stands. First. He also tells us that even the Lokayukta, Honorable Lokayukta, by the letter dated 11/6/2020, had requested the government to bring about some textual change to the said rule, keeping in view the realities of functioning. and nature of inquiries that would otherwise take longer time. First. Since then, 5 years have lapsed. More than 5 ಆಗ್ತದೆ government letter ಇಟ್ಕೊಂಡ್ರೆ. First. Lapse. First. Learned government AGA, when confronted with all this, seeks a period of 1 week to come out with a positive response from the government and also from the law commission, if possible. Second is, if possible. First, 5 years, a period of 5 years is a very long period in the lives of men who are mortals. First, next paragraph. Very reluctantly, we grant a period of 1 week. 1 week. Though we are not impressed by the way the things are happening at the government level. First, more is not necessary to specify, and less is insufficient to leave the hard truth told. Okay. First, registry to send a copy of this order to the Chief Secretary, Government of Karnataka, before the sunset of the day by speed post. Okay. Call this matter, and the other one date kodi. Ali, to the chairman of the law commission, state law commission, to the honorable chairman, the Karnataka State Law Commission. Address on this kondo ಕಳಿಸ್ಬೇಕು. ನಿಮ್ ರಿಮೈಂಡರ್ಸ್ ಎಲ್ಲ ಇಲ್ವಾ 11/6/2020 ಆದ್ಮೇಲೆ
ಆದ್ಮೇಲೆ ಒಂದು ರಿಮೈಂಡರ್ ಇದೆ. ದೇರ್ ಆಫ್ಟರ್ ವಿ ಹ್ಯಾವ್ ಫೈಲ್ಡ್ ದಿಸ್ ರಿಟ್ ಪಿಟಿಷನ್ ಇನ್ 22.
ವಾಟ್ ಈಸ್ ಯುವರ್ ಪ್ರೇಯರ್ ದೇರ್?
But in prayer in the writ petition is, first prayer not to seek to set aside the KAT's order. Second prayer is in relation, second and third prayer in relation to Rule 214. May I read not?
Read.
Issue an order direction declaring that Rule 214(2)(b)(2) of KCSR has no application in respect of proceedings initiated either on the complaint given under Section 9(3) of the Lokaयुಕ್ತ Act by a private individual or in respect of reference made under Section 7(2)(A) of the Karnataka Lokaयुಕ್ತ Act by the state government. In the alternative, issue an order direction or any appropriate writ declaring 214(2)(b)(2) and 3 of the KCSR as ultra virus being contrary to the provisions of Lokaयुಕ್ತ Act and Article 14 of the Constitution.
Only one submission on facts, my lord. My lord, allegation is pertaining to, my lord, 1986. And entrustment is, my lord, 1990. My lord, the charge memo is issued in the year 1999. There is a delay in issuing the charge memo by 9 years in the Lokaयुಕ್ತ. In the facts and circumstances of the case, my lord.
These are related to mining operation is some.
ಇದಲ್ಲ. Mining, Lord, allegation
Just
is,
give an
my lord,
example.
I have failed to collect the rent. I was working as commissioner in Shimoga municipality at that time. I have failed to collect the rent is the allegation. My lord, 9 years there is delay in issuing the charge memo in Lokaಯುಕ್ತ.
Why did you not collect the rent, government money? ಅದನ್ನ ಟೈಮ್ ಬಾರ್ಡ್ ಮಾಡಿ ಬಿಟ್ಬಿಟ್ರೆ ಮತ್ತೆ ರಿಕವರಿ ಯಾರಿಂದ ಮಾಡ್ಬೇಕು ಗವರ್ಮೆಂಟ್?
My lord, 214(2)(b) in the facts of this case may not be examined is my submission.
ಹಂಗ ಬರಲ್ಲ. ನೋಡೋಣ, ಅದೆಲ್ಲ ದುಡ್ಡು ಹಿಂಗ ಹೋಗ್ಬಿಟ್ರೆ ಗವರ್ಮೆಂಟ್ ಮುಂದೆ ಹೆಂಗೆ? ಈಗ ಎಲ್ಲದಕ್ಕೆ ಬೇಕಾಗತ್ತಲ್ಲ ನಿಮ್ಗೆ, ಫ್ರೀ ಬಿಗಿ ಕೊಡ್ಲಿಕ್ಕೆಲ್ಲ ದುಡ್ಡು ಎಲ್ಲಿಂದ ತರ್ತೀರಿ ಗವರ್ಮೆಂಟ್? ವೇರ್ ಫ್ರಮ್ ಯು ಬ್ರಿಂಗ್ ದ ಮನಿ? ಎಲ್ಲ ಹಂಗೆ ಹೋಗ್ಬಿಟ್ರೆ 214 ಜೋತ್ ಬಿತ್ಕೊಂಡು ಹಂಗ ಹೊಂಟ್ಬಿಟ್ವಿ ಅಂದ್ರೆ, ಅದರ್ವೈಸ್ ವಿಲ್ ಇಂಟರ್ಪ್ರಿಟ್ 214 in a way they want. Let us see what we should do. ಆ ರೀತಿ ಅಬ್ಸಲ್ಯೂಟ್ ಎಂಬ ನಾವು ಯು ಡೋಂಟ್ ಅಗ್ರಿ ವಿತ್ ದಟ್. ಎಸ್,
seek short pass. Top subjections are complete this matter, my lord. And your lordship on 2/12/2024 passes the order to ascertain who was officer responsible for alleged incident, because at the relevant point of time petitioner was not there. On 2/12/2024, your lordship may kindly.
As on that date, who was there?
My lord, we have sought for instructions, my lord. They have said that
When
we'll
did
furnish
when did
Paravai's
you-
reply for.
When did you seek for information?
My lord,
How did you
in
seek?
December itself, communication has been
You have
sent.
sent that.
Please.
No, we are not entitled to look
My lord,
into
I'm told
communication.
that, my lord, they have to communicate with the KADB, where he was deputed when the misconduct took place, my lord. He is accused of reacquiring land which was already vested in the government without verifying the records, my lord.
And paid
On
the
the last,
money also. Paid the money also.
paid the money also, caused a loss of around 1.8 crores loss to the government.
Government acquiring government's land.
Government.
It's a serious matter.
At that point, the petitioner was not there.
He
But
says
some
I
time
was
may
not
be
there
given.
at all.
Because the
When are you, 2:30?
reply file,
Case.
reply fine ಮಾಡ್ತೀವಿ ಅಂತ ಹೇಳಿದ್ವಿ. They have challenged the articles of charges.
Very well. He is saying, I was not there. ಅವ್ರು ಇದ್ರು ಇಲ್ಲೋ ಅಂತ ಅನ್ಲಿಕ್ಕೆ
Lord,
ಜನರದ್ದು ಎವಿಡೆನ್ಸ್.
No, I've already consulted the concerned
Records.
officer. Well, the officer was not, today he's unwell, my lord, therefore he's not in.
You
office
sent
today.
it when?
My lord,
When did you send that intimation?
my lord, this was sent in December itself, my lord.
From there, he is not well?
My lord, today he was, my
Today
lord, my
already.
predecessor
But
was
why-
handling this matter, my lord, previously when he sent the letter. Today I contacted him.
At 2:30, ask him to bring the records.
Probably.
God, pass over. Will not leave that way. Otherwise, ನಿಮ್ಗೆ ನಾಳೆ ನೀವು ಏನು ಮಾಡ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ ತಿಳ್ಕೊಳ್ಳಿ. ಕೋರ್ಟಿಗೆ ನೀವು ಎಂಪವರ್ ಮಾಡಿದ್ರೆ ಮಾತ್ರ ಏನಾರ ಮಾಡ್ಕೊಳ್ಳಿಕ್ ಆಗ್ತದೆ.
ಇಲ್ಲ, I've cautioned them that the court will view it seriously if timely
ಯಾರು?
information is not given.
Who is that officer?
My lord, his name is Banavar, my lord. He is
Banavar.
the legal, he is on leave, I am told, my lord. I have spoken to him.
So spoken. At
He said
2:30
that he is,
ಈಗ ಆರ್ಡರ್ ಮಾಡಬೇಕು 2:30 ತರಿಸ್ತಿರೋ ಆಪ್ಷನ್ ನಿಮ್ಗೆ.
ನಾಳೆ ನಾಳೆ
ಅರೆಸ್ಟ್ ಅಂಡ್ ಡಿಟೆನ್ಷನ್.
ಅಲ್ಲ, ಇವತ್ತು ಲೀವ್ ಅಲ್ಲಿ ಇರೋದ್ರಿಂದ ನಾಳೆಗೆ ಹಾಕೊಂಡ್ರೆ ದಯವಿಟ್ಟು
ಕಾಲ್ ದಿಸ್
ನಾನು ನಾಳೆ ತರಸ್
ಡೇ ಆಫ್ಟರ್ ವೆಡ್ನೆಸ್ಡೇ.
ಗ್ರೇಟ್ಫುಲ್.
ಯಾಕೆ ಕೊಡ್ತಾ ಇಲ್ಲ ಪೇಪರ್ಸ್ ಅಂದ್ರೆ we assume that things happen hand in glove with each other.
I have cautioned
ಎಲ್ಲ
them.
ಗೊತ್ತಿದೆ ಮೊದಲೇ ಜುಡಿಷಿಯರಿ ಬಗ್ಗೆ ಹೆಂಗೆಲ್ಲ ಆಗ್ತಾ ಇದೆ ಹೊರಗಡೆ ಅನ್ಕೊಂಡು. ಇಂಥ ಹೊತ್ತಿನಲ್ಲಿ ನಾವು ಸುಮ್ಮನೆ ಕುತ್ಕೊಂಡ್ರೆ ಜನ ಅಬಾಲಿಷ್ ಕೋರ್ಟ್ಸ್ ಅಂತ ಹೊಂಟೆ ಬಿಡ್ತಾರೆ. ಮತ್ತೆ ನೆಕ್ಸ್ಟ್ ಡೇ ವಿ ಆರ್ ಟೆಲಿಂಗ್ ಯು ದ ಟ್ರೂತ್. ಕೋರ್ಟ್ ಅನ್ನು ಎಂಪವರ್ ಮಾಡಿದ್ರೆ ಸಮಥಿಂಗ್ ವಿಲ್ ಹ್ಯಾಪನ್. ಕೋರ್ಟ್ ಅನ್ನು ಎಂಪವರ್ ಮಾಡಬೇಕು, ಅಕೌಂಟಬಿಲಿಟಿನೂ ಮಾಡಿಸ್ಬೇಕು, ಎರಡೂ ಬೇಕಾಗ್ತದೆ ನಮಗೆ. ಬಟ್ ನಮ್ಮನ್ನು ಎಂಪವರ್ ಮಾಡಿದ್ರೆ ನಮ್ಮನ್ನು ಅಕೌಂಟೇಬಲ್ ಇಡಿ. We have not landed from heaven. We are accountable to the system. ಏನಿಲ್ಲ, ಕೆಲಸನೂ ಮಾಡಂಗಿಲ್ಲ, ಎಂಥದ್ದು ಇಲ್ಲ. ನಾಡ್ದು ವೆಡ್ನೆಸ್ಡೇ
ಆಗ್ಬೋದು.
ವೆಡ್ನೆಸ್ಡೇ. The Lieutenant Government Advocate would inform the concerned officer the anguish of this court, which is available on in online record. Okay. Now, ಹೇಳಿ. Next.
I appear for the Mr. Land grabbing court proceedings have been challenged.
Yes.
The allegation is that the petitioner owns about 1 acre of converted land.
Yes.
It is alleged that in this 1 acre of converted land, 8 guntas flood, a water channel passes through.
Yes.
This court directed that you conduct a survey and find out. Then on that, my lord, the Tahsildar passed an order against which we filed an appeal. On appeal, it is remanded back for reconsideration. At this stage, my lord, the land grabbing court, even before that proceedings could be finalized, entertains the complaint and takes cognizance of the matter. That order, my lord, remanding the matter.
What was the order that Tahsildar had made?
Tahsildar directed eviction of about 8 guntas of land.
Under which section it was appealed?
That is, my lord, under
Padi.
94.
Padi.
He passed the order under section 104 of the KLR Act.
Section 104.
Remove the encroachment.
Whether appeal is provided against order under 104?
104, my lord, against that.
I'm not very sure.
Yes.
Go to 40, kindly go to 49.
Land Revenue.
Land Revenue Act.
104 of the Land Revenue Act.
I'm not very sure that it is appealable order.
I thought since appeal order is passed, I did not look into it. Because 104, he ordered eviction, it's the original order. Since it is all original orders are appealable.
Appeal shall be from every original order passed under this act. Rules may
Under
vary.
49, any original order by the revenue officer.
Code of Civil.
And there is a direction by this honorable court also will have to decide the matter. In fact, at page
That
one,
appeal is decided now,
that appeal is decided.
And remanded.
Remanding.
and he is not passing the orders.
He has not passed the order. He
Why
can
he
pass
is
an
not
order.
passing the order? Why Tahsildar is not passing the order?
I'll verify.
When it was remanded, Mr. Arnold,
It is remanded on 12th January 2024.
well, January,
2024. Almost 1 year is over.
more than a year has happened. Who is that Tahsildar? Fresh matter. Issue emergent notice.
Tahsildar East Taluk.
Learned AGA is requested to accept notice for 124. Sri B.S. Karthikeyan is requested to accept notice for response number 5, BBMP. Call this matter day after tomorrow, so that the Tahsildar will either pass order or be personally present before this court to offer explanation as to why for more than a year, in the remanded matter, no order is passed.
There is an NBW issued, my lord, that.
ಯಾವತ್ತು issue ಮಾಡಿದ್ರು?
NBW issue ಮಾಡಿದ್ದಾರೆ ಒಂದು NBW stay ಮಾಡಿದ್ರು.
ಅಲ್ಲಿ stay of NBW till next date of hearing. Call this matter on next Monday, we will have it.
Please, ma'am.
You tell your Tahsildar. Monday, second, all right, second Tuesday. Have you given, Mr. Harnadi, whether your client has a given book?
Yes.
Formed on law by 5C.
ಕೊಟ್ಟಿದ್ದಾರೆ.
Have you given that?
I'm filing that note.
Acknowledgement ಹಾಕಿಲ್ಲ ಇವರು.
Compliance.
In fact, that
Of
5G
the
is a very good book, my lord.
It's a
Much
famous
better
book.
than even.
5Z is one of the famous writers on Islamic law.
I taught Mohammedan law for 1 year.
I was also there with you. 5Z on Mohammedan law. Mullah is also standard book
But
only.
5G narration is very good.
Correct. But many of us do not travel beyond Mullah at all. As if we take Mullah is the last word. Mullah was a Dinsha, Sir Dinsha Mullah, the great author, a Parsi author. He has written books on so many subjects. He was a member of Privy Council also, Judicial Committee of the Privy Council. All.
I appear for responding to which is, my lord, I have complied with the office objection.
Ali, call, Mr. Harnali will say the stay is till 2nd of April. Call this matter, this one, stay of NBW, first of April, first of.
Can it be on
Okay.
third, my lord?
Huh?
Third ಆಗ್ಬೋದಾ?
ಇಲ್ಲ, ಏನು ಹೇರ್ ಮಾಡಿ.
Instead of second, third.
Third, all right. Third ಅಂತ ಅನಿಸ್ತು ಹಂಗಾಗಿ.
First ಬೇಡ.
Third.
First ಬೇಡ ಅಷ್ಟೇ.
Yes.
In this case, I appear for respondent, my lord. I have complied with the office objections, filed the second set also today, my lord.
You have complied with the order.
Yes, ma'am. Office objections, my lord. The second set was not filed. That's how I filed today, my lord.
Learned counsel appearing for the respondent submits, and we agree that office objection is complied with by filing the second set, first off. Registry to just verify.
And next week, my lord, there's some urgency in the matter, my lord.
Next week we have difficulty, brother. Week after next we'll have it.
Some date may kindly be given, that
Week
because.
after next ನೋಡ್ಕೊಳ್ರಿ ಯಾವ್ದಾರ ಒಂದು ಡೇಟ್ ಸ್ಟಾರ್ಟ್ ನೇ ಹಾಕೋಬೇಕು. ಓಕೆ, ಎಂಟ್ರಿ ಮಾಡಿದೀಯಾ?
My lord,
Entry
successful.
ಮಾಡಿ.
Great.
I appear.
Awaiting service of
First
R4
matter.
to R8 ಯಾರು?
First matter.
ಹಾ.
This is a case where PSI, my lord, recruitment, without a final select list published in the official gazette, the list has been operated. Earlier, we approached the KAT, my lord. So far as the model key answers were belatedly, my lord, wrong. That was given to the authorities. And the member secretary directed the KEA to examine. Without examining that, my lords, now the list is operated. That's the prayer. So far as the prayer 2 is concerned. So far as the prayer 1 is concerned, my lord, My learned friend, last time he argued, difference of 15, that is question.
Yeah, that lady argued very well at the other day. But we raised two issues. That those to whom the orders have been issued are not parties eo nomine before us.
But I have implemented 5 papers in a representative capacity because question of law is same.
Oh, it cannot be a representative capacity.
But that is permitted.
Not permitted.
Supreme Court judgments.
Good.
Sorry, I did not bring it. 81 Supreme Court, that is being followed in consistently in more than 10 judgments.
That 81 Supreme Court related to seniority.
No.
Ah.
If a person, if a question of law, my lord, is involved in applications, then, or a rule is challenged. If a rule is challenged, then implement is not required.
No,
But
only
if
rule
it
is
is a-
challenged, we understand. Suppose rule is challenged. Under that rule, many orders have been issued to XYZ. You mean to say XYZ need not be made parties?
No, if there is already a selection has taken place,
Yes.
if a question of law is raised in an application, if it is of general importance, it is applicable to all. With the permission of the court, people can be, selectees can be implemented in a representative capacity. That's the purpose.
Did
I'm
you
sorry,
seek for
my lord.
any sanction, permission of the court to treat them as representative of
Yes.
rest of the people?
Yes, representative capacity.
Where have you stated in your petition? Kindly read
I have stated.
this. But which line? Mr. Ruben,
Please.
whether the final selection list was prepared and published?
No, my lords, it is not published.
It's not.
Only the provisional select list was published. In terms of the rules, my lords, we have to publish a revised provisional select list after the medical test is over. Thereafter, my lords, the document verification and the eligibility will be, the document verification, my lords, and suitability is considered. And thereafter, the final select list is issued. But, my lords, it is an admitted fact, my lords, that the state, without issuing the final select list, my lords, has gone about issuing appointment orders to 485 people. Under the circumstances, my lords, this was a point which is not, my lords, that has been raised in the petitions. The main,
We are
please, I get
we
it.
are asking you.
No, my lords, therefore, my lords, I'm saying this in the last state of hearing, my lords, my learned friend, one of the petitioners, my lords, brought this up. And my lords, now we will file a statement, my lords, under what circumstances without the final select list, my lords, the appointment orders was issued. The rules, can I just pass on the relevant rules? My lords?
Do they provide for that?
No, my lords.
Lord, it shall be published in the official gazette.
I'll just explain under what circumstances, my lords, we went about doing that.
Two things you have to explain.
Please, my lords.
One, whether rule is mandatory or not.
Please.
Number two, whether the rule is selectively directory. In the sense, your explanation can be fit into that selective
Please, my lords.
circumstance.
If it is the first case, my explanation is irrelevant.
You are right.
Please, my lords.
You are right.
Please.
We
Not
should
sir.
really appreciate him. He is one of the so fair advocates. He will simply say what is what and he just really, we
Grateful.
appreciate that.
Grateful.
Yes, shows, no?
My lords, if my lords may see,
Appreciation by your lordships is.
Really, he does that way.
You know, a
Very
big-
fair he is. And he's not mindful of consequences.
It is a crown on his head.
It's really, he's like that. That person is like that. Yes,
page number 6, my lords.
6.
6, my lords. F, appointment, my lords.
Select.
The selection authority, after medical examination by the medical board, prepare second provisional select list on the basis of the result of the medical examination and send such list to the appointing authority to satisfy itself on such inquiry as may be considered necessary that the candidates are otherwise found suitable in all respects for appointment. On receipt of the inquiry report from the appointing authority, the selection authority shall prepare a final select list of such candidates. Such final select list shall be published in the official gazette. The candidates whose names are included in the final select list may be appointed by the appointing authority against the vacancies in the order in which their names appear in the final select list.
So there is a whole lot of things.
Lot of things. My lords, in this, in the scheme of recruitment, you have a provisional select list. Afterwards, my lords, we have what is called as a medical examination, and the standards of the medical examination is also provided, my lords, in the previous page itself, page number 5. Bottom of the page, medical examination.
Medical examination.
Please, standards of medical exam.
After the publication of the provisional select,
Correct.
publication means in the final, in the, where publication?
We have published, that is published.
No, publication means what?
Lords, publication, my lords, where we know.
Second provisional list, then final list.
Lords, provisional,
That's
first
no, what
provisional
is-
select list is published, no dispute.
We want,
Please.
what is meant by publication?
Lords, we notified it to the public at large.
Is it, how you do that?
Lords, in the website and in the notice board. Usually earlier we used to do it in the notice, now we do it in the website.
So what all medical examination shall consist of?
Consist of is provided here.
Then you will prepare the second provisional list.
Please, my lord.
That you will send to the government. Government will look into whether they are suitable or not.
Please, my lords.
Then they send back the inquiry report to you.
No, my lords, it is the appointing authority, my lords, is zone wise here.
But there is one appointing authority. The
Well,
selection authority shall prepare a final select list of such. After the government makes inquiry
Please, my lords.
about suitability
Please, my lords.
of the candidates.
Please,
Along with that report, you will prepare the final select list.
final select list.
Then it goes for
Appointment.
appointment.
My lords, here the appoint, this is a group C post, my lords. Appointing authorities, my lords, are the concerned commissioners and the range,
Not government.
not the government, appointing authorities. So therefore, my lords, the second provisional select list ought to have been sent to the appointing authority, and they have to do this process with regard to the inquiry.
Why this,
No,
who
lords,
are
they-
commissioner of?
My lords, we have, my lords, in this case, there are 10 appointing authorities, my lords. Commissioner of police of different ranges,
Ranges.
including Bangalore, Belgavi, and then Deputy Inspector General of Police, my lords, of other ranges, my lords. They are the appointing authorities. My lords,
Wherever there is commissionerate, they will be commissioner.
please, my lords,
Wherever the non-commissionerate area, there will be DIG.
DIGs.
Why they issued appointment
Please,
orders?
my lords, we have, in this case, my lords, we have the medical examination was completed. After the medical examination is completed, the revised provisional select list is the persons who are not, who will not be, who fail the medical examination, that post again will be, my lords, revised and other people will be made part of that. So that is the concept of a revised select list. Then, my lords, finally, after the inquiry with regard to suitability is held, with police verification otherwise, this is with regard to PSI post, my lords, of civil inspector. So afterwards, the final select list is issued. Now, in this case,
Civil or criminal law?
my lords,
I am asking not about the things that have happened. We are asking the post.
post is police sub-inspector civil.
Civil.
Now, my lords, we have completed the medical examination and have completed the inquiry only in respect of those candidates who have cleared the medical as well as the inquiry with regard to suitability. Appointment orders were issued. This was only, my lords, in view of this fact, my lords, 371J matter is going on with regard to that. Here, my lords, though this litigation is not part of that, this was also done in terms of the circulars, my lords, of 2000. The recruitment was commenced on the earlier circular, and my lords, the final select list was prepared in terms of the latest circular. Therefore, my lords, in terms of the interim orders there, the opinion had come to the AG's office, my lords. We had said, whatever you don't select some candidates who will be displaced from the earlier list on account of that. So therefore, my lords, 40 posts were kept vacant. Remaining, my lords, we published a provisional select list. And on the basis of that, my lords, we have completed this process. But to issue a revised provisional list and a final select list, my lords, it takes some time because we can do it only in one shot. It cannot be a
Why without all this procedure and forego madi?
Please, my lords.
Appointment orders, these commissioners, why did they issue?
Lords, they sought the permission of the government. Government permitted them, lords, subject to the condition you finish the medical inquiry. I will file that statement, lords. Government permitted them. Now, my lords, there is shortage of police sub-inspectors, and I have the statistics on record. I will place it along with the statement. My only request is we cannot take contract appointments, my lords, or outsource, my lords, with respect.
That's all right. But ಇದನ್ನ ಸರಿಯಾಗಿ ಮಾಡಿಬಿಟ್ರೆ ಮುಗಿದು ಹೋಗ್ಬಿಡ್ತಿತ್ತು.
ಇಲ್ಲ ಇದ್ರಲ್ಲಿ ಏನಾಗುತ್ತೆ, now persons have made failed medical, my lords, have to go down again. Then 371J litigation is pending, the final select. Then 3 persons, my lord, this honorable court directed not to issue the appointment to keep those posts vacant. I've kept those posts vacant. My lords, I will explain, my lords, in a statement itself filed by the concerned officer, my lords.
When are you filing this statement?
My lords, my lords, 1 week's time may be given to me.
Take the mic.
Mike.
Take the mic.
Hello, wait, let Mr. Lakshmi Narayana is leading. Let the senior advocate is on legs. Wait, on his feet. Yes, Mr. Lakshmi Narayana.
My lord, the rule contemplates after the second.
No, we have understood the entire gamut of.
No, it should be published in the official gazette. I think other day your lordships are dealing with the seniority. What shall be the seniority? A person who reported after 15 days in the order of ranking in the seniority. Now, without a publication of a seniority in the official gazette, there is no select list at all. Not, it is contrary to the rule. The second submission, my lord, before your lordship should be that.
Before that, before we forget, you said that you have taken a permission of the court to treat them as a.
Not permission. I sought for permission. Para 20, my lord.
You have said
Para
that.
20. Yes, I sought. Full paragraph I sought. There are totally 545 candidates. 5 candidates may be implicated as a parties, since it is a question of law involved, and permission may be sought for.
ಎಷ್ಟು
Full
ದಿವಸದಿಂದ
paragraph.
ಕೆಲಸ ಮಾಡ್ತಾ ಇದ್ದಾರೆ?
Milords,
Training ಅಲ್ಲಿ ಇದ್ದಾರೆ.
they are in training, Milords.
They are in training.
Training. Milords, sir, appointment orders, Milords, were issued on different dates. Milords, it was January 25, Milords, is most of the, in the month of January, Milords, 2025. They are in training, Milords.
Appointment orders are issued after they filed application in the KAT or before?
No, Milords, after. Milords, we were supposed to finalize the provisional select list.
No, when you finalized, when
After the disposal, Milords.
after the, not disposal,
Please,
they had approached the KAT.
please.
Yes, my lord, 1 year.
As on
back.
that date, appointment orders were issued.
Not
No,
issued.
no, not issued. During the pendency, my lords, of the proceedings before, my lords, where Ravi Shankar sir is appearing, my lords had directed us, where then the provisional select list was not yet issued, directed us to keep the 3 posts, not to fill up 3 posts.
Because
there are
one
three-
thing, legality,
Please, legality, I'll come to that. My lords, the main issue, my lords, is,
ಈಗ you,
ನಾನು just one statement ಹಾಕ್ತೀನಿ, sir.
ಅವ್ರು ಯಾರಿಗೂ ಇದನ್ನ ಪೋಸ್ಟಿಂಗ್ ಕೊಡಬೇಡಿ.
Please.
Till next date of it. Let them undergo training.
Undergo training, grateful.
Because their matters were pending
I get
before
it,
the KAT.
I get it.
So whatever you do, it will be list pendants.
Please,
Therefore, they may say, no, we need not.
we need not
treat
make
them at all.
parties. Correct.
Because main matter itself is.
Please, please.
So far as my matters are concerned, it is after I had approached this honorable court that they have issued the appointment orders.
So that's also list pendants.
That's also.
Same
respect.
thing with
Milords,
us.
Do you want to add anything? Yours also list pendants. Understood. One sentence. Submission means it's like chancellor's put from 13 inches, 9 inches to 13 inches.
Yes,
All day you
Milord.
may argue.
My lords, what I learned is that there were logistical difficulties and therefore they placed the cart before the horse, and it is in itself prima facie illegality.
That we have
In the
understood.
government,
Let him come with the objection statement.
on
Then-
that point, I want to say, my lords, there is something called the Henry VIII clause, which we learnt in service jurisprudence.
Notwithstanding.
Notwithstanding, or the power to remove difficulties is, for example, once the government enacts certain rules, they are bound by their own rules. They cannot overcome that rules
all.
by
Yeah.
a notification.
Yeah,
So
understood.
no matter what order or permission they take from the government, that will not be tantamount to delegated legislation.
That-
So this is an exercise in futility.
Understood. Keep this for hearing. It's a good point which you have raised. What?
And
Next
one
day.
more submission.
Next date ever to.
Please, Milords, next Monday.
Learned senior advocates, Mr. Lakshmi Narayana and Ravi Shankar, and the learned advocate Srimati so and so contend that the rules provide for the preparation of selection list with the SOP like thing. And till the final selection list is prepared and published, comma, no appointments could have been done. First, learned AG, senior advocate appearing for the KPSC,
No, Milords, I'm appearing for the state.
Torment,
No, this is a recruitment conducted by KEM, Milords,
Okay.
not by KPAS.
learned senior additional advocate
Advocate
general, Mr. Ruben Jacob, appearing for the state, submits that he would be filing, his client would be filing the statement of objections, explaining the circumstances that resulted into issuance of appointment orders, and therefore some time be given. First, we should also appreciate the fairness of the net senior advocate in bringing to our notice the true legal position, comma, which we need not discuss at this stage. First, he also tells us that all the appointees are undergoing training at the police training school.
Please.
Delhi. PTC na?
Mysore and
At,
Kalburgi.
At Mysore and Kalburgi, PTCs at Mysore and Kalburgi.
Lords,
In
KPM
Karnataka Police Academy. At Karnataka Police Academy at Mysore and Kalburgi.
and PTC at Kalburgi.
Police Academy at Mysore.
Mysore.
PTC at Kalburgi. Kalburgi. First up. Let them undergo training. First up. However, they shall not be posted to work in any police stations without the leave of this court.
Please.
This court. First up. The respondent state shall give wide publicity
Please, I'll do.
to this order so that who are likely to be affected in the event the petitions succeed, can come before court seeking impediment. Seeking impediment. Okay. Give full publicity
We'll do
to
that.
this one.
We'll do it.
Send it to first up. A copy of this order shall be sent to each of the appointees by speed post.
We'll do it.
So that they can take a stand in the matter. Although prima facie, they may not be proper or necessary, much less necessary parties, since the applications before the KAT were pending even before issuance of appointment orders. Okay.
Next Monday seems to be a holiday. Tuesday.
Unella ಸ್ವಲ್ಪ important ಮಾಡಿ
I'll,
ಮುಗಿಸ್ಕೊಡಿ. Where people will get restoration of their faith in the judicial process.
Grateful.
Where judicial process is strained now.
Strain now.
And it is
2008, my lord, the apex court passed a similar order about the impediment.
The English translation of my lord,
dispensed
with my lord, the
ಏನಿದು ಮಿಸ್ಟರ್
Lokayukta filed a petition, my lord, challenging the order of the KAT, my lord, wherein KAT has, my lord, set aside the penalty order passed by the
ಕವಡ ಬೈ ಧಾರವಾಡ ಬೆಂಚ್
ಇಲ್ಲ. Inquiry ಎಲ್ಲ ಆಗಿದೆ. My lord, on 2 counts, my lord, KAT set aside the order. My lord, on the ground that, my lord, the complaint was not examined before the inquiry officer. And my lord, even DGOs are also placed ex parte. But KAT would have, my lord, ought to have remanded the matter to the, my lord, inquiry authority. Rather than that, my lord, they have set aside the penalty order itself. And one more issue was taken, my lord, the authority which was passed the penalty order, my lord, BBMP has passed the penalty order. They are originally from state government, my lord, the PW department. Deputation. But that issue also pending, my lord, writ appeal in division bench, my lord, 634/2021.
Issue emergent notice. How many states of Karnataka are there in our state? Kindly come to your cast title.
Sorry, my lord.
ಮತ್ತೆ ಮೊದಲೇ ಡಿವಿಸಿವ್ ಟೆಂಡೆನ್ಸೀಸ್ ಇದೆ. ಹಂಗೆಲ್ಲ ಎರಡು ಸ್ಟೇಟ್ ಮಾಡಿಬಿಟ್ರೆ that may trigger
Mistake.
appears to be very innocuous. It's not like that.
Please.
Yes.
I'll permit it to correct.
Correct, Madi.
Please.
Petitioner Upalokayukta is permitted to correct the cost title, correct the description of second respondent in the cost title. First, issue emergent notice. Learned AGA requested to accept notice for response 1 and 2.
3 and 4, my lord.
Emergent notice to 3 and 4. Stay as sought for. Interim order as sought for.
Please. Apply.
ಸರಿ ಮಾಡ್ಕೊಳ್ಳಿ.
Petitioner had challenged the premature transfer order issued on 25th, my lord.
25 of
November. Lord, 27 November, my lord, she approached the tribunal.
await notice is
Lord, the reason I have moved is, my lord, your lordship have ordered notice, my lord. But the petitioner has reported before the head office before the pendency of the application. The tribunal proceeded on a footing that the orders should be implemented and therefore dismissed the application.
How? That's not the correct position. In Varadarao, Apex Court considered this. There is another matter. SV Venkatesha Murthy versus Karnataka State Forest Industries Corporation. The division bench said, where there is a transfer, the employee should first report for duty, then lay a challenge to that. Otherwise, disciplinary inquiry in hold ಮಾಡಿದ. What kind of reasoning? Suppose he decree amount ಕೊಟ್ಬಿಡ್ತಾನೆ. Decree amount ಕೊಟ್ಬಿಟ್ಟಾನೆ, ಹಂಗಾಗಿ appeal ಇಲ್ಲ ಅಂತ ಹೇಳಕ್ ಬರ್ತದ.
I won't dispute the position of law.
Now, what has happened is, my lord, during the pendency of this writ petition also, my lord, she has been transferred to Udupi, my lord.
Now again transfer to Udupi.
Udupi, my lord.
Posting has been given after the writ petition came to be filed, my lord. It has been given on
Lord, writ petition was filed in now January 2020.
ನಿಮ್ಗೆ ಎಲ್ಲಿ ಬೇಕಿತ್ತು? ನೀವು ಅಲ್ಲೇ
But I have to continue in present place because of premature
place?
transfer at Bangalore.
Bangalore.
Yes, sir, it is
ಎಷ್ಟು
a premature
ವರ್ಷ
transfer.
All right. ಯಾವಾಗ ಜಾಯ್ನ್ ಆಗಿದ್ದು ನೀವು? ಡ್ಯೂಟಿ ಇದಕ್ಕೆ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಯಾವಾಗ ಆಗಿದ್ದು?
3622.
Your appointment?
I was appointed as a.
When were you appointed? How many terms you were in Bangalore?
My lord, between, your lordship may kindly come to page.
ನಾವೀಗ ಅವೆಲ್ಲ ಬೇಡ್ರಿ. ಯಾವಾಗ
Years ಅಂತ
date
finding
ಹೇಳ್ರಿ.
is. The finding is 14 years. She has
My lord, that is not correct, my lord.
finding
Your
at
lordship
page 20, my lord. 14 years.
14 years.
My lord, your lordship may kindly come to page.
You want to appear? All right. Shri Raghupati MJ, learned counsel, appears for response number 3 and 4. 4 alone. 4. 3 ಯಾರಿದ್ದಾರೆ? Only R 4 ಮಾತ್ರ. All right.
1 to 3.
How many years you have put in service?
My lord, I have.
Answer our question.
Yes, my lord, from 2008 till 2020, I was in Bangalore, my lord.
8 to 20.
Yes, my lord.
12 years you were in Bangalore.
On promotion, I was transferred to Udupi, my lord, on 28 2020.
Let us see.
My lord,
Call this
thereafter, my lord,
matter.
I was posted to present place
Okay.
on 3622. My lord, after rendering 2 years, my lord, I was entitled to continue.
We'll see, we'll examine. 12 ವರ್ಷ ನೀವು ಒಬ್ಬರೇ ಬೆಂಗಳೂರಲ್ಲಿ ಇದ್ರೆ ಅವ್ರೇನ್ ಕೆಂಪೇಗೌಡರ ಮೊಮ್ಮಕ್ಕಳಲ್ಲ, ಎಲ್ಲರೂ ನಾವು ಹೊರಗೆ ಹೋಗ್ಲೇಬೇಕು ಅಲ್ವಾ? ಹಂಗನ್ನಕ್ಕಾಗಲ್ಲ.
On promotion,
No,
I
no,
was transferred.
We understand. We understand. One cannot seek that always I want to be in the Eden garden. Even Adam and Eve could not stay there. See, by biblical history. Yes, call this matter after 3 weeks. Okay. Objection I can hakbeku. Yes, next. We have noted that the petitioner had served in Bangalore admittedly for a period of 12 years already. Full stop. However, that may not be very, very relevant factor in deciding this case. Okay. Yes, next.
Petitioner.
Yes, Suraja.
Petitioner was challenging the posting order dated 6/3/2024 before the tribunal, my lord. The same was communicated on 31/5/2024, my lord. Initially, the tribunal was granted the interim order. By virtue of interim order, my lord, the petition was continuing in the present place. The brief facts, my lord, on 4/8/2023, my lord. Article of charges was issued against the petitioner, my lord.
ಏನಂತ charge?
Charges, my lord, page number 45, my lord. Annexure A3, my lord.
ಏನ್ charge ಏನು?
Charge, my lord, some dereliction of duty, my lord. Higher officer ಮಾಡಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು. The regular inquiry was conducted, my lord. Charges was not proved, my lord.
Not proved.
Not proved, my lord. As per the annexure A4, my lord, page number.
Authority did not agree with that report.
Yes, my lord. Without disagreement notice, my lord, the penalty was.
Proposal notice is not given. Proposal notice ಕೊಡಕ್ಕೆ you are entitled to disagree with the finding, provided you put it to the employee. Admit. Learned AG is requested to accept notice for respondents. First, interim order as it existed before the KAT shall continue. Please. If you want to disagree, notice. Let's go and say. Which is that judgment, brother, which said proposal notice has to be given before reversing the findings?
7/2A, my lord, CCA rules.
That's all right. Which is that judgment of the apex court? Apex court held it that way, na?
Mohammed.
Nodama. Kunj Bihari Mishra, above all interim relief is granted, keeping in view the apex court decision in Kunj Bihari Mishra versus state of North Konkodi. Just give it that one. Very old judgment actually. Read with
11/2A and 2, my lord.
11/2A of KCA CCA rules.
Yes.
Okay. Next.
This is also identical, my lord. The
Yes.
petitioner had approached the tribunal challenging the premature transfer, my lord, on 1/8/2024.
Ah.
Since there was no interim order, my lord, with a writer, my lord,
In which place he was?
my lord, he was in Raichur, my lord.
Raichur.
Yes, my lord.
How long he has been in Raichur?
My lord, from 2014 to 2021, he was in Raichur, my lord. My lord, thereafter, on promotion, he came to Koppal, my lord, in 2021. My lord, he was prematurely transferred from Koppal. My lord, again posted to Raichur only. My lord, that was challenged before the tribunal on 1/8/2024.
You want to be in Koppal?
Yes, my lord, I have to continue in Koppal because it is premature transfer.
What
And now the tribunal says that since the order, I have gone and reported before the Raichur, my lord, question of the interfering with the impugned order doesn't arise.
Why can't you advise the tribunal? So many cases are coming before us. Let them read that Varadha Rao versus state of Karnataka. 95 Supreme Court. So there's a very beautiful judgment. I think yes, Venkatramaya decided. ILR 85/86 Karnataka. Very beautiful judgment. Just look into that. Merkali. Issue emergent notice. Who is occupying your post?
My lord, the fourth respondent, my lord, by virtue of the order passed by the tribunal, my lord, is continuing in Koppal, my lord.
Send the question. Let the petitioner report for duty there. Tribunal is absolutely unjustified. It has not seen that judgment at all. SV Venkatesha Murthy versus Karnataka State Forest Industries Corporation. Justice Mohan Kumar and another. Entry order ಏನಂತ ಕೇಳಿರಿ?
Not stay of
Bengaluru idre we would have understood. Therefore, we did not grant.
Stay the impugned order of transfer, my lord, and to continue the petitioner at Koppal, my lord.
Impugned order of interim order as sought for. Issue interim order as sought for. First, the respondents, AGA is requested to accept notice. They already have entered a plea.
1, 2, 3, my lord. 4 notice has to be added.
AGA to accept is requested to accept notice for response number 1, 2, and 3. First, emergent notice to respondent number 4. First, the above order shall be implemented immediately, failing which the official respondents, the respondents shall not be, maybe, shall not be heard in the matter. Will not hear you at all. And the pleadings in the petition may be taken with their face value. Okay.
I appear for the
Yes, Mr. Sridhar.
petitioner, my lord.
Ah.
The petitioner is a professor and head of the department in Nursing College, Bangalore Nursing College, my lord. Originally, the health department was one. There was no medical education department. The health department was having a wing of medical education also.
It was part of health department.
Part of health department. Later, medical education came.
Yes.
And persons who are working in the medical education department wing, who are having qualification of teaching, they have been permitted to absorb in the respective cadre, my lord. There was similar government orders have been passed. This Honorable Court also in the division bench also passed an order, framed the rules for absorption. And I am working here in the medical nursing college for 12 years.
After bifurcation or before?
After bifurcation. I am entitled for absorption. That issue is I am agitating separately. Now in the present case, what happened, my lord? An inquiry was started against principal. Kindly see annexure A9, my lord. Page number 63, my lord.
63.
63. 63.
Your client is assistant, what is the designation?
Professor and head of the Department of Nursing Education.
Okay.
My lord, in this college, there were 21 vacancies. Only 5 are holding from health department. We are entitled to continue. Now what they are doing? No, you go back to health department.
You are from health department.
Health department with the medical wing. I am working since last 12 years.
That's
and
right.
I am teaching. I am a MSc qualified PhD. I am teaching students, PhD students. I turned out hundreds of students to
That's all
become
right. But you are appointed as what?
appointed as a lecturer in this nursing college.
Nursing college. Where is your appointment order?
That is produced, my lord, annexure A2.
Page number?
Page number 45.
45.
43, 44, 45. ಉಲ್ಲೇಖ ಸರ್ಕಾರದ GC ಮಮತಾ ಶುಶ್ರೂಷೆಗೆ ಅನ್ಯಪರ ಸೇವೆಯಲ್ಲಿರುವ ಇವರನ್ನು ಸರ್ಕಾರಿ ಶುಶ್ರೂಷಾ ಮಹಾವಿದ್ಯಾಲಯ ಬೆಂಗಳೂರಲ್ಲಿ ಖಾಲಿ ಇರುವ ಕ್ಲಿನಿಕಲ್ ಇನ್ಸ್ಟ್ರಕ್ಟರ್ ಹುದ್ದೆ ಎದುರುಗಡೆ ನಿಯೋಜಿಸಲು ಸರ್ಕಾರವು ಅನುಮತಿ ನೀಡುವುದರಿಂದ ಸದರಿಯವರು ಈ ಕೂಡಲೇ ಜಾರಿ
Thereafter you have been promoted.
ಪ್ರಮೋಟೆಡ್. ಇಲ್ಲಿ ನಾನು ವರ್ಕ್ ಮಾಡಿ 12 ವರ್ಷ ಆಯಿತು. ನಾನು ಹೆಡ್ ಆಫ್ ದ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಆಗಿದ್ದೀನಿ. ಈಗ ನೀನು ವಾಪಸ್ ಹೆಲ್ತ್ ಡಿಪಾರ್ಟ್ಮೆಂಟಿಗೆ ಹೋಗು ಅಂತಾರೆ. ಈ ಇಂಪ್ಯೂಂಡ್ ಆರ್ಡರ್ ಮಾಡ್ಲಿಕ್ಕೆ ಕಾರಣ ಏನಂದ್ರೆ ಪೇಜ್ ನಂಬರ್ 63 ನೋಡಿ ಸ್ವಾಮಿ. ಪೇಜ್ ನಂಬರ್ 63. 63. ವಿಷಯ
ನಿರ್ದೇಶಕರು
ಈ ಸಂಸ್ಥೆಗೆ ಸಂಬಂಧಿಸಿದ ಬೆಂಗಳೂರು ವೈದ್ಯಕೀಯ ಮಹಾವಿದ್ಯಾಲಯ ಸಂಶೋಧನಾ ಸಂಸ್ಥೆಯ ಅಧೀನದ ಸರ್ಕಾರಿ ಶುಶ್ರೂಷಾ ಮಹಾವಿದ್ಯಾಲಯದಲ್ಲಿ ಪ್ರಾಂಶುಪಾಲರಿಗೆ ಕಾರ್ಯನಿರ್ವಹಿಸಿದ ಡಾಕ್ಟರ್ ಜಯಲಕ್ಷ್ಮಿ ಎನ್ನುವರ ಮೇಲೆ ಸಂಸ್ಥೆಯ ವಿದ್ಯಾರ್ಥಿಗಳು ನೀಡಲಾಗಿದ್ದ ದೂರಿನ ಸಂಬಂಧ ವಿಚಾರಣೆಯನ್ನು ನಡೆಸಲು ಸಮಿತಿಯೊಂದನ್ನು ರಚಿಸಲಾಯಿತು. ಸದರಿ ಸಮಿತಿಯವರು
Jayalakshmi is different.
Jayalakshmi is the principal against whom students have made some allegation. One of the allegation is that my lord principal was using the service of the students for evaluating the answer paper of another university without using the services of the existing teaching staff. That was brought to the notice.
Where is that inquiry report?
Inquiry report is at page number 130. Last page. Dr. Jayalakshmi MSc ವಿದ್ಯಾರ್ಥಿಗಳಾದ ಮಂಜುಳಾ ಮತ್ತು
ಹೆಸರು ಓದ್ಬಾರ್ದು. ಹೆಸರು ಓದ್ಬಾರ್ದು. ಎಲ್ಲ ಆನ್ಲೈನ್ ಇರ್ತದೆ. ಈಗ ಏನೋ ನೀವೇನೋ ಒಂದು ಹೇಳ್ಕೊಂಡು
ಇಲ್ಲ ಸಾರಿ ಇವರುಗಳಿಂದ ಪ್ರಾಂಶುಪಾಲರು ಜಮ್ಮು ಕಾಶ್ಮೀರ ರಾಜ್ಯದ ಉತ್ತರ ಪತ್ರಿಕೆಗಳನ್ನು ಮೌಲ್ಯಮಾಪನ ಮಾಡಿಸುವುದಾಗಿ ವಿದ್ಯಾರ್ಥಿಗಳು ಒಪ್ಪಿಕೊಂಡಿರುವುದರಿಂದ ಹಾಗೂ ದೂರುದಾರರು ನೀಡಿರುವ ಪೆನ್ ಡ್ರೈವ್ನಲ್ಲಿರುವ ಮಾಹಿತಿಯಿಂದ ಕಂಡು ಬಂದ ಸದರಿ ಪ್ರಾಂಶುಪಾಲರಿಂದ ಆಗಿರುವ ಇಂಥ ತಪ್ಪುಗಳು ಮತ್ತೆ ಮರುಕಳಿಸಿದಂತೆ ನೋಡಿಕೊಂಡು ಸಂಸ್ಥೆಯ ಗೌರವಕ್ಕೆ ಧಕ್ಕೆ ಬಾರದು ನೋಡಿಕೊಳ್ಳುವ ಎಚ್ಚರಿಕೆ ನೀಡಬಹುದಾಯಿತು. ದಿಸ್ ಇಸ್ ಆಲ್ ದಿ ರೆಕಮೆಂಡೇಶನ್.
6 member committee.
ಈಗ ಇಂಪ್ಯೂಂಡ್ ಆರ್ಡರ್ ಅನ್ನೆಕ್ಷರ್ A10
ಅದಕ್ಕೂ ಇದಕ್ಕೂ ನಿಮ್ಗೇನು ಸಂಬಂಧ?
ನನಗೇನು ಸಂಬಂಧ ಇಲ್ಲ. ಲೆಟ್ ದೆಮ್ ಡೂ ವಾಟ್ ಎವರ್ ಫಾರ್ ಜಯಲಕ್ಷ್ಮಿ, ವಿ ಹ್ಯಾವ್ ನೋ ಅಬ್ಜೆಕ್ಷನ್. ಬಟ್ ಇನ್ ದಿ ಇಂಪ್ಯೂಂಡ್ ಆರ್ಡರ್ ಅನ್ನೆಕ್ಷರ್ A10 at page number 65, they say you go back to health department. That is nothing to do with inquiry.
But you are from health department only.
True. True. But in the impugned order, annexure A10, page number 65, the reason for starting the proceedings is allegation against the principal.
ಅದು ಏನಾಗತ್ತೆ?
ಅದಾಗತ್ತೆ.
ಅದಕ್ಕೂ ಇದಕ್ಕೂ ಏನು ಸಂಬಂಧ? ಹೆಂಗೆ ಕಲ್ಪಿಸಿ?
ಸಂಬಂಧ ಇಲ್ಲ, ಇದಕ್ಕೂ ಸಂಬಂಧ ಇಲ್ಲ. But they should not have passed this order.
ಯಾಕೆ?
In the reply statement they have filed that because she is working here, we are deputing her, repatriating her for health department. In so far as repatriating is concerned, my lord, that was not the subject matter in the.
That's all right. They have power to repatriate.
Yes,
from parent department.
No, my lord. Therefore, my respectful submission is one judgment of Honorable Supreme Court.
ಈಗ ನೀವು ಅಲ್ಲಿ ಹೋದ್ರೆ ಬೇರೆ ಇನ್ನೊಬ್ಬರಿಗೆ ಅಪಾರ್ಚುನಿಟಿ ಸಿಗ್ತದೆ.
ಅಲ್ಲ, ಅಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ my submission is having regard to my experience and qualification in this.
Permanently ಅಲ್ಲೇ ಇರಬೇಕು ಅಂತೀರಾ?
No, I am entitled for observation. Division bench also has passed order, frame the rules, and medical department rules also permits. Rules also, para 8, my lord. They have filed a counter. In the counter, they said that I've been deputed there for para 8, my lord. The second equally relevant matter is that when statutory functions are made.
78 Supreme Court, 52 Supreme Court.
Govardhan
Banje versus Commissioner of
Correct.
Police.
The impugned order ಏನು action ಏನು ತಗೊಂಡಿದ್ರೆ ಅದು ಇರಬೇಕು ಅಂತ. ಆಮೇಲೆ
that is reiterated by Justice Chandrachud Saab.
Next,
Mohinder Singh Gill, 78 Supreme Court. That makes no sense.
My submission in this case is annexure A9 started. A10 is the order passed. A9 ನಲ್ಲಿ ಸ್ಟಾರ್ಟ್ ಆಗಿದ್ದು ವಿತ್ ರಿಗಾರ್ಡ್ ಟು ಎನ್ಕ್ವೈರಿ ಅಗೇನ್ಸ್ಟ್
ಅವ್ರ ಮೇಲೆ
ಅವ್ರ ಮೇಲೆ, ನನ್ನ ಮೇಲೆ ಅಲ್ಲ. ಆದ್ರಿಂದ ನನ್ನನ್ನ
ಯುವರ್ ರೈಟ್ ಟು ರಿಮೇನ್ ಆನ್ ಎ ಫಾರಿನ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್.
ನನ್ನ ರೈಟ್
ಎಂಡ್ಲೆಸ್ಲಿ
ಅಲ್ಲ, ನನ್ನ ರೈಟ್ ಏನಂದ್ರೆ ಐ ಆಮ್ ಎಂಟೈಟಲ್ ಫಾರ್ ಅಬ್ಸಾರ್ಪ್ಷನ್ ಇನ್ ದಿಸ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್. ಆ ಅಬ್ಸಾರ್ಪ್ಷನ್ಗೆ ದೇರ್ ಇಸ್ ಆಲ್ರೆಡಿ ಅಬ್ಸಾರ್ಪ್ಷನ್ ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ ಅದರ್ಸ್ ಆಸ್ ಪರ್ ಅನ್ನೆಕ್ಷರ್ H. That order I have produced.
You are fighting it else.
ನನ್ನ ಅಪ್ಲಿಕೇಶನ್ ಈಸ್ ಪೆಂಡಿಂಗ್ ಫಾರ್ ಅಬ್ಸಾರ್ಪ್ಷನ್.
ಅದಕ್ಕೆ ಹೇಳೋಣ, ನೀವು ವಾಪಸ್ ಹೋದ್ರು ಸಹಿತ ಇಂಡಿಪೆಂಡೆಂಟ್ಲಿ ಅಬ್ಸಾರ್ಪ್ಷನ್ ಮೇಲೆ ಡಿಸಿಷನ್ ತಗೋಬೇಕು ಅಂತ ಹೇಳೋಣ. ನೀವು
ಅದು ಏನಾಗುತ್ತೆ, ಒಂದ್ಸರಿ ನಾನು ಒಂದ್ಸರಿ ನಾನು ಹೋಗ್ಬಿಟ್ರೆ
ಏನು ನಾವು ಹೇಳ್ಬಿಡ್ತೀವಿ. ಒಂದ್ಸರಿ ಅವರಲ್ಲಿ ಬಂದಾರೆ ಅನ್ನೋ ಕಾರಣಕ್ಕೆ
ಅಲ್ಲಿ
ಅಬ್ಸಾರ್ಬ್ ಮಾಡಲ್ಲ ಅಂತ ಹೇಳ್ಬಾರ್ದು. ಮೆರಿಟ್ ಮೇಲೆ ಅಬ್ಸಾರ್ಪ್ಷನ್ ಕ್ಲೇಮ್ ಅನ್ನು ಕನ್ಸಿಡರ್ ಮಾಡಬೇಕು ಅಂತ ಹೇಳ್ತೀವಿ. ಪರ್ಮನೆಂಟ್ಲಿ ಹೌ ಲಾಂಗ್ ಒನ್ ಕ್ಯಾನ್ ಕಂಟಿನ್ಯೂ ಆನ್ ಡೆಪ್ಯುಟೇಷನ್? 5 years. Normative.
Rule 5 of KCS, sir. 5 years.
5 years.
5 years.
5 years ಆಗಿದೆ.
Ago. Even the issue of whether absorption can be done is covered by.
ಇವ್ರಿಗಿಂತ ಸೀನಿಯರ್ ಆಗಿರುವಂತವ್ರು ಡೆಪ್ಯುಟೇಷನ್ ಮೇಲೆ ಇದಾರ ಅಲ್ಲಿ?
ಅಲ್ಲ, ಈ ಕಾಲೇಜ್ನಲ್ಲಿ ಇದ್ದವ್ರೆ ನಾವು 5 ಜನ.
ಹಂಗೆ ಇವ್ರಿಗಿಂತ ಸೀನಿಯರ್ ಇರೋ
ಅಲ್ಲ, ಒಬ್ರನ್ನೇ. ಆಮೇಲೆ ಇನ್ನೊಂದು ಏನಾಗಿದೆ ಅಂದ್ರೆ, ಈ ಆರ್ಡರ್ ಆದ್ಮೇಲೆ ಸರಸ್ವತಿ ಅನ್ನೋರಿಗೆ, ನಮ್ಮ ಕಲೀಗಿಗೆ ವಾಪಸ್ ತಗೊಂಡ್ರು. ಆದ್ರೆ ವಾಪಸ್ ತಗೊಂಡಿದ್ದಾರೆ ಆನ್ ದ ಗ್ರೌಂಡ್ ದಟ್ ಅದನ್ನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ. ಏನಂದ್ರೆ, ನಾನು ಈ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ನಲ್ಲಿ ಯಾರು ಇಲ್ಲ, ಅದಕ್ಕೆ ಸರಸ್ವತಿ ಆ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ನಲ್ಲಿ ತಗೊಂಡಿದ್ದೀವಿ ಅಂತ ಆರ್ಡರ್ ಆಗಿದೆ. ದಟ್
ಟೋಟಲ್ ಸ್ಟ್ರೆಂತ್ ಎಷ್ಟು ಅಲ್ಲಿ? ಟೀಚಿಂಗ್ ಸ್ಟಾಫ್ ಎಷ್ಟು ಜನ ಇದ್ದಾರೆ?
ಟೀಚಿಂಗ್ ಸ್ಟಾಫ್ 21 ಇರಬೇಕು ಟೋಟಲ್ ಎಲ್ಲ ಸೇರಿ.
ಎಷ್ಟಿದ್ದಾರೆ?
ಈ 5 ಜನ ಇದ್ದಾರೆ.
ಮತ್ತೆ ಇವ್ರು ವಾಪಸ್ ಹೋದ್ರು ಮತ್ತೆ ಯಾರು ಕಲಿಸಿ?
ಯಾರು ಇರ್ತಾರೆ ಮಕ್ಕಳಿಗೆ? ಆಮೇಲೆ ಯಾರಂದ್ರೆ ಅವರು ಇದರಲ್ಲಿ ಇನ್ಸ್ಟಿಟ್ಯೂಟ್ ಇದೆಯಲ್ಲ, ಬೆಂಗಳೂರು ಮೆಡಿಕಲ್ ಕಾಲೇಜ್ ರಿಸರ್ಚ್ ಇನ್ಸ್ಟಿಟ್ಯೂಟ್, ಆ ನರ್ಸಸ್ ಪೋಸ್ಟ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ಅವರು ದೇ ಆರ್ ನಾಟ್ ಕ್ವಾಲಿಫೈಡ್ ಟು ಹೋಲ್ಡ್ ದ ಪೋಸ್ಟ್ ಆಫ್ ಟೀಚಿಂಗ್ ಸ್ಟಾಫ್. ಅಂಡ್ ಮೋರ್ ಓವರ್ ದೇರ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆರ್ಡರ್ ಈಸ್ ಎ ಕಂಡೀಷನ್ ದಟ್ ದೇ ಶುಡ್ ನಾಟ್ ಕ್ಲೈಮ್ ಫಾರ್ ದಿ ಪೋಸ್ಟ್ ಆಫ್ ಗೌರ್ಮೆಂಟ್ ಪೋಸ್ಟ್. It is a government post. That
cannot be a ground for them to take.
But we want
it would become public.
That's all right. Public ಅಲ್ಲ.
Public
ಅಂದ್ರೆ ಸ್ಟೂಡೆಂಟ್ಸ್ ಇಂಟ್ರೆಸ್ಟ್ ನೋಡ್ಬೇಕಾಗತ್ತೆ.
ಹೌದು.
ನೀವು ಯಾವ್ದೋ ಒಬ್ಬರು ಪ್ಯೂನ್ ಅವ್ರನ್ನ ಕರ್ಕೊಂಬಂದು ಇಲ್ಲಿ ಮಾಡಿಸ್, ಈಗ ಇವರನ್ನು ವಾಪಸ್ ಕಳಿಸ್ತಿರಲ್ಲ, ಆಲ್ಟರ್ನೇಟಿವ್ಲಿ ಯಾರನ್ನ ಪೋಸ್ಟ್ ಮಾಡ್ತೀರಿ ಅಂತ ಹೇಳಿ ನಮಗೆ. ದೆನ್ ವಿಲ್ ಕನ್ಸಿಡರ್. ನೀವು ಅದನ್ನ ಪೋಸ್ಟ್ ಮಾಡಿ ಅದನ್ನ ವೆಕೆಂಟ್ ಇಟ್ಟು ಅಲ್ಟಿಮೇಟ್ಲಿ ಯಾರನ್ನೂ ಮಾಡ್ದಂಗೆ ಆ ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಡೆತ್ ಆಗಿ.
ವಾಟ್ ಹ್ಯಾಪನ್ ಮೈ ಲಾರ್ಡ್? ತಪ್ಪಾಯ್ತು.
ನಾವು ಸ್ಟೂಡೆಂಟ್ಸ್ ಬರ್ಬೇಕಲ್ಲ ಅಲ್ಲಿಂದ, ಅಲ್ವಾ?
ಪ್ಲೀಸ್.
ಅಂತ ಸ್ಟೂಡೆಂಟ್ಸ್ ಬರ್ಬೇಕು ಅಂದ್ರೆ ಟೀಚರ್ಸ್ ಒಳ್ಳೆಯವ್ರು ಬೇಕು ನಮ್ಗೆ. ಈಗ they may not have the right at all, but what you are going to do with the vacancy that would be eventually created?
Well, that should be taken care of. I'm only assuming, my lord, because otherwise they will lose student intake capacity as well as recognition. All that
government will do it things according to law. No presumption ಇದೆಯಲ್ಲ, ಅದು ಬಹಳ ವೀಕನ್ ಆಗಿದೆ.
I'll get the information. Who is being replaced? Who is replacing her ಅಂತ I will find out.
ಕೊಡ್ಬೇಕು. ಆಮೇಲೆ ಉಳಿದಂತ ಖಾಲಿ ಹಾಕಿಟ್ಟಿ ನೀವು ಅಲ್ಲಿ ಪ್ಯೂನ್ಸ್ ಅವ್ರನ್ನೆಲ್ಲ ನರ್ಸಿಂಗ್ ಕರ್ಕೊಂಡ್ಬಂದು ಟೀಚಿಂಗ್ ಮಾಡಿಸಿದ್ರೆ ಈ ಸ್ಟೂಡೆಂಟ್ಸ್ ಗತಿ ಏನು?
I'll find out whether qualified person is replacing this. I'll find out.
ನಮಗೆ ಬೇಕು ಅಲ್ಲಿ ತನಕ ಡಿಸ್ಟರ್ಬ್ ಮಾಡಬೇಡಿ. Issue emergent notice. Learned DG is requested to accept notice for the respondents.
But can it be taken up tomorrow itself? Otherwise, there is no merit in this matter. I'll find out and reply.
ನಮ್ಗೆ ಇಷ್ಟ ಹೇಳಿ.
Instead of stay.
ಆಮೇಲೆ ಇವ್ರನ್ನ told ಮೇಲೆ they have no right to remain here.
Indeed.
Because they belong to some other department. ನಾವು ಯಾರು ನೀವು ಪೋಸ್ಟ್ ಮಾಡ್ತೀರಿ ಅಂತ ಕೊಡಿ, ಮತ್ತೆ ಅದಕ್ಕೊಂದು ಕೇಸ್ ಬೇಡ.
ಅಲ್ಲ, ಬೇಗ ಮಾಹಿತಿ ಕೊಡ್ತೀನಿ instead of granting stay, my lord. I will not precipitate the matter. In the meantime, we will not force us to leave.
Call tomorrow.
I'll get the information.
A day after tomorrow.
Agos.
Day after.
Please.
ಅಲ್ಲಿ ತನಕ ನೀವು ಇದು ಮಾಡಬೇಡಿ, precipitate ಮಾಡಿ.
Please, please.
All right. Next.
Short passover.
Passover.
Senior counsel is engaged.
Yes. What is this matter?
Impleading applicants.
Yaar impleading?
We are the affected person. The tribunal, the impleading applicants was selected under the government order dated 15/11/2006, my lord. By virtue of KT order para 13, my lord. Initiate the inquiry against the impleading applicants, my lord. We are not the party before the tribunal, my lord.
ಆಗಿದೆಯಾ? The court officer points out that this application is already allowed by the coordinate bench by order dated 25/4/2023. First off, the petitioners to amend the cost title. ಮಾಡ್ಕೊಡಿ. ಹೌದು, ಮಾಡ್ಕೊಡಿ. Petition ಆಗಿದೆಯಾ? But still other. Therefore, no order need be passed on this application. All right, physically ಮಾಡಬೇಕು. Please, ಮಾಡ್ಕೊಡ್ಬೇಕು. Okay. CPC says pleading should be amended
within 7 days.
even when said, and even when you file the amended petition, that's not sufficient.
Yes, ma'am.
ಕೈಯಿಂದ ಮಾಡಿ ನಂತರ
amendment.
ಹಾಕ್ಬೇಕು. Yes. Yes, Udri.
Challenging, my lords, the land grabbing case proceedings against the petitioner at page 118, my lords.
Good. All applications are allowed, dispensation as sought for is granted. Yes, brother.
I have attached, my lords, the sketch at page 118.
118.
Please. The main allegation, my lords, is the line that your lordship sees above playground, that is divided into two parts, my lords. The upper portion, my lords, is 52/2 survey number, which measures 4 acres, and 52/3, my lords, which is the bottom portion, measures about 2 acres. Now, the allegation, my lords, is that there is a kaldari which goes in between that. That is the
The playground belongs to whom?
Us only. The petitioner. Petitioner, my lords, is the principal of the institution. Principal mele, there is a criminal complaint which is filed by a private complainant.
ಏನಂತ?
Saying that that portion which I showed your lordships at page 118, Kaldari anta helbitu encroachment agide anta heli, they filed the criminal case. Now, my lords, let's assume that there is a Kaldari there. Let's go one step further and assume. Under the Land Revenue Act, my lords,
ನೀವು ಯಾವಾಗ ಬೈ ಮಾಡಿರಿ ಇದನ್ನ?
2007.
2007.
Please.
Act was not there.
It was not there. My boundaries are there, my lords, at page 81 and page 107. Page 81 is one sale deed.
ಅಂದ್ರೆ ಅರ್ಧ ಮೊದಲು ತಗೊಂಡು ಅರ್ಧ ಆಮೇಲೆ ತಗೊಂಡಿರಿ ನನ್ನ ಸರ್ವೆ ನಂಬರ್
52, which later got ported and it became 52/2 and 52/3. And the other sale deed, my lords, is at page 107.
What the land grabbing court said?
It is taken cognizance of the matter. It is taken cognizance. We have taken bail. All that has happened, no doubt about it. But all I am saying, my lords, is even under the Land Revenue Act, 68, section 68 onwards, my lords, there is a provision where, assuming that there is a government land, I can go purchase it. There is an amendment under 2020 under the Act where I can go purchase that property.
Read that.
Please, at my lords, the 69A, section 69A, disposal of lands or other property belonging to state government by public auction. Notwithstanding anything contained in section 69 of the Act, subject to such rules as may be prescribed in this behalf by state government or the authorized officer, may dispose of valuable land or other property belonging to the state government under section 61, 67 or otherwise by public auction, provided that heritage sites and buildings or relics shall not be disposed under this section. The proviso, my lords, which was inserted in 2020, reads thus: provided further that landlocked government kharab land in city areas and up to 18 kilometers from the limits of BBMP, up to 5 kilometers from the limits of other city corporations, after extinguishment of public right under section 68, may be disposed of by the government in such manner at such rates as may be prescribed, but not less than the market value guidelines which is prevailing. 68, my lords, is extinction, whereby notification they say, if there is a dead end or if it is of no use.
Brother, we have admitted and granted entry orders in all such matters. ಎಲ್ಲವನ್ನು pull up ಮಾಡಿ. And even otherwise, This sale is before the act came into force.
Much.
2012 act, notified in 2014.
14. After all the challenges, everything, my lords.
Issue emergent notice. Learned AG is requested to accept notice for respondents 1 and 2. Correct?
Please, my lords.
Emergent notice to private respondents.
My lords, those are, because they were in the complaint, respondent number 3 and 4, my lords, notice may be dispensed. Because they are other accused in the
They are
same
also
proceeding.
accused.
In the same proceeding, different properties, they may not be necessary in this.
But they were not party.
Because order, I am seeking for complaint to be quashed.
As
Complaint-
against you.
As against me.
But our ಬೇಕಿತ್ತು.
That's why, my lords, dispensation.
Counsel for the petitioner seeks leave of the court to disarray respondent numbers 3 and 4. Complaint ಹಾಕಿದವರು ಯಾರು?
Complaint is dead. At page 5 of my petition, my lords.
He is dead.
He is dead.
To be disarrayed from cause title. First off, we have noted submission of learned counsel for the petitioner that original complainant is dead and gone. Interim order has prayed for till next date of hearing.
Great.
Cause title amendment.
Please, my lords.
Revert a couple of seconds.
Court officer? Court officer? Sir? Court officer? Hello? Court officer? Court officer ಇಲ್ವೇನ್ರಿ? Hello? Court officer? ಸಾಹೇಬ್ರು ಮತ್ತೆ ಬರ್ತಾರಾ ಹೆಂಗೆ? ಓ ಅಣ್ಣ. ಅಯ್ಯೋ ಯಾರು ಮಾತಾಡಲ್ವಲ್ಲಪ್ಪ? ಮೇಡಮ್.
ಸರ್ ಬರ್ತಾರೆ ಸರ್.
ಹಾ ಅಷ್ಟೇ ನಾನು ಇನ್ಫಾರ್ಮೇಶನ್ ಕೇಳಿದೆಮ್ಮ ಅಷ್ಟೇ.
ಬೈಕ್ ಆನ್ ಇದೆ ಸರ್ ಅದಕ್ಕೆ.
Yes, brothers. For the petitioner, my lords. This is also arising out of land grabbing itself, my lords, but
Sale deed is of which year?
So,
my lords, here we are a joint development agreement,
Of which year?
2010.
Before the act. Where is that agreement copy?
The joint development, my lords, is at page 36. The grievance here, my lords, is we may not be really shying away from the proceeding, although it's a suo motu proceeding based on a newspaper article.
We have held it is permissible
Please.
to
That's why, my lords, I'm not shying away. What I've challenged in this petition, my lords, is at page 30 of the order sheet. Order dated 1/7/2024, passed by the court. Shri so-and-so, representative of so-and-so is present. He is the person, my lords, who's taken bail, who's the authorized person from the company. But as per section 6 of the Land Grabbing Act, it reads as thus. Where offences are alleged to have been committed under the act by such companies or firms, a mere bald statement that the accused is a director of the company or a partner of a firm in the complaint or FIR held would not suffice to constitute the offence under the act. Such person against whom prosecution is launched is or was in charge or was responsible for the company for conduct of his business. In that light, the authorized signatory is directed to give the details of the person who were in charge. I cannot incriminate. It's a criminal proceeding, my lord. I cannot incriminate myself. And this didn't stop. Sorry.
No, you will not be incriminated. They are saying, give the particulars of your successors.
Successors illa. I am saying I was in charge. I went to file a memo saying that I am in charge. I have taken bail before the court. I am in charge is what I am saying. But instead, my lords, repeatedly the order is being passed which says that you produce documents to show who was in charge. And at page 35, your lordships will see.
Who was in charge ಅಂದ್ರೆ ನೀವು ಬೇರೆಯವರು ಇದ್ದಾರೆ ಅನ್ನೋ ನೀವೆಂಗೂ ಒಪ್ಕೊಂಡ್ಬಿಟ್ರಿ ನೀವು ನಾನಾ ಇನ್ ಚಾರ್ಜ್ ಇದ್ದೇನೆ ಅಂತ.
ಹೌದು.
ಬೇರೆಯವರು ಇರ್ಬೋದು ಅನ್ನೋದಕ್ಕೆ ನಿಮ್ಮ ಹತ್ತಿ ಕೇಳ್ತಾ ಇದ್ದಾರೆ.
ಯಾರಿಲ್ಲ, Tahsildar doesn't say any of that in his report. There's a direct judgment, my lords, if I may pass on.
What we are taught in the law school is right against self-discrimination. Kathi Kalu Ranning versus State of Saurashtra, the famous judgment with which it began. You can't be compelled to be a witness against yourself.
Please.
You cannot be compelled to give evidence against yourself.
Please.
That is the theme we have taken from American.
Please.
Anyway, Kathi Kalu Rawat, Kathi Kalu Ranning versus State of Saurashtra. If we ask you to give certain information, you can't refuse to divulge certain information unless you show, if I divulge that information, I am likely to be prejudiced.
If I just show the joint development agreement, your lordship may kindly see the person, authorized signatory's name is there in the joint development agreement.
68 or 69 Supreme Court, perhaps. A leading case. Constitution bench judgment.
May I just show this, my lords? 482 was filed, identical issue. The Tahsildar should say, my lord, saying that these were the people who have encroached, is what the judgment said.
Is it your case? I do not know. Therefore, I cannot. Or is it your case? I know, but still I will not. Which is your case?
My case, my lords, is that I am the authorized signatory of the entity. I am responsible for the affairs.
Correct.
I am responsible as on the date.
Yes.
All that I have said.
Correct.
I have said so.
Very well.
The Tahsildar does not in his report say that these were the people.
No, we are asking you.
Please.
Court is asking you.
I was responsible is what I am saying, my lords.
Huh?
I was responsible is what I am saying.
That is already, there is one thing.
Please. That also has not been taken on record.
No, that we'll consider that. Do you know who others were? Your statement is not that there is no other person. I am the only person who
We
is
can say that, my
responsible.
lords. If that is the statement to be done, we will say that. I was in charge and nobody else was in charge of it is something that I can say.
ನಿಮ್ಮ ನೀವು ಇಲ್ಲಿ ಇದು ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ಅದು.
ಅದಕ್ಕೆ
He has to make a statement.
That's why, my lords, if your lordships kindly see the judgment that I have now given at paragraph 7.
Which para?
My lords, this also arose from LGC proceedings at paragraph 6. So far as the petitioners 2-4 are concerned, in the order itself, it is mentioned that the accused one is a company represented by its manager, Shri so-and-so. The counsel appearing before the special court also submitted that A2, A4 were not indulged in any activity of the company. Therefore, their names have to be dropped. In spite of that, cognizance was also taken against them, applying the provisions of section 6 of the act. Then paragraph 7 on the next page. As could be seen from the order sheet of the special court, in none of the dates, any further information have been given by the Tahsildar to show that what exactly the role of other directors of the company, so far as the alleged offenses are concerned, and further in the complaint dated so and so, also nothing has been mentioned about the names of the directors and their role. In this context, it is worth to mention here a decision of the Honorable Supreme Court in so and so, wherein the Honorable Apex Court has in detail dealing with section 141 of the Negotiable Instruments Act with reference to the liability of the directors of a company has categorically held as so and so. Then at paragraph 9, therefore, there should be a specific allegation with regard to any connivance or consent of the director in committing such offense. In the absence of such material things in the complaint, merely showing that all the director also are responsible and they were indulged in day-to-day affairs of the company is not sufficient. Therefore, the special court has not given any of its opinion with regard to these aspects, whether there is any material to show that petitioners 2 to 4 are also involved or indulged in committing such offense, or they were also responsible for the day-to-day affairs of the company. In the absence
But
of
who are you to challenge that? Who are you to challenge that?
I
If
am-
They come, we can understand.
Then,
What is
my
your
lord-
locus?
Allah, then what will happen? It's multiplicity.
No, that's not the point.
Your
Court
lordship,
will address. A million questions may arise before the court,
please.
but court will address such questions if they are brought before the court by right persons. That's the law.
Please.
How you are aggrieved? If they want to take action against them, let him come here. We may give relief to them, not you. You can't hold a brief for those who are unknown.
I am currently representing the company. The offense
Anyway,
is
how you are, anyway, you want to be in the waters.
please.
You have told that you want to be in the.
I will face the
fight.
proceeding. my lord.
Very well.
I will face.
But how can you say? You should not bring anybody else here. What is your authority to argue on behalf of those who are unknown? Who wants to know that?
That's why, my lords, I'm saying one submission. I understand if the Tashildar had said the directors.
Question is not that. If those are your clients, straightway we would have issued the notice and stay also. How you are worried about those people?
My company, my lord,
Not with the
ultimately
company, you do it. Why are you worried about those people who are not before the court? If you know, you tell. Otherwise, you say, I do not know. Whatever court wants to do, do it. If they come here, you can't preempt the proceedings against indeterminate people.
The problem, my lords, I am facing there is the case is not moving forward for framing of charges. Your lordships-
You can't hold brief for those who are not before the court.
Allah,
Court wants to bring them in. And that's what. Justice, the judgment which you have given,
please.
that relates to the cases where they came before the court
They came
and
before
said,
the court, my
not
lord.
you.
I understand. They came before the court. But at page 35, your lordships may kindly see.
ನಿಮ್ಗೇನಿಲ್ಲ ನಿಮ್ಗೆ ಲೋಕಸ್ ಇಲ್ಲ ಆ ಪಾಯಿಂಟ್ ಅನ್ನು ಹೋಲ್ಡ್ ಮಾಡ್ಲಿಕ್ಕೆ ನಿಮ್ ಮೇಲೆ ನಿಮ್ಗೆ ಏನಾರ ಆಗಿತ್ತು ಎನಿವೇ ಯು ವಾಂಟ್ ಟು ಬಿ ಇನ್ ದ ವಾಟರ್ಸ್ ಓನ್ಲಿ ಯು ಹ್ಯಾವ್ ಪ್ಲಂಜ್ಡ್ ಇನ್ ಟು
I have
ವಾಟರ್
plunged, my lord. I have
and you
taken
want to
bail.
be in waters. Why
I have
do
no
you
other option.
you are saying let others not punch? What's your right to say that?
Because it is company.
do not-
After all, it's a company. The offense is against a company.
Very well. There may be other persons we do not know. Court wants some information from you. If you know, divulge it. If you do not know, tell I do not know. Because there is one section in IPC which says every person shall answer the questions put by the public authorities. And if he does not answer, it amounts to an offense. I do not remember the section. This is what our professor Alur used to teach us.
It's 35 Vansati, where they say repeatedly, my lord, learned counsel for the accused is directed to furnish certified copy or original memorandum of association of so-and-so company by next date.
ಮತ್ತೆ ನೀವು ಕಂಪನಿ ನೀವೇ ಇನ್ಚಾರ್ಜ್ ಅಂತ ಹೇಳ್ಕೊಂಡ್ರಿ ಆ ಕಂಪನಿ ಇನ್ಚಾರ್ಜ್ ಅಂತ ಹೇಳಿದ್ಮೇಲೆ ಅದನ್ನೂ ಕೊಡಲ್ವಾ ಆಸ್ಕಿಂಗ್ ಡಾಕ್ಯುಮೆಂಟ್ ಮೇ ನಾಟ್ ಅಮೌಂಟ್ ಟು ಇನ್ಕ್ರಿಮಿನೇಷನ್ ಯಾವ್ದು ಜಡ್ಜ್ಮೆಂಟ್ ಆಸ್ಕಿಂಗ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್
Ultimately, my lord,
after all those are all
it's
documents
providing
which can-
evidence against my, tomorrow warrants will be issued, notices will be issued to the directors. My lords, that is not envisaged under the act.
anyway
And that is not the case of the Tashildar either.
that's all. But who are you?
I am the authorized signatory by the company
So
itself.
face it.
The
If there are other, why we should go by your statement as the gospel? If they come and say, we understand.
Let Tashildar say that, my lords, that
ಏನಂತ?
so-and-so people were involved in the encroachment.
How you are aggrieved ಅಂತ ನಮ್ಗೆ ತಿಳಿತಾ ಇಲ್ಲ.
Because I am representing the company. That's my only submission.
ಕಂಪನಿ ಮಾಡ್ಕೊಳ್ಳಿ, ಕಂಪನಿ ಇದೆ, ನೀವಿದ್ದೀರಲ್ಲಿ.
In fact, even if the
there are
judgment-
other people, but how can you represent those who are not before the court?
on behalf of the company, that's all, my lord. That's the only grievance.
ನಿಮ್ಗೆ ನೀವು ಇದನ್ನ ಕೊಡೋದಿದ್ರೆ ಕೊಡಿ, ಏನು ಡಾಕ್ಯುಮೆಂಟ್ಸ್. ನೀವು ಕೊಡಲ್ಲ ಅಂದ್ರೆ ವಿಲ್ ಪರ್ಮಿಟ್ ದಿ ಕೋರ್ಟ್ to proceed against to take those documents from the office of the registrar
ROC, my lord.
ROC ಇಂದ ತಗೊಳ್ಳಿ.
They can do that. They can do that. But to
ನೀವೇ
keep compelling
ಕೊಡ್ಬಿಟ್ಟು
me to
ಪ್ರಾಬ್ಲಮ್
do it,
ಇಲ್ಲ, but you can't hold brief for others.
Allah, that's why I'm saying, if the tribunal wants to, my lords, sumo to take action, I cannot come in the way. I cannot say, please don't go to ROC website and.
You what we do not understand it. They are saying, give the registrar of certificate, so bylaw, so memorandum of MOA, articles of AOA, ಎರಡನ್ನು ಕೇಳಿದಾರ.
ಹೌದು.
ನೀವು ಇನ್ಚಾರ್ಜ್ ಅಂತ ನೀವೇ ಒಪ್ಕೋತೀರಿ, ಒಪ್ಕೊಂಡ್ರು ಅದನ್ನು ಕೊಡಲ್ವಾ ಅಂತೀರಾ?
Tomorrow notice and warrants will be issued against directors.
Oh, why do you worry about that?
My lords, after all, I'm representing the company. I'm representing the company, my lords. I have to protect the interest of the company. So
Interest of company, all right,
please,
but not who are supposed to.
if the Tahsildar, my lords, had said.
You have said that, we have understood.
That's why, my lord, that's my only submission.
And then put a mail. Basu, Article 20, Clause 2. Basu on. Adil Gotagala. Constitution. Basu. Even documents cannot be sought for from the accused.
If.
What is the law on the point? Any student of constitutional law? You become accused at what stage of the proceeding? Protection is to the accused.
Please.
When you attain the status of accused.
When the company is already an accused, my lords, there is a difference.
When you become an accused in criminal law.
When notice is given, my lords, and then cognizance is taken, then you become.
law ಇದೆ. Harpreet Singh. Hardeep Singh versus so and so. Yeah, famous judge. State of Punjab.
State of
14, you are right. Take out that judgment. Criminal side no yaridiri. Criminal side advocates.
319. Section 319.
When a person is called, attains the status of an accused in criminal jurisprudence. Not just somebody filed a complaint on the action accused agalla. Next week it will study
Wednesday, my lords.
whether asking for the documents amounts to self-incrimination.
Please.
Here's apex court. We did not agree with the
No,
American
no, I'll
Supreme
look
Court.
into it, my lord.
Just look into.
On Wednesday,
Come back, but ಏನಿಲ್ಲ ಕೇಸ್ನಲ್ಲಿ. Anyway, let us see.
I'll have it.
Wednesday. All right.
Great.
Wednesday ಆಗಲ್ಲ.
Thursday.
Thursday. Even next Wednesday, Thursday ಇಟ್ಕೊಳ್ಳಿ. ನಾವು ಓದ್ಕೊಂಬರ್ತೀವಿ.
Great.
Because our memory is also fading. ಅದು ಕಥಿ ರಾಣಿ ರನ್ನಿಂಗ್ versus state of Saurashtra ಓದ್ಕೊಂಬರ್ಬೇಕು. They have discussed entire jurisprudence on that. Professor Nagarajan, what is the jurisprudence on that? Whether if a person, when he becomes an accused, like your 214 of your KCSR, it are not like that. And 214 of KCSR, when an employee is said to be an accused ಅಂತ ಗೊತ್ತಾಗತ್ತೆ. Charges are framed. ಅಲ್ಲಿವರೆಗೆ ಆಗಲ್ಲ. ಇಲ್ಲೂ ಹಂಗೆ. He becomes a delinquent when inquiry officer is appointed, articles of charges
are furnished. I'll look into it.
Just look into it. Next week, Thursday, next Thursday. That protection is available only to the accused. If he is not an accused, that protection is not available. Yes. Yes, Mr. Keshav Reddy.
My lord, I appear for the petitioner, my lord.
Yes, sir.
My lord, the father of the petitioner was a government employee, my lord. He was working under the printing press, government printing press at Mysore. He, my lord, expired on 3/9/2020. Then, my lord, 3/9/2020.
ಇದೇನು ಕಂಪ್ಯಾಷನೇಟ್ ಅನ್ನಿದು?
Compassionate ground. Yes, my lord. It is a
Married daughter.
ಮ್ಯಾರಿಡ್ ಡಾಟರ್. ಜಸ್ಟಿಸ್
Married, my lord.
ಜಡ್ಜ್ಮೆಂಟ್ ಕವರ್ ಆಗಲ್ವಾ?
ಆಗಲ್ಲ.
ಆಗಲ್ಲ. ಯಾಕೆ?
She is living separately, my lord. She is not the dependent.
But that.
My lord,
One second, Mr.
Please,
We
please,
have
please,
lot
please,
of
please.
literature on that. Please.
Please,
wait.
please.
What is that? What Justice Nagprasanna said? And you have amended the rule also?
Yes, my lord, we have.
What is that? Dependence illa anta.
ಹೌದು.
Not on the ground that she is daughter, but she is not dependent.
Dependent.
Which is that rule which reads? Dependent of a deceased government servant means.
Yes,
But family, deceased government servant who was living with and dependent the deceased government servant who fulfills the conditions specified so and so so and so. Family, deceased male married government servant, his widow, son, daughter, unmarried, married, or widow, who were dependent upon him. 2.1b.
Family was described, my lord.
What is your client's husband doing, Mr. Reddy Garu?
My lord, right now I don't know, my lord, but my request to your lordship to look to my document, my lord, at annexure A5, which was produced before the KAT, available
A5,
at page
page number?
47, my lord.
ಏನಂತ ಹೇಳ್ತದೆ ಅದು?
ಅದು ಅರ್ಜಿ ಕೊಡ್ತಾರೆ ಅವ್ರ ತಾಯಿಯವರು, ಅದರಲ್ಲಿ ಅವರು ಕ್ಲಿಯರ್ ಆಗಿ ಹೇಳ್ತಾರೆ ಸ್ವಾಮಿ.
ಏನಂತ?
ಮೈ ರೀಡ್ ಮೈ ಲಾರ್ಡ್. ಸೊ ಸುಜಾತಾದ ನಾನು ಮೇಲ್ಕಂಡದ ನನ್ನ ಯಜಮಾನರು ಸೊ ತೀರ್ಕೊಂಡಿದ್ದಾರೆ. ನನಗೆ ಇಬ್ಬರು ಹೆಣ್ಣು ಮಕ್ಕಳಿದ್ದು, ದೊಡ್ಡ ಮಗಳಿಗೆ ಮದುವೆ ಆಗಿದೆ. ಎರಡನೇ ಮಗಳಾದ MS ಚೈತ್ರಾರವರಿಗೆ ಮದುವೆಯಾಗಿದ್ದು ಕುಟುಂಬದ ನಿರ್ವಹಣೆಯ ಜವಾಬ್ದಾರಿ ಇವಳ ಮೇಲಿರುತ್ತದೆ. ನನಗೆ ವಯಸ್ಸಾದ ಕಾರಣ ನಾನು ಕೆಲಸ ನಿರ್ವಹಿಸಲು ಆಸಕ್ತಳಾಗಿರುತ್ತೇನೆ. ಆದ್ದರಿಂದ ದಯವಿಟ್ಟು ನನ್ನ ಎರಡನೇ ಮಗಳಾದ MS ಚೈತ್ರಾಳಿಗೆ ಅನುಕಂಪದ ಆಧಾರದ ಮೇಲೆ ಅವರ ತಂದೆಗೆ ಹುದ್ದೆಯನ್ನು ನೀಡಿ ನಮ್ಮ ಕುಟುಂಬಕ್ಕೆ ದಾರಿದೀಪವಾಗಿ ಬಂದು ಮೂಲಕ ಕಳಕಳಿಯಿಂದ ಪ್ರಾರ್ಥಿಸುತ್ತೇನೆ.
ಪ್ರಾಪರ್ಟಿ ಹೋಲ್ಡಿಂಗು ಇದೆಲ್ಲ ಏನಿದೆ ಅವ್ರದ್ದು? ವಿಡೌಟ್ ಡಾಟರ್ ಇದಾರಲ್ಲ, ವಿಡೌಟ್ ಡಾಟರ್ದು ಪ್ರಾಪರ್ಟಿ ಹೋಲ್ಡಿಂಗ್ ಏನಿದೆ? ಬ್ಯಾಂಕ್ ಬ್ಯಾಲೆನ್ಸ್ ಎಷ್ಟಿದೆ?
Daughters. My lord, there are only 2 daughters.
We have understood that. Question
Yes, my
is,
lord.
the widowed daughter, you want that job to be given to widowed daughter?
Widowed ಆಗಿಲ್ಲ. She is also married. She is living with her mother in the same family.
She is married.
Her mother, she is looking after her mother there in the same family, my lord. Because
she will not be dependent only. She is looking after another person.
Allah, all of these persons were living along with the father, and they were dependent upon the income of the father. Thereafter, she got married, but still she was responsible for running the family of the mother, my lord. So the source of income for the widowed wife is required to be, my lord, made available under the compensated grounds.
See, in our law, in our scriptures say, Pita rakshati kaumare, Bharta rakshati yavane, Rakshanti sthavire putra. Means the son should look after the aged lady. During her youth, Bharta rakshati yavane, husband will look after. Your client has a husband. That's what section 125 says.
That's right, my lord. But the wife of the deceased government employee will become destitute. There will be nobody to look after because they have no sons.
Let her have the appointment, compassionate appointment.
ಅಲ್ಲ, ಅವಳು ನನ್ ವಯಸ್ಸಾಗಿದೆ, ನನಗೆ ಮಗಳಿಗೆ ಕೊಡು ಅಂತ ಕೇಳ್ತಾರೆ.
ಮಗಳಿಗೆ ಕೊಡ್ರಿ, ಒಂದು 50 ವರ್ಷ ಅವ್ರು ಇರ್ತಾರೆ ಸರ್ವಿಸ್ ನಲ್ಲಿ, ಆಮೇಲೆ ಇನ್ನು ಉಳಿದವ್ರಿಗೆ ಯಾರಿಗೂ ಸಿಗೋದು. ಇಟ್ ಈಸ್ ಫಾರ್ ಟೈಡಿಂಗ್ ಓವರ್ ದ ಡಿಸ್ಟ್ರೆಸ್ ಅರೈಸಿಂಗ್ ಆನ್ ಅಕೌಂಟ್ ಆಫ್ untimely demise of the breadwinner of the family, patriarch of the family. Your case is not that the ಅದನ್ನ ಹಂಗೆ ನೆಗೋಷಿಯಬಲ್ ಇಲ್ಲ. ಅದು ಇದು ನಂಗೆ ಬೇಡ ಅವ್ರಿಗೆ ಕೊಡ್ರಿ ಅಂತ ಹೇಳಕ್ ಬರಲ್ಲ. ನಾಟ್ ಎ ನೆಗೋಷಿಯಬಲ್ ರೈಟ್ ಅದು. If she applies, government will consider independently. You can't say, you give that right. It's not a negotiable. TDR type Allah. Right to get the
I
compassionate
understand, my lord, but the endorsements given was not on that line. ಇಲ್ಲ ನಿಮ್ಗೆ ಇವ್ರು ಕೊಡಕ್ ಬರಲ್ಲ ಅಂತ ಹೇಳಿಲ್ಲ. Because she is married, she cannot be given anta. That's the only point they raise.
No, but the law says, section 2.
But according to the amended rules, married daughter also can be given.
Provided she is dependent. Correct. Only on the ground that one is married, one is not married, there cannot be discrimination. Married daughter is also a daughter, but
that's true.
The dependence. Suppose married daughter is a billionaire irtan ganda. Oh, I am married, I am also daughter, marriage is irrelevant, therefore give me employment only ಕೊಡ್ತದ. ಅದು ಯಾರಿಗೆ ಡಿಸ್ಟ್ರೆಸ್ ಆಗಿರುವಂತವರಿಗೆ ಅಲ್ಲಿ ಡೆತ್ ಹೆಡ್ ಆಫ್ ದಿ ಫ್ಯಾಮಿಲಿ ಡೆತ್ ಆಗಿರ್ತದೆ, ಅವ್ರಿಗೆ ತೊಂದರೆ ಆಗ್ಬಾರ್ದು ಅನ್ನೋ ಒಂದು ಫಿಲಾಸಫಿ ಮೇಲೆ ಅದನ್ನ ಬಿಲ್ಡಪ್ ಮಾಡಿದ್ದಾರೆ.
May I make a submission, my lord? I'll find out what is the husband of the applicant is doing, my lord. Your lordship may give me a short time. I will come back.
ಅಲ್ಲ, ನಿಮ್ಮ ಅಪ್ಲಿಕೇಶನ್ ದಲ್ಲಿ ಇರ್ಬೇಕದೆಲ್ಲ, ಇಲ್ಲಿ ಹೇಳೋದಲ್ಲ. ನಂದು ಇಷ್ಟೇ ಇದೆ, ನನಗೊಂದು 250 ಎಕರೆ ಲ್ಯಾಂಡ್ ಬಿಟ್ಟರೆ ಬೇರೆ ಏನಿಲ್ಲ, ಆ ರೀತಿ ಬರ್ಬೇಕು ಅಪ್ಲಿಕೇಶನ್ ದಲ್ಲಿ, ಅವಾಗ ಬರ್ತದೆ. ನೀವು ಅಪ್ಲಿಕೆಂಟ್ ಅಲ್ಲೇ ಇಲ್ಲ, ಮದರ್ ಇಸ್ ದಿ
ಆಮೇಲೆ ಮತ್ತೆ she was made to apply, my lord. ಒಂದು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ತಾಳೆ ಇವಳೆ, petitioner has filed the application.
Dismissed on the ground that the mother cannot have the negotiable right of compassionate appointment in favor of married daughter. Married daughter. First.
One request, my lord.
Secondly, the married daughter is not the applicant seeking a compassionate appointment at all.
ಇಲ್ಲ, ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದಾರೆ ಸ್ವಾಮಿ, ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದಾರೆ. ಅದು ಇಲ್ಲೇ ಇದೆ ನೋಡಿ. My lord, I will point out, my lord, the application is there. ಅವ್ರು ಹಾಕ್ತಾರೆ ಅಪ್ಲಿಕೇಶನ್. Subsequently, she made application. ಅವ್ರ ತಾಯಿ ಮೊದಲು ಕೇಳ್ತಾಳೆ, ಆಮೇಲೆ ಈ ಅಮ್ಮ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ತಾಳೆ, my lord. ಇಲ್ಲಿ ಇದ್ರಲ್ಲಿ ಹಾಕ್ತಾಳೆ. ಅಪ್ಲಿಕೇಶನ್ was filed. ಒಂದೇ ನಿಮಿಷ. Application was 67 ನಲ್ಲಿ, page number 67 is the application filed by the petitioner.
ಇದ್ರ ಮೇಲೆ ಡಿಸಿಷನ್ ತಗೊಂಡಿಲ್ವಾ? ಇದ್ರ ಮೇಲೆ ತಗೊಂಡಿದ್ದು ಡಿಸಿಷನ್.
ಅದರ ಮೇಲೆ
ಇಂಪ್ಯೂಗ್ನ್ಡ್ ಆರ್ಡರ್ ಇಸ್ ಮೇಡ್ ಬೇಸ್ಡ್ ಆನ್ ದಿಸ್ ಓನ್ಲಿ.
ಎಸ್ ಮೈ ಲಾರ್ಡ್.
ಅಲ್ಲಿ ಅದೇ ಸೇಮ್ ಡಿಪೆಂಡೆಂಟ್ ಅಂತ ಪ್ರೂವ್ ಮಾಡಿಲ್ಲ ಅನ್ನೋದ್ರ ತಗೊಳ್ತಾರೆ, ಲಿಮಿಟೇಷನ್ ಅಂತ ತಗೊಳ್ತಾರೆ. Limitation, my lord, that is covered because of that corona period, my lord. Exemption was there from the Supreme Court. So ಅದ್ರ ಕೆಳಗಡೆ
now what is your husband ಅಂತ ಎಲ್ಲಿ ಹೇಳಿರಿ?
ಅಲ್ಲ, ಎಲ್ಲೂ ಹೇಳಿಲ್ಲ,
ಸೆಂಟೆನ್ಸ್ ಇಲ್ಲ, ಎಲ್ಲೂ ಹೇಳಿಲ್ಲ. ಹಸ್ಬೆಂಡ್ ಪ್ರಾಪರ್ಟಿ ಏನಿದೆ, if you are a dependent you follow go against husband.
ಹೇಳಿಲ್ಲ. I accept, my lord, I accept it is ಹೇಳಿಲ್ಲ. I am permitted to say before your lordship what is
dismissed.
At least her mother may be, my lord, her mother may be permitted to apply, my lord.
The tribunal. However, this dismissal order will not come in the way of eligible and qualified person seeking compassionate appointment in accordance with rules.
Please.
Yes.
Identical matter. The respondent petitioners filed this case in application.
ಆನ್ ಮಾಡ್ಕೊಳ್ಳಿ.
The writ petition number 5483 of 25 and 5701 of 25. It will be listed on Thursday, my lord.
Call along with on Thursday.
Lords, one submission.
Ah.
There, my lords, the applications were dismissed. Only in one application, my lords, it was allowed. The state has filed a writ petition. Contempt is coming up on Friday. Let them not precipitate the contempt.
Thursday
Call
ಬರುತ್ತೆ
this matter
on Thursday.
next week. Till then, the respondent shall not precipitate the contempt proceeding
CTA number 13 of 2025.
in CTA number
13 of 2025.
Alhingano. Yeah, respond annal beda. The pending CTA number so and so shall not be precipitated at the hands of the tribunal.
Yes, grateful.
Call along with these matters a week after next. Next. 5483. I'll mail get a heard. K.N. Prakash, panel counsel is requested to accept notice for response number 2, issue notice to signs. Next.
Grateful.
Here for the petitioner, Manoj.
Yes.
This is arise out of a consumer complaint. The respondent number 1 had filed against the petitioner. Petitioner is a bank in relation to a bank guarantee that was given in favor of R1. Certain documents were given to me for safekeeping, which I have given to R2 to keep in their warehouse as part of my agreement with them. Those documents got destroyed in a fire that was then in R2's premises, OP2. In the proceedings below in the proceedings before the State Commission, OP3 has been implemented by the complainant on the ground that they are the holding company of OP2. OP3 files an application for deletion of OP3 alone. That application comes to be allowed and OP2 and 3 are both deleted. Then there was never any prayer to delete OP2. The application, your lordship would find the impugned order at page 33.
33.
Please, Lance. Relevant portion starts at 34. The heading itself records orders an IA filed under Order 1, Rule 10.2 by OP3. This is an application filed by OP3 to strike out the name OP3 from the array of parties.
2 is also struck out.
2 is also struck out, Manoj. At the bottom of 36, accordingly, Commission directs complainant to strike out the names of OP2 and 3.
On what ground OP3 is struck off?
I had a contract with OP2. OP3 is their holding company. So on that ground, they filed an application saying they have no contract with anybody. The contract was only between OP1 and OP2 for safekeeping of those documents. And therefore, OP3 only being a holding company, they said we are neither necessary nor proper parties.
They are referred to 2002. Come to page 36. Is not necessary.
That's right. But in this instance, there is no application on behalf of OP2.
There need not be.
But OP2 is the party who was keeping the documents which were destroyed in the fire.
All right. How that will be? How he will be necessary? What for you want him to be?
And it's as the contracting party, I am the bank. I have taken due care. There's no negligence on my part. I have contracted with the party to store my documents in his location.
Correct.
As to what has happened to those documents, whether due care was taken, whether there is a deficiency in service in that storage, only OP2 can respond.
For that, why he should be ready? Party, he need not be a party at all. You can lead evidence, you can summon him.
In that sense, since he is also providing the service, and the Honorable Supreme Court has also said there's a full bench decision that even if there is no direct privity of contract, under the Consumer Protection Act, even third parties who get the benefit of that contract.
Upon him to produce a document.
You can ask him to produce document. You can ask him to depose.
Since the service of service was actually of safekeeping was actually being provided by him. It is not a service that is being provided by me. I am taking the documents to keep in safe custody to protect, secure.
You are respondent number?
I am OP1 before the
OP1.
Yes.
How you are aggrieved if OP3 is left out?
OP3, I have no dispute.
OP2 is aggrieved
because he is the party with whom I have contracted.
Complainant is the master of the cost title.
Please, Manoj. Complainant has impleaded him.
Complainant, whether his complainant is complaining before this court.
Not I am before this court.
You take up contention. A necessary party is left out and therefore complaint is not maintained. That contention you can take up. Markali. petitioner is knocking at the doors of Writ Court for assailing the State Consumer Dispute Redressal Commission order dated so and so, whereby OP2 has been disarrayed in terms of APESCO decision in 2002, which accords with the long-standing legal position in Prajia Begum versus so and so 58, Supreme Court so and so so and so. First. Next paragraph. Learned counsel for the petitioner vehemently argues that the application was filed only for deletion of OP number 3, whereas the tribunal suo motu has disarrayed OP number 2, which is impermissible. First, having heard the learned counsel for the petitioner and having perused the petition papers, we do not subscribe to the argument advanced at the bar that in the absence of an application, comma, a person who is a party nomine cannot be disarrayed when court, after examining the material on record, forms a considered opinion that he is neither necessary nor a proper party in the light of Rajia Begum. First, for that, there need not be a separate application as a precondition for undertaking said exercise. First, next paragraph. The cause title ordinarily belongs to the dominant litis and thereafter to the court. First, a respondent ordinarily cannot raise objection to disarray certain person from the cause title in the absence of demonstrable prejudice likely to happen by such disarrangement. First, that is not been established before us even prima facie. Next one, in the above circumstances, petition being devoid of merits is liable to be and accordingly dismissed. First, however, it is open to the petitioner to take up the contention as to proper and necessary party, comma, if at all it is admissible based upon the pleadings and substance. Okay.
Deeply obliged.
A registry to send a copy of this order to the respondent by speed post. Okay.
May be permitted to submit on behalf of the petitioner's advocate, my lord.
In this case, my lord, I pay for the respondent 9. I am undertaking to file an wakalat on behalf of respondent number 9, my lord.
You want to file wakalat?
Yes, your lord.
Let us see. Let him make a
Please,
case,
my
na?
lord, please.
Yes.
But this is an order under section 18 of the Recovery of Debts Act appeal. My lord, the Debt Recovery Tribunal, Chennai, assumed jurisdiction, my lord, even though the application under section 17 was filed in Bangalore on the premise that the liability is more than 50 crores. There was a notification of October 2nd, whereby any amount above 50 crores would be considered by the Debt Recovery Tribunal, Chennai. The Debt Recovery Tribunal, Chennai, my lord, considers my submission on the premise that the liability is restricted to 50 crores. Therefore, it could not have exercised its jurisdiction. That is one aspect. Second aspect, I made a submission that my guarantee was rightly revoked under section 130 of the Contract Act. The third submission I made, my lord, which was not accepted by the Debt Recovery Tribunal, was that the documents were executed in Hyderabad and it was not stamped because the property concerns Bangalore. It was not stamped. The Debt Recovery Tribunal says that the document is executed in Hyderabad, therefore it need not be stamped as per the Karnataka Stamp Act, which is contrary to section 3 and 7 of the Stamp Act. My submission is based on this fact, my lord, that no valid security interest is created because there is no registered mortgage. Under section 59, it should have been, because if it's a property for more than 100 rupees, the document should be attested by at least 2 persons and it should be registered or at least duly stamped to be looked into. Based on all these considerations.
Equitable mortgage?
My lord, the document reads, my lord, that it's a I am supposed to deposit the documents later.
Where is that document?
Yes, my lord, I produced the documents. Please see ink page 95 to the petition.
Because Apex Court said
Yes, my lord.
an equitable mortgage need not have any document at all.
Yes, my lord, I would bow down to that, my lord, to say further that what the Honorable Apex Court, what I read was, my lord, that that's a cooperative case, my lord is pleased to rely on that, which says it's a right in personam. That means if I would give the documents to the bank by not creating a mortgage completely in, it's an analogous mortgage, it would be a right in personam, even in, I think, Bombay, JK.
How we are concerned with that
My
concept?
lord, reason is, if it is not a security interest under the SARFACI Act, then 13(2), my lord, where any steps are to be taken as against a property would not be applicable. If I have created a security interest, I request my lord to kindly see
Where
the
is there
Yes.
a document?
ink page 95. This is a guarantee agreement. My lord is pleased to see the first page is for 200 rupees. And the following page, my lord, ink page 96, the unnumbered paragraph 2, which says that, whereas in terms of the agreements executed by so-and-so, the borrower, I'm not the borrower, my lord, unless repugnant to the context, meaning shall be include successor, the bank has agreed to provide the facilities or any of the facilities as may be agreed from time to time between the bank and the borrower for sum not exceeding in the aggregate of 50 crores short-term loan for the purposes of working capital requirement. Now, this was followed up, my lord. Please see the page 101 is where I have signed it. And
You don't dispute this document.
My lord, what I say, my lord, because I should fairly say to my lord, I have filed a separate suit because the moment they gave me a notice under the Securitization Act, I filed a suit to say that this transaction is a fraudulent one.
What is your status? Are you
My lord,
income tax payer?
I'm an income tax payer.
What's your educational qualification?
My lord, I'm a practicing lawyer, my lord.
Lawyer.
I'm a practicing lawyer.
What is your property holding?
My lord, this particular property is
Worth?
7.5 acres it's already been sold, my lord. During the pendency of the proceedings, property was already sold. And this is at page 100. Please see, my lord, on the left side. The second person.
Issue notice, no interim order.
My lord, only one.
Learned Counsel Shri
Jagdish JP for
appears
Paras
for 9th
R9.
respondent. Issue emergent notice to
There are only one
rest of
request,
the respondent.
because as per the proceedings, my lord,
He is not some Kalle Gowda, Rame Gowda working in the farmland to take up the contention that I have been defrauded, I have been coerced. He's a practicing lawyer owning property worth crores. Crores.
my lord, my submission here, my lord, is I'm challenging the proceedings.
Despite OC for a submission. Shall we record or you
No,
wait?
no, I'm only saying this, my lord. The DRT rejected my contention. I went before the appellate tribunal.
You have said all that.
No, no,
Okay, you
appellate
raised
tribunal
those
has.
points as to the pecuniary jurisdiction number 2 not being duly stamped and the anomalous mortgage it is, and therefore registration was also necessary, etc. Yes. We consider that. Yes.
Please.
Yes.
They have to continue that
After 2.
this month.
Ready?
No,
Yes.
ready, because it is
Start.
Have to-
Backlog you can see.
What has happened is, my lords,
Ah.
in the name of backlog, almost the entire cadre has been filled by SC, ST. That was set aside by the tribunal based on working out the details as per the roster in force in state of the Karnataka.
Yes.
And our direction was issued to consider general merit candidates promotions. That has been stayed, and that is the urgency. Last time they started.
ಈಗ ಬೇರೆ other matters ನಲ್ಲಿ ಇದ್ದೇವೆ. As many of you may be knowing, we have taken up some cleansing exercise.
Yes,
as you know. So
I
call this
know,
matter.
Millards. Now, after the
Okay.
last hearing, I came to know of it.
ಅದೇ ಹಿಂಗಿದೆ ಅದು. ಸರಿ. Call this matter in the last week of April. Full stop. Release from part head, interim order to continue. Please, Millards. Yes. Next.
Transfer matter. My colleague will argue, Nagaraj.
Companion matter, I have a appearing matter, my friend has quoted me to argue his case on.
Aish, Aish, you are most welcome, Professor.
Lord, the petition is directed against the orders of the Honorable Tribunal dated 13 January 2015 application.
ನಾವು ಒಂದೆರಡು ಒಂದ್ ನಾಲ್ಕೈದು ಆರ್ಡರ್ಸ್ ಎಲ್ಲ ಸೈನ್ ಮಾಡ್ಲಿಕ್ಕಿದೆ. ಕೆಲವು ಅರ್ಜೆಂಟ್ ಮ್ಯಾಟರ್ಸ್ ಇದೆ. We'll come at 2:30. Come at 2:30.
Grateful, please.
Very good. Some urgent orders to be signed.
I'm great.
Very
I'm great.
Here for the respondent in this matter. But then afternoon we have KPSC matter.
Sir.
2:30, then yes.
2:30 KPSC matter is there.
2:30 KPSC matter.
KPSC matter is there.
It did not take more than 10 minutes, Mother. Complete.
More than 5 minutes.
10
Some
minutes.
difficulty at 2:30, my lord.
I won't take much time.
Senior is appearing through VC.
Only the question is as to your lordship, as to the moot question that would arise for your lordship, whether the Commissioner for BMRDA has competency to relieve me from the post of STRRPA, that's all.
Padi. Yes, start.
My lord, I'm the.
What are the foundational facts? Just say in 5,
Yes, my
6.
lord. I'm a town planning officer, my lord, that.
You are town planning officer?
Yes, I'm a town planning officer.
Ah.
In the cadre of Joint Director. Joint Director, Town Planning, Joint Director.
Ah.
Working, and I was given posting at the BBMP. In this BBMP squad. Not the, by the, by the, what, annexure A3, my lord.
BMRDA.
Yes, annexure BBMP. I
ಯಾವ
was
ಕೇಸ್
working.
ಆರ್ಗ್ಯೂ ಮಾಡ್ತಾ ಇದ್ದೀರಿ? 1596.
House.
1596 Yes. BMRDA ಅಂತ ಹೇಳ್ತಾ ಇದ್ದೀರಿ?
BMRDA has relieved me.
ಏನಂತ?
The Commissioner for BMRDA has relieved. I was working as a member secretary of the STRR, what is that? STRRB, Satellite Town Ring Road Project Authority. I was working as a member secretary of that.
Yes.
Now, I was relieved by the Commissioner for BMRDA. Commissioner for BMRDA. These BMRDA and STRRPA are two different entities.
The BMRDA is constituted under Town and Country Planning.
Town Planning Act, Section 4. 4B provides for segregate withdrawal of certain portion from the BMRDA and withdrawal. 4C, a separate authority can be constituted. By the order to annexure A1 brought that the page number 58, 50 million.
50?
Yes, ma'am, 50. There are ಎರಡು ಅಧಿಸೂಚನೆ ಎರಡಿದೆ ಸ್ವಾಮಿ. ಒಂದು ಎರಡು. The certain portions from the BMRDA has been withdrawn and STRRBS ಅಧಿಸೂಚನೆ ಎರಡರಲ್ಲಿ STR was constituted.
ಆ ಪರ್ಟಿಕ್ಯುಲರ್ ಏರಿಯಾ STRR ಗೆ ಬರ್ತದೆ.
Yes, ಬಂದ್.
ಅಲ್ಲಿ ನೀವು you were joint?
Annexure A3 brought that. Annexure A3. Annexure A3, page number 74. ಶ್ರೀ ವೆಂಕಟ ದುರ್ಗಾ ಪ್ರಸಾದ್ ಕೊಂಟಾಳ ನಗರ ಮತ್ತು ಗ್ರಾಮಾಂತರ ಯೋಜನೆ ಇಲಾಖೆ ಜಂಟಿ ಬೃಹತ್ ಬೆಂಗಳೂರು ಮಹಾನಗರ ಪಾಲಿಕೆಯವರನ್ನು ಸಾರ್ವಜನಿಕ ಆಡಳಿತ ಹಿತದೃಷ್ಟಿಯಿಂದ ಈ ತಕ್ಷಣದ ಜಾರಿಗೆ ಬರುವಂತೆ ಹಾಗೂ ಮುಂದಿನ ಆದೇಶವರೆಗೆ ಶ್ರೀ ಎನ್ ಗೋಪಾಲಕೃಷ್ಣ ಜಂಟಿ ನಿರ್ದೇಶಕರು ಹಾಗೂ ಸದಸ್ಯ ಕಾರ್ಯದರ್ಶಿ ಉಪನಗರ ವರ್ತುಲ ರಸ್ತೆ ಯೋಜನಾ ಪ್ರಾಧಿಕಾರ STRR ಬೆಂಗಳೂರು ಇವರ ಸ್ಥಳಕ್ಕೆ ವರ್ಗಾಯಿಸಿ ಆದೇಶಿಸಿದೆ. This order is by the government. This order is by the government. And then the annexure A4.
This was your posting order.
Yes, madam. I reported and I working. Annexure A4. ಬಿಡುಗಡೆ ಆದೇಶ ಅಂತೇಳಿ page number 75.
Who has power to direct posting?
Government.
Which section? Which rule?
Section 4.
Section 4. What is
Section 4C
Town and Country
of the
Plan?
Town and Country Planning Act.
Government has posted you.
4.3, not every planning authority.
4C.
4C, Constitutional Planning Authority. 4C provides for Constitutional Planning Authority.
Correct.
And 4T,
May in fact appoint one of the members as vice chairman.
the planning officer appointed by the state government who shall be member secretary of the state planning authority. Now,
Come to 3.
Every planning authority constitution shall be consider the following members, namely a chairman appointed by the government, a town planning officer appointed by the state government who shall be member secretary to the planning authority.
New town planning officer ನೀವು?
Yes, I have town planning. Joint director, in the cadre of joint director, town planning.
Like a joint director.
House. Town planning is different. Assistant director is some, deputy director, joint director, per place.
ಅಲ್ಲ ನಿಮ್ಮ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ as ಟೌನ್ ಪ್ಲಾನಿಂಗ್ ಆಫೀಸರ್ ಅಂತ ಎಲ್ಲಿದೆ?
Member secretary ಅಂತ ಇದೆಯಲ್ಲ some A3.
Member secretary is different, town planning officer is different.
No.
ನೋಡಿ.
No, a member now the question is that whether member secretary, the fact that I am appointed as member secretary is not in dispute.
Where is that?
That is page A3.
Post create ಮಾಡಿ
A2 post create ಮಾಡಿದ್ದಾರೆ please ಅದನ್ನ.
ಯಾವಾಗ ಕ್ರಿಯೇಟ್ ಮಾಡ್ಯಾರೆ?
Page number 27 on 2021, page number 72, the operative portion of the entire order, page number 72.
72.
Yes, madam.
Member secretary.
Yes, madam.
But new member secretary ಅಲ್ಲಲ್ಲ?
ಇಲ್ಲಿ A3 member secretary ಪಾಸ್ ಮಾಡಿದ್ರಲ್ಲ ಸ್ವಾಮಿ A3.
ಎಲ್ಲಿದೆ?
A3 page number 74.
ಸ್ಥಳಾಂತರಿ ಸದಸ್ಯ ಕಾರ್ಯದರ್ಶಿಯಾಗಿ ಪೂರ್ಣ ಪ್ರಮಾಣದ ವ್ಯವಸ್ಥೆ ಅಂಟಿಸೋ.
Yes, that's right. Now, when while working, sir, the commissioner BMRDA, by the annexure A4, page number 79, the operative portion is at page number 78.
78.
Yes. ವೆಂಕಟ ದುರ್ಗಾ ಪ್ರಸಾದ್ ಕುಂಟಾಳ ಜಂಟಿ ನಿರ್ದೇಶಕರು ನಗರ ಮತ್ತು ಗ್ರಾಮಾಂತರ ಯೋಜನೆ ಇಲಾಖೆ ಪ್ರಸ್ತುತ ನಿಯೋಜನೆ ಮೇರೆಗೆ the word used is ಪ್ರಸ್ತುತ ನಿಯೋಜನೆ ಮೇರೆಗೆ when the government is appointed as member secretary.
How what is the authority of commissioner of BBMP? Bengaluru Mahanagara Pradesh Abhiruddhi Pradhikara. BMRDA. What is his authority? Who appears for
please, senior counsel is on.
BMRDA, blood, BMRDA. Yes, blood. BMRDA commissioner, he noticed that for 18 months repeatedly they had asked him to implement the project blood.
Correct.
And they issued show cause notices and he did not fulfill the
correct. What is your power?
And repeatedly.
Yes, sir. We will agree that he has committed so many mistakes there.
Yes, blood. Commissioner is the overall in charge BM affairs of the BMRDA. And therefore
the power is in the government.
Government has the power, blood, but commissioner has only relieved him. He has not,
that he cannot do. He should seek orders at the hands of the government.
Blood, but thereafterwards, what the government has done, government has taken these orders and posted him elsewhere, blood.
Where is that?
That is at annexure R10. So therefore, government has accepted this order. And now he challenged the position that has been dismissed in KT and that has been dismissed.
Next petition.
Government has accepted the relieving order
Government
and
has-
given posting.
I have challenged that order. I challenged that order in subsequent written company writ petition. No, the KAT dismissed my writ petition on the ground since I have obeyed this order. 20.
Obeyed Allah. Ali, government has given you
Yeah,
this order. Why, on what ground,
Sir,
where is the
that- that's
security of
subsequent-
thing?
So that is subsequently this and during the pendency of the petition or during the pendency of the application before the Honorable KAT, 22/11/2024 order, this order was came to be passed.
All right, this is passed.
Yes, ma'am.
What is fault with this order? Anta?
This order challenge is before the KAT also.
On what ground?
3 years. On the ground that 3 years. ma'am.
Retention period is 3 years.
3 years. Once Sasai Karse 3 varsha. The tribunal said that it is not an appointment, it is transfer. Even otherwise, not that I'm a group A was maintained for 2 years. That is on that ground also, alternate ground also taken that.
The charges was there.
Planning, the Karnataka Planning Authority rules 1965, not that.
The commissioner notes in his order, my lord, that repeated chances were given to him to fulfill the project. SDRRP was a huge satellite ring road
Term of
project.
office of that 4C, the section rule 4 of the town planning rules.
But this is done because there is some lapse on your part.
Yes.
No, that for that, not that, I may not agree that the honorable tribunal, I place reliance upon judgment of this honorable, a coordinate bench of this honorable court, not that.
Yenanta? I'll put it, please. Put it. What it says, coordinate bench.
The transfer is the page number. Page number 30 of that internal page 30. Your question has been articulated. Where an officer can be transferred because certain complaints have been received against him. 7.2. In our consideration, that would be a dereliction of duty on the part of the government. If according to the government, serious complaints have been received, it is for the government to take necessary action as regards the said complaint against respondent number 4 as per the applicable cadre and recruitment rules. In the number, even otherwise, he is the competent authority.
What do you say?
Whether the
Based on allegations, we have acted upon.
Kindly come to paragraph 11.3 of the division bench.
They have not provided money.
Put it. 11.3 over 2 and 3 over. Then in every case you will say a retention period kinta transfer madilla allegations ittu hange transfer madivi. You can defeat the guidelines.
And it was documented over a long period of
identical
time.
issue not that idea. Honorable Supreme Court reported in 2009 to SEC.
Lord, this lapses in duty. This lapses in duty was documented over the period of his service in FDRRA. R1 was a show cause notice. R3 was another show cause notice issued on the lapses.
Correct. But where is the proceeding? Wherever you want to transfer, if we agree your contention, then security of tenure at a particular place will be diluted. ನಮ್ಗೆ ಯಾರ್ಯಾರು ಬೇಡ ಆಗ್ತದೆ ಅವ್ರ ಮೇಲೆ ಅಲಿಗೇಷನ್ ಮಾಡೋದು ಈಗ ನೋಡಿ ಹಿಂಗ್ ಹೇಳ್ತಾ ಇದಾರೆ ನಿನ್ ಬಗ್ಗೆ ಏನ್ ಹೇಳ್ತೀಯ ಅಂತಾರೆ ಇಲ್ಲ ಹಂಗ್ ಮಾಡಿಲ್ಲ ಅಂತ
Yes, ಇಲ್ಲಿ persistent lapses ಇತ್ತು ಬ್ರಾಡ್.
Correct. Kindly see Mr. D. 11.3. In the present case, both the government advocate counsel for it contend that because of serious allegations against respondent number 4 was transferred and in his place petitioner has been posted. Another contention which has been raised by the government advocate is that if an inquiry were to be ordered in the place where respondent 4 is working, since respondent 4 is the head of the said office, inquiry cannot be conducted independent properly. Under the transfer guidelines, there is no particular protection which has been provided to transfer the person because a complaint has been received against him. If a complaint is received, then it is for the concerned authority to take necessary action as per the applicable rules. The government cannot transfer a person on the basis of complaint received without taking action on the said complaint. in as much as if the complaint is
But
frivolous.
here one
then the
distinction,
complaint-
Lord, is it is
Yes.
not a complaint that we received.
Huh?
This commissioner personally had issued certain directions to complete the SDRR project. It was a public project, Lord. He was supposed to
Therefore, he
complete
should
it
take
within a
action
deadline.
against him.
He repeatedly did not execute anything in those lines, which delayed the implementation of the project, which was a public project. Therefore, Lord, he records in his order. Can you kindly see an action R1 notice, Lord?
Are
R1
you, have
and
you,
R3
who is the competent authority hold the inquiry against him? Government.
Government.
Government is the appointing authority. But commissioner can feed the government. ಈ ರೀತಿ ಮಾಡ್ತಾ ಇದ್ದಾನೆ ಇವನು.
Supervisory authority is the commissioner, my lord.
Supervisory does not
Authority.
include discipline.
ಇಲಾಖೆಯಿಂದ ನಿಯೋಜಿತರಾದ ಬಿ ಮತ್ತು ಸಿ ವೃಂದದ ಸಿಬ್ಬಂದಿಯವರಿಗೆ ಯೋಜನಾ ವಿಭಾಗ
I'm not a
I-
officer.
1 second.
I'm a group officer.
Supervise, he is not good, the number one.
Yes.
Secondly, power to supervise does not include disciplinary action ಅಂತ hold ಮಾಡಿದ್ರು. ಮರಾಠವಾಡ. ಅಲ್ಲಿ. And he is not in that cadre at all.
Yes.
Now, what is your reaction? You should have asked why he should be, you have transferred ಅಂತ ಅವ್ನಿಗೆ ಕೇಳ್ಬೇಕಿತ್ತು.
R1 and R3 notice, Lord, issued to him.
Correct.
issued
But
to us
who
notice.
issued the notice? You are not the disciplinary authority. Disciplinary
Yes, one-
authority is the
one-
government.
Ondaಗುತ್ತೆ, Lord, in public projects, highway projects, if one officer is delaying it and there is continuous lapse and it is documented,
You should
then the
write to the
commissioner-
government. You should write to the government that he is doing like this. All mischiefs are happening here. The things are
and
not.
we have got, yes, we have got stuck with this officer and project is not moving. That was our difficulty. In the meantime, Lord, after we relieved him, actually, we did not transfer him, Lord. We said his services in SDRRA
You
is
can't
not
relieve.
required.
You can't relieve because that amounts to arrogating to your zealous the power of the appointing authority.
Yes,
It is
Lord,
the
if the
appointing
commissioner has-
authority. Government is the appointing authority. Government said, you are there as the planning authority, na member antadama. So
Yes.
during that period, suppose if you want to take action against that person because he has committed some delinquency, then you have to
Yes.
hold inquiry, then you can do. Otherwise, the guarantee of tenure at a particular place will be diluted by the government. No, ಸರಿಯಾಗಿ ಕೆಲಸ ಮಾಡ್ತಿರ್ಲಿಲ್ಲ, ಹಂಗಾಗಿ ನಾವು ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿ. That will have a dangerous consequence. That will dilute.
ಇವಾಗ
That
ಏನಾಗಿದೆ-
will be
ಇವಾಗ
death knell of
ಏನಾಗಿದೆ?
the transfer guidelines.
Yes, ಈಗ ಏನಾಗಿದೆ, subsequently government has accepted this
Complaint
order.
also, Lord, sorry,
also
complaint is
transferred it.
also on the one, 3 complaints on the same day.
ಇರ್ಬೋದು, ಅದು ನಿಜ ಇದ್ರೆ ಏನ್ ಮಾಡೋಣ?
That has been fully.
And government actually accepted this, whatever order that I had passed, and immediately put him into a different department.
Whether
That shows
government
not-
government gave him a showcause notice and came to a conclusion that you have done all this, therefore we are transferring you. We are acting on the recommendation of the commissioner. Government cannot do all that. Tomorrow, nobody will be safe. Object of transfer guidelines is that the officers will not be at the mercy of the government. Already officers are at the mercy of the government nowadays. Executive is almost spineless because he will be transferred, he will be troubled because these things happen. We need the legislature, executive and the judiciary, 3 important wings of the governance in any standard state. These are the 3 essential wings. If executive is spineless, then how are you going to? They will obey everything because of this threat.
There'd be one area, Lord, where there could be a solution. Commissioner usually under these local body enactments is given the power to overall take a decision on the supervisory role.
Not
and
this
so far as
cadre,
employee-
not this cadre,
so
you're
far as
right.
employee.
Not this cadre. Other than lesser cadre he has been given, that's rightly given to him. He has no supervisory power against the candidate of this cadre.
Yes. Now, let's suppose he exercises the power of relieving him, not transferring him. He has just told him that this services in
He
this
could not have
institution-
relieved. When government has, when king has posted, the king's servant cannot tell to the co-employee, you go home, to put it in service jurisprudence of UK. King is the appointee. King will send him if he wants it. A lesser body, that will be contempt of the palace. You cannot do that. But petitions allowed reasons to follow. Kalsi.
R2 may be put in this, or your lordship may kindly, R2 may be put in liberty to take action for his dereliction, this order.
What is your power? It is for the government to take action. Government is appointing, not you. You are another servant along with him. You have no such power. Hello.
Sir.
The other two petition, the other petition also I challenge the other. petition.
Correct.
Great.
Third, small submission. I could not move the matter in the morning.
Yes.
Therefore, when matter is urgent, the petitioner is an employee. Sought for regularization. She has been removed from the service therefore.
When she was removed?
Mentioned.
Last year it's.
Last year.
Actually, I had filed an application for direction to the.
Next week,
respective
next week.
Please.
With your lordship kindly, serial number 31 would be taken up on next Monday. And
31. ಯಾವ್ದು 31?
The departmental inquiry.
ಹಾ. ಯಾವ year?
Short matter, my lord, 2023 matter.
23. ಅಲ್ಲಿ week after next ಹಾಕೊಳ್ಳಿ.
Interim order, my lord, in fact, there was an interim order before the KAT.
You had interim order?
ಇದೆ. There was an interim order before the KAT. Now the government is going to implement the penalty order. Hence, my lord, interim, not to implement the penalty.
I will record that you said like this.
ಹೌದು, ಇದೆ.
Learned counsel for the petitioner submits that he had advantage of the interim order at the hands of the tribunal, and therefore that protection needs to be extended. First, unilaterally acting on such a submission, we extend the protection. First, should assertion be proved to be wrong, heavy costs would be levied on the petitioner after dismissing his petition.
Please, okay, next month.
But I call this matter in the first week of June. Interim order ಬೇಕು. ಮತ್ತು ಈಗಲೇ ಹೇರಿಂಗ್ ತಗೋಬೇಕು, ಹೆಂಗ್ ಸಾಧ್ಯ?
The short matter.
ಇವತ್ತು ತಾಲೀಕಿಲ್ಲ ನೋಡೋಣ ನೋಡ್ಕೊಂಡು ಹೇಳ್ತೀನಿ.
Madam.
Sir. Sir, court officer, sir. Sir, court officer, sir. 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 Court officer, sir. Sir, court officer, sir. Sir, court officer, sir. Sir, court officer, sir.
ಸರ್ ಮನೆಗೆ ಹೋದ್ರು ಅವರು ಊಟ ಮಾಡ್ಕೊಂಡ್ ಬರ್ತಾರೆ.
ಹೌದಾ ಸರ್, ಇದು ನಮ್ದು ಒಂದು WP 12602 ಯಾವತ್ತು ಹಾಕಿದ್ರು ನೋಡ್ಬೇಕಾಗಿ ಸರ್.
ಯಾವುದು
ಮೆಮೊ
ಸೀರಿಯಲ್ ನಂಬರ್
ಬೆಳಗ್ಗೆ
ಹೇಳಿ, ಸೀರಿಯಲ್ ನಂಬರ್.
ಸರ್, ಸೀರಿಯಲ್ ನಂಬರ್ ಅಲ್ಲ, ಇದು ಫ್ರೆಶ್ ಮೆಮೊ ಕೊಟ್ಟಿದ್ದೆ ಒಂದು ಬಿ
ಮೆಮೊನ
ಗ್ರೂಪ್ಗೆ.
ನೀವು 2:25ಕ್ಕೆ ಇದು
ಹೌದಾ?
ಮಾಡಿ.
ಅಲ್ಲ, ಮೆಮೊ ಕೊಟ್ಟಿದ್ದೆ ತಗೊಂಡಿದ್ರು ಬೆಳಗ್ಗೆ ಸಬ್ಮಿಷನ್
ಹಾ,
ಮಾಡಿದಾಗ ಸಾಹೇಬ್ರು
ಹೋಗಿರುತ್ತೆ
ಬಂದಾಗ.
ಹೋಗಿರುತ್ತೆ. ಹಾ
12602 ಏನಾದ್ರು
ಹೋಗಿರುತ್ತೆ.
ಬರ್ಕೊಳ್ತೀರಾ ಬುಕ್ಕಲ್ಲಿ ಏನಾದ್ರು ನೋಡ್ತೀರಾ ಸರ್? 12602 ಆಫ್ 2020. ಇಲ್ವಾ ಸರ್? 20. Next matter Friday ಬರ್ತೀವಿ. ಮೆಮೊ ಕೊಡೋಣ, ಅದು ಮಾತ್ರ ಬರ್ತಿದ್ದೀನಿ.
Government appeal.
ಪುಷ್ಪ ಆಡಿಯೋ ಎಲ್ಲ ಆಡಿಯೋ
change
It would be unfair, that is.
that will be one of the points.
That would be.
Maybe in your favor also, I do not know.
I am not
But it will
saying.
be one of the.
If my lords have any reservation about it, I will just.
ಅಲ್ಲ ಹೇಳಿ ನಮ್ಗೇನಿಲ್ಲ ನಾವು ಮುಂದೆ ಹಾಕಲ್ಲ ಇದನ್ನ we have decided to go ahead and just argue, will not permit any adjournment. Yes.
Reply is filed by KPSC. The copies are not according to Lord.
ಓದಿ ಕೊಡ್ತಾರೆ ಕೂತ್ಕೊಂಡು ಓದಿ ಅವ್ರ ಮಾಡಿ ಆರ್ಗ್ಯುಮೆಂಟ್
But now rejoined ಹಾಕ್ಬೇಕಾಗುತ್ತೆ.
ಅಂತ ಹಾಕಿ ನೀವೇನಾರ ಮಾಡಿ
ಅಲ್ಲ.
You have said, do not waste time. You read that. We'll, Mr. Learned Senior
ಅಲ್ಲ,
Advocate.
last occasion, my lord.
Learned Senior
One
Advocate.
minute. Last occasion, my lord directed the KPSC and the government to file reply.
ಅವ್ರು ಮಾಡ್ತಾರೆ ಈಗ ನಿಮ್ ಕಾಪಿ ತೊಳಿ ಈಗ ನಾವೇನು ಈಗ ಮುಗಿಸ್ಬಿಡಲ್ಲ ಇದು ಇವತ್ತ ಮುಗಿಸಂಗ ಇದೆಯೇನೋ ಕೆಲಸ ಎಷ್ಟೆಷ್ಟು ತಲೆಗಳಿದಾವ ಅಂತ ಯಾರಿಗ್ ಗೊತ್ತು ಬಿಡಿ
ಗೊತ್ತಿಲ್ಲ. ನಾವು
ಕೂತ್ಕೊಳ್ಳಿ
ಯಾಕಂದ್ರೆ
ಕೊಡ್ರಿ ಅವರಿಗೆ ಒಂದು ಕಾಪಿ ಕೊಡಿ ಎರಡೆರಡು ಕಾಪಿ ಕೊಡ್ರಿ ಎಲ್ಲ ಓದ್ಲಿ ಕೂತ್ಕೊಳ್ಳಿ
ನಾವು ರಿಜಾಯಿಂಡ್ ಹಾಕ್ಬೇಕಾಗುತ್ತೆ
ನೋಡ್ಕೋಣ. ಜನರು ನಮ್ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನಲ್ ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್ಸ್ ಬಗ್ಗೆ ಎಲ್ಲ ಏನ್ ಮಾತಾಡ್ತಾರೆ ಅನ್ಕೊಂಡು ಸ್ವಲ್ಪ ಎಚ್ಚರ ಇಟ್ಕೊಳ್ಳುವಂತ ದಿವಸಗಳಿವು.
ಖಂಡಿತ.
ಎಲ್ಲಿ ತನಕ ತಡ್ಕೋತಾರ ಜನ, ಒಂದ್ ಹಂತದ ತನಕ ತಡ್ಕೋತಾರ, ಆಮೇಲೆ ಆಗಲ್ಲ ಅವ್ರಿಗೆ, ಕ್ರಾಂತಿ ಆಗ್ತದೆ ಅಷ್ಟೇ.
ರೆವಲ್ಯೂಷನ್ ಆಗುತ್ತೆ. ಐ ಅಗ್ರಿ.
ಆಯ್ತು. Please be seated.
My request is that.
Yes, Mr. Raju, start. Where is your reply statement? Padi. Yes. ನಾವು ಏನೆಲ್ಲ ಪಾಯಿಂಟ್ ಅನ್ನ ಹೇಳಿದ್ವಿ ಅದಕ್ಕೆ ರಿಪ್ಲೈ ಹಾಕ್ಬೇಕು ಮತ್ತು ಇದನ್ನೆಲ್ಲ ಆನ್ಲೈನ್ ನಲ್ಲಿ ನೋಡ್ಕೋಬೇಕು ಅಂತ ಆರ್ಡರ್ ಮಾಡೇವಿ ನಾವು. ಅದನ್ನೆಲ್ಲ ಬರೆಯೋ ಅಗತ್ಯ ಇಲ್ಲ ಅಂತ. ಅದೆಲ್ಲದನ್ನು ಮೀಟ್ ಮಾಡಿದ
ಎಲ್ಲ ಮೀಟ್ ಮಾಡಿದ್ವಿ ಎಕ್ಸೆಪ್ಟ್ para 3 onwards. This paragraph I have only said my lords because
let us read first paragraph.
Petitioners in WP 5.
ಇಲ್ಲದೆ ಓದ್ತಾ ಇದ್ರೆ ಕಷ್ಟ ಆಗುತ್ತೆ.
ನಾನು ನಿಮ್ಗೆ ಏನು ಅಡ್ವರ್ಸ್ ಮಾಡಲ್ಲ, ನಮ್ಗೆ ಹೇರ್ ಮಾಡಕ್ ಬಿಡ್ತೀರಾ ಇಲ್ಲ? ನಾವು ಸ್ಟಾರ್ಟ್ ಮಾಡ್ಲಿ. You can't halt the court that way.
No, I am
We are not passing any order against you.
But I am not halting. What I
You are
to read. Allow at least what is the reply?
Let us see. We'll give you time. You can't hold the court that way. All people will be seeing. Please do not do that. We are not passing any adverse order against you.
I am told it is mailed to them on.
ಯಾವತ್ತು ಕೊಟ್ಟಿದ್ರಿ ಅವರಿಗೆ?
Saturday ಹಾಕಿದ್ದಾರೆ.
Saturday. When it was given to you?
Saturday we have mailed ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
WhatsApp, my lord. WhatsApp copy is not legible, my lord. So that's why I am requesting to.
ಆಯ್ತು, ಇನ್ನೊಂದು ಕಾಪಿ ಕೊಡಿ ಅವರಿಗೆ, ಎರಡೆರಡು ಕಾಪಿ ಕೊಡಿ, ಎಲ್ಲರಿಗೂ ಎರಡೆರಡು ಕೊಡಿ. Yes. Start. Give copy. Don't stand like that. First serve copy. Yes.
Petitioners in WP number 5310 of 2025 approached the tribunal seeking quashing of letter 22 sent by the commission to the state government in rural development and Panchayat Raj department requesting the state government to withhold issuance of orders of appointment pursuant to final select list of candidates eligible for appointment dated.
Go to next page.
Next page. Next page. Second of the writ petition, rejecting the interim review sought by the petitioner is justified and no interference, that is on the main I have said. Second of the writ petitions and so is not even maintainable since the petitioner is admittedly not a party before the tribunal. Then para 3 onwards is on 3/9/2022 pursuant to an intent placed by the state government, the commission issued 2 separate but identical notifications inviting applications from eligible candidates for recruitment to 18 posts of AE grade 1 in the department of.
Go to next page.
Next months, the recruitment notification, the recruitment process consisted as mandated by Rule 5(1)A, a competitive examination followed by interview. The competitive consists of 2 papers, paper 1 being general and paper 2 being specific paper. The commission conducted written examination of 1/7/2023. On the basis of performance in the written examination, eligibility list in the ratio of 1:3 was published and personality test was conducted on 15/9/2023 and 16/9/2023. The commission, based on the percentage of marks secured by the candidates in the written exam personality, published the provisional select list of candidates eligible for appointment under 2 notifications on 22/9/2023. In response to the provisional select list inviting objections, certain objections were received by the commission. Final select list was published on 31/1/2024.
Yeah, at the time when the final selection list was published, a subcommittee of commission was inquiring into specific objection of one candidate who did not find his name in the provisional selection list, be alleging that the candidates at serial numbers 1, 2, 3, 4, 6, 7, 8, and 9 from RPC and candidates at serial number 1 from Hyderabad, Karnataka in the provisional list have scored various marks in various examinations conducted during 2022 and 23, but did not succeed in tampering OMR sheets. But however, they succeeded in tampering of OMR sheets in AE, RDO, ABLS, conducted by the Commission on 2nd July and requested to cross-check the OMR sheets and CCTV footages of respective examination centers and to take immediate action. After deliberation, Commission in its meeting held on 13/2/2024 decided to request the state government to withhold making of
Decided to request or requested?
There it was resolved to request.
Did you send that resolution to?
That requisition has been sent on 13/2/2024. The copy of these by the impugned letter dated 22/2/2024. Secretary of the Commission communicated the decision of the Commission to the state government and conveyed the request of the Commission not to make any appointment pursuant to selection list dated 31/1/2024.
One second, one second.
This is the one of the letters that is one of the prayers in the application before the tribunal is
Correct.
quashing of 22/2/2024.
Let us see annexure A9.
A9.
But that's what. A9 is addressed.
A9 is what is questioned in the tribunal. A9, my lord.
Is addressed by KPSC to whom?
Principal Secretary to the government in RD and PR, which is the administrative secretariat for the recruitment in question. Page
Bhagavat our petition dalla
102.
102.
102.
Compilation ಕೊಟ್ಟಿದ್ರಲ್ಲ ಜಾಕೋಬ್ ಪಡಿ. One.
It is faithfully communicated to the state government.
Report. Compilation ಮಾಡಿಕೊಟ್ಟಾರು. ಇದ್ರದ್ದು ಯಾವ ಡೇಟಿಗೆ 120?
126 to 127.
You're right.
Yeah, that is.
This is 22/2/2024 ಇದೆ.
Yes.
ಇವ್ರು ಹೇಳ್ತಾ ಇರೋದು January 31/1/24 ಅಂತ ಅನ್ಕೊಂಡು.
31/1/2024 is the date on which select list was published.
No dispute.
Page 86 of the red paper.
86 of this.
Red paper.
Yes, 86 of the red paper.
Yeah, we have that one. Yes.
Then, my lords,
Ah.
thereafter, coming back to my the it is respectfully submitted that the said communication being internal correspondence between the Commission and the state government, challenge to the said communication is not maintainable. That apart, the letter dated 22/2/2024 has spent itself in as much as petitioners have been appointed on 25/6/2024. Petitioners having accepted the terms of appointment and joint duties in pursuance to the very order dated 25/6/2024 cannot thereafter turn around and question one of the conditions of appointment. They cannot blow hot and cold. It is settled that he who accepts a benefit under an order must adopt the whole contents of that order, must conform to all its provisions and renounce all rights that are inconsistent with it. Having accepted the order to review and acquiesced therein, it is not open to the petitioners to question a part of it. The subcommittee appointed by the Commission directed the Secretary of the Commission to secure expert opinion by scientific examination of CCTV footages, original OMR, carbon copies of OMR candidates about whose selection suspicion was entertained. It is necessary to submit that a subcommittee had called upon such candidates to furnish carbon copies of their OMR. That endorsement seeking that copies of the OMR has been produced by the petitioners themselves. Correct. While most of the candidates submitted carbon copies of their OMR, 4 of the candidates, namely the petitioner number 5, 6, and 7 in writ petition number 5562 and in writ petition 53, did not submit carbon copies of their OMR. Pursuant to the direction of the subcommittee, Secretary of the Commission wrote to the state government seeking permission to refer OMR sheets and CCTV clippings for expert bar FSL report. State government by its letter dated 27/5/2024 granted permission. The matter was referred to FSL. On receipt of the report dated 9/10/2024, the subcommittee continued and found certain wrongdoing prima facie on the basis of materials before it. Notices were issued to the concerned candidates to appear before the subcommittee. All the petitioners in the above noted writ petitions appeared before the subcommittee and submitted their say on 17/1/2025. After considering all the minutes, subcommittee submitted its report on dated 23/1/2025. The commission in its meeting held on 30th January 2025, having examined the report of the subcommittee, unanimously resolved as under. Commission resolved to receive the investigation report of the subcommittee. It was resolved to take action on the following first 5 aspects of the recommendation. Commission shall forthwith cancel the selection of tainted candidates as shown in para number 26 of the 66 of the report. Commission shall authorize Secretary to forthwith initiate criminal action against the tainted candidates by lodging complaint to the police. The Commission to request the government to order investigation through CID to unravel the truth. The Secretary to assist the police CID in investigation for taking appropriate action against tainted candidates and all those persons who are responsible for the malpractice. The Commission shall recommend to the government to issue posting orders in favor of non-tainted candidates immediately. Then, more the list of tainted candidates is there. To instruct the head legal cell. Order sheet. Legal cell. To lodge caveat petitions before the Bangalore, Dharwad, and Kalburgi benches of the High Court of Karnataka and Bangalore and Belgavi benches of the tribunal. To examine incorporating recommendations 6 to 12 in future examinations. A copy of the proceedings of the Commission taken in its meeting held on 30th January 2025 is annexed here to and marked as Annexure R2. The Commission forwarded the report of the subcommittee to the state government by its letter dated 2/2/2025. A copy of the letter dated 2nd February 2025 is annexed here to and marked as Annexure R3. It is responsible the power to entrust invasion vests only with the government. Therefore, a request was made to the state to take further action on the investigation report of the subcommittee of the Commission and decision of the Commission taken in its meeting held on 30th January 2025. When the Commission was examined the report with a proper complaint before the jurisdictional police, 9 of the candidates against whom action was recommended by the subcommittee approached the tribunal on 10/2/2025. Tribunal directed the standing counsel to take notice on 11/2. Interim relief was rejected by the tribunal by order dated 18/2/2025. Writ petition number 5310 was preferred before this court on 19/2/2025. Interim order directing respondents not to precipitate the matter was granted by this honorable court on 15/2/2025. Petitioners have already appointed subject to outcome of the investigation by the Commission that was in progress. State government in the Department of Personal Administration Reforms has by its letter dated so-and-so dated 21/3, copy annexed to Annexure R4, communicated its acceptance of the recommendations of the Commission. The Commission assures this honorable court that expeditious action will be taken in pursuant to the resolution dated 30th January 2025 by making complaint to the jurisdictional police and requesting the government to issue a formal order of transferring the investigation to CID. Commission is also in consulting the state government take steps to have the inquiry in terms of Rule 20 of the General Recruitment Rules read with specific condition in the recruitment notification referred to supra. That inquiry is required to be initiated by the state government since the petitioners are already appointed. Grounds raised in support of the writ are not tenable. No prejudice has been caused to the petitioners on refusal of the. And no, my lord, state government's letter also, my lords, may kindly have a look at Annexure R4 at page, because this is one development that has taken place after the last.
You have not whispered anything about our proposal as to why CBI should not be, services CBI should not be engaged.
So we are bound by whatever the court would say.
No, we asked you to say about that.
About that, my lords, One thing is this, Manoj. Earlier investigations have been carried out by the CID and are based on
ಸ್ವಲ್ಪ
that.
ಜೋರಾಗಿ ಹೇಳಿ ಎಲ್ಲರಿಗೂ ಕೇಳಂಗೆ. Mic ಅನ್ನು
Earlier
ಹತ್ತಿರ
investigations have been carried out by the CID. On that
CID.
basis, yes, Manoj. Even 1998 Gazette probationers, Manoj. That is one
What
of the.
happened?
No, the chairman is facing trial, chairman of the commission. And several officers also are facing trial.
Since
And-
how long?
Manoj, that is, my lord.
I'm asking you.
That was because, my lords, I am told, there was some stay of the proceedings and all that was there. I am not. But, my lords.
So, but you have not whispered anything about
why
our proposal about entrusting it to
My
CBI?
lords,
Because there is not even word CBI anywhere in your pleadings.
I would make my submissions, my lords, on that. My lords, normally, my lords, unless there are any circumstances to say that state police would be unequal to the task.
So that is not your stand. Anta.
That is
That is
because.
not your stand at all.
That is meanwhile, the state government's letter also came, which I have annexed. Therefore, I wanted to read it, my lords. There they said that we are in concurrence with the CBI, with the commission to entrust the matter to CID investigation. And once the court, the proceedings are clear or the stay is vacated, we will take action to entrust the inquiry to the CID.
We are again asking you, have you said one word about CBI in your statement of objection?
I have not said, now I am saying, my lord, that I am in concurrence with what is stated by the state government in its letter dated 21st March.
We specifically put a question to learned senior advocate representing the KPSC as to whether it has stated even one single word about the proposal to entrust the matter to CBI by this court, if at all it so decides. Semicolon, come on. Learned senior advocate in all fairness says, in the whole of the pleadings, the word CBI does not appear. And there is no whisper about the idea of entrusting the matter to CBI. All right.
My reference submission is this one. The state has concurred with the recommendation of the CBI.
However, he
Of the commission, which was made before my lord's order.
Since the state government is in principle in agreement with the entrusting the matter to CID, comma, nothing is mentioned about the CBI inquiry proposal. Okay.
That's all I would like.
Now we are putting a few questions to you. You have to assist us.
Yes.
Ordinarily, law and order is a state subject. Therefore, state agency should be believed, matter should be entrusted is the normative procedure. On that, we will not differ perhaps. So do you agree?
I agree with
I
that
agree.
proposal.
But there are extraordinary cases where CBI investigation has been entrusted by the high courts in relation to scams in recruitment itself of the kind. And there are at least 3 judgments of the apex court, 3 judgments of the high court, the last 3 years. Last 3 years. There will be many. In the light of that, do you dispute power of the High Court to entrust the CBI investigation? Anyway, we are not saying whether court should do it or not is another thing. Now we are asking a pure question of law. Learned advocate general here, we'll come to him. Here is question to you also. To you also. Do you dispute power of the Constitutional Court to entrust the CBI matter to CBI investigation as to the existence of power?
I cannot dare doubt the power of the Constitutional Court.
You are very fair.
And
Next question.
I'll
by one
continue,
we
my
go,
lords.
because we
This
have a
court
format.
has all the power to do what is required to be done to ensure ends of justice are met.
To our specific question, comma, learned senior advocate appearing for the KPSC in all fairness submits constitutional courts do have enormous power to do what is eminently required to be done in matters like this. And that power would include the power to entrust investigation to CBI. First, now we are putting certain things to you, since it's a very serious matter. Ordinarily, there is a pattern available. Before we direct investigation by CBI, we have to go in a methodic way. Therefore, we are putting it to you now. Letter is, you have, since you were not here, we are only reminding you, will be knowing these things. Again, we are repeating. 3-member committee was formed. Then 5-member committee became very active in the matter. The resolution was sent to the principal secretary and to the chief secretary of the state, saying we have passed such a resolution, matter is being looked into. Therefore, do not act upon the selection list at all. And selection list is no selection list because KPSC has not approved it. There are such sentences. I'll take you through that. So that
That is
are you aware of that?
1st February letter of the
Yes.
chair. Yes.
You are right. So if chief secretary, principal secretary, do not care about your client's letter, do not make appointment. Many things have happened. We have not approved the selection list at all because quorum was lacking. It is said in so many words. Still, nothing has been done in the matter. Can state police investigate into the affairs where CBI can better do that job? Because chief secretary is involved in this case, in the sense he has taken no action on the basis of what was informed to him. Chief secretary, how any police officer will be in a position to counter the chief secretary?
The question is this, my lords. There is no, because there is no doubt that letter was written to the chief secretary and chief secretary has not acted on that. With the expediency, one would expect him to do.
When it was given, letter was sent.
Letter is sent on 1st February 2025. There is no, sir.
1st February 2025.
Yes.
And appointment orders were issued. Even the ink of this letter
That
had
letter
dried up.
was sent on 1st February. This is 1st February 2024.
24.
Yes.
And appointment orders were issued when?
On 25th June 2024.
Why?
With the condition
No, that they can answer, not you can't answer. You have done your job. Appreciate it.
This is for them to-
Learned AG has to answer this.
Grateful manners. At least I have no respects for some time.
All right.
The issue is with regard to what happened in KPSC. The question of whether assuming it's an order, it's not a case for CBI inquiry, assuming what fell from your lordship, there's a decision taken. There's nothing for the CBI to inquire into it. It may be at best error of decision.
How?
Assuming,
Let us read the letter of the
no,
KPSC now.
assuming for a moment, I'll just go by what fell from my lord. Saying there's a communication from KPSC that something has happened in their house. So therefore, investigation by the CID would be what happened in their house. And the second issue would be, where we'll inquire into why appointment order was done and condition was imposed. It is not that we have made appointment without any condition. The communication was, and when the communication came from KPSC, FSL report has to be done, verification. I said, you go ahead with that investigation.
Where is your statement of?
It's just coming, 2 minutes, just almost being sworn in.
Can you read for a moment the letter of the KPSC, what he told the Chief Secretary?
To hold on to the.
Let us see that. Let us read again.
Manoj, cases, Manoj, where CBI is referred to, Manoj, your lordships are fully aware, Manoj. This is not a case where it's an extraordinary case, exceptional case, which requires any investigation even for that moment, Manoj. So what is that? It's a case of decision which has been taken, right or wrong, which your lordships will do under judicial review. Assuming that decision is wrong or right, your lordship will pass a judgment on the decision. Manoj, there is no investigation of a criminal investigation that may be required. Manoj. Even at the hands of what is given to the CAD is what happened in the KPSC.
No. That happened at your hands also.
No, Manoj. Your lordship may kindly see, we are
not only KPSC, because KPSC passed a resolution saying we have not approved the selection list at all. Therefore, don't operate it.
correct, Manoj. That is a wrong at burst in judicial review, Manoj. Your lordship will say the order is bad. You could not have import condition number 8 or 12 in the appointment order saying subject to the outcome. It could not have been done.
Yes. Learned Advocate General submits that the issue before this court is as to whether what has been done is right or wrong, and that in the conventional limitations of judicial review, the question of entrusting the matter to the CBI investigation would not arise.
Please. The issue was, Manoj, during the KPSC examination, Manoj, there was tampering of OMR sheet. The question is where this tampering took place, at the examination hall, in the transit, or in the KPSC itself. Manoj. Therefore, Manoj, the issue is that the only what falls out, Manoj, is pursuant to the communication dated 1st February, which to the government, and subsequently on 22nd February, Manoj, is whether in spite of that decision, whether appointment could have been made imposing conditions subject to the outcome of.
He adds that after the government received the communication from the CBI,
Not CBI,
KPSC, whether appointment order should be issued or not is the only question which court can examine and nothing beyond.
By imposing a condition in the appointment order.
In as much as the appointment order at condition 4 has stipulated that such appointment should be subject to outcome of the pending inquiry.
Therefore, my lords, what we are proposing is, my lords, conducting the recommendation, we have accepted the recommendation of the KPSC insofar as condition number 3 is concerned, my lords, referring the matter to CAD. Investigation, we have no objection. That is what they wanted. We have accepted the condition number 3. Condition number 2 also says, my lords, don't make appointment orders to those 10 people, my lords, who are petitioners before your lordship. We are ready to accept that also.
No, they said don't issue appointment orders to these people.
So, that is why, Manoj, what the reason, there are 2-3 reasons in why we had to go ahead, Manoj, that may be justifiable or may not be acceptable, Manoj. I'll just try and put across why we had to make an appointment, with the objections, Manoj. Your lordship. I'm sorry for the delay, Manoj.
No, it's all right. No issue. Anyway, ಇದರಲ್ಲಿ ಬಹಳ ಹೇಸ್ಟ್ ಮಾಡಲ್ಲ ನಾವು, ಯಾಕಂದ್ರೆ ಸರಿಯಾಗಿ ಬಿಗಿಯಾಗಿ ಆದೇಶ ಬರೀಬೇಕಾಗ್ತದೆ.
ಅಲ್ಲ ಇದರಲ್ಲಿ
ಹೇಸ್ಟ್ ಮಾಡೋ ಪ್ರಶ್ನೆ ಇಲ್ಲ ನಮ್ಮಲ್ಲಿ.
Manoj, this case ಬಿಗಿಯಾಗಿ ಏನು ಮಾಡ್ಬೇಕಂತ ಆಗಿಲ್ಲ. This not, your lordship may kindly see, Manoj, is this not one with most humble, with greatest humility at my command, Manoj. Your lordship may kindly appreciate, Manoj, what has been done here. At best, Manoj, a decision has been taken in order to save time, Manoj, to see that, I'll just read that letter, to see that, Manoj, the appointment of assistant executive engineer is not delayed. In the event it comes, there's nothing found, Manoj. And if it is found, they'll be removed. And Manoj, your lordship may kindly, salaries are not paid, only training is done. I'll just point out why it was done, my lord. I'll be able to convince your lordships, my
Yes.
lord, then your lordships may not,
Before that, I will go to that level. What action you had taken against the secretary? You
in
had
fact-
drafted the notice, kept in the file was your submission.
Yes, my lord, stated that
So then what happened?
nothing has happened, my lord. My lord, there are two aspects, my lord, of it.
Once, we'll just write down whatever interaction takes place.
ಇಲ್ಲ,
I'm
easy
writing
ಆಗತ್ತೆ.
down.
No, it's already stated, my lord, in the petition.
That we'll write down so that let people know.
Please, please.
Margaret. On the previous occasion, it was specifically pointed out to the learned Advocate General to make a statement as to what action was taken against the then secretary who was allegedly transferred to some other place. Samuel. He had in all fairness submitted, and it is available on online record of this court, that the show cause notice, draft of show cause notice was available in the file.
Only draft is,
That's what.
please.
And now he repeats only draft show cause notice. First, now we are asking you, what happened to the draft?
It's only in the draft stage, my lord.
When asked,
So the reason is this, my lord, very next day she went on leave. Once she came back from leave.
when
yes,
she came back,
I'll just give the dates to your lordships, my lords. She went on leave on 17th.
no precipitatory action was taken pursuant to the said draft notice, in as much as the said official, said IAS official, went on leave with effect from
With effect. She went on leave from, my lord, 7th February, my lord.
7 February 2025,
24, my lord.
24, and reverted to duty.
No, my lord, she was transferred on 4th March, my lord. She never came back to duty, my lord. Once she was went on leave. Immediately after that, she was transferred.
On leave only. Throughout.
After that, transferred on 4th March 2024, my lord.
And she was transferred to
I'll have to find out, my lord. She was transferred, my lord.
ಹಿಂದಿದಾರ್ ಕೇಳಿ ನಿಮ್ಮ ಆಫೀಸರ್ ಇದಾರೆ ನೋಡಿ.
ಈ ಪೆದಗುಡಿ ಆಫೀಸರ್ ಜಿಲ್ಲಾ ಪಂಚಾಯತ್ ಬೆಂಗಳೂರು ರೋಡ್
CEO Jilla Panchayat Bangalore on 25/3
4/3, my lord.
4/3
2024, my lord. Executive Director, Karnataka Residential Education Institutions Society, Bangalore.
ಎಂತದ ಒಂದು
Transfer orders here, my lord.
Good. Is it part of this annex? No, it's not.
No, because your lordship. My lord, one apart from this, my lord, what your lordships are saying, action, that is one aspect. We just wanted to know because there are certain things stated against her, my lord. I'm given to understand, my lord, she's one of the, it has nothing to do with the action per se, what we are going to do. Or previous actions in discharge of duty in a career, my lord, supposed to be an upright, honest officer.
We don't.
That's why I just wanted to point.
You said also, we do not know what is her version because she is not before us.
That is why, my lord, I want to.
And we told them not to utter her name also.
That's why, my lord.
There is, apparently, you have framed the draft notice.
No, that's the difference. I'm on that, my lord. So what I just wanted to convey, my lord, saying that sometimes, my lords, some mistakes do happen for which the whole thing should, the career of an individual who's especially upright officer diligently, my lords, who has done her career through this, all this time. So therefore, that is one aspect, as your lordship said, both are different compartment. This is one aspect that is entirely different, which has nothing, what your lordship. I just wanted to bring it to your lordship's kind notice, my lord, that, it's not.
Can you substantiate that she is not at fault by taking?
I'm not saying that. I'm not saying that, my lords. My lords, I'm not. I'll just see. There are two things, my lords, in this. I'm not on the basis of the resolution of 31st, trying to justify the resolution dated 31st January 2024, my lords. Because that's, as the secretary of KPSC, your lordship, what was pointed out, my lord, the resolution has been passed because we are not aware of what actually transpired because the resolution is not forthcoming to us, my lord. From the records, what was saying, quorum was not there. In spite of that, it was added, is what follows from the records, what through the submission, what has been made. I'm not on that, my lord. Independent of that, my lord, what show cause notice had to be issued, report has to be taken, we will do that, my lord. We are not shying away from that aspect
No,
also.
why no action is, you have kept the show cause notice ready.
Because she was the reason she went on leave, then she was transferred, my lord. Then they did.
Transferred means to Delhi, here only, your department.
Bangalore.
Ah.
That is a transfer order.
Why show cause notice?
It should have been taken to its
That you have to
logical.
answer. That's one of the points in decision making of this kind.
No, my lord. I would put it this way, my lord. In a functioning, assuming this, my lord, there are two things, my lord. Inquiry has to be conducted, notice has to be given, reply has to be obtained. No way, no two ways about it, my lord. The question is, what will CBI do in such a matter?
No, to decide.
The question is.
Why? We do not know.
My lord,
In every case, it will be like that.
No, man. With great humility, my lord, my respectful submission for your kind consideration. Yes, there's an error of judgment, my lord. At best, my lord.
One second. What was the agenda in the meeting?
No, that is in the KPSC level. I'm talking.
That's what, therefore we wanted to know you, what action you have taken, because you have questioned her. You mean to say KPSC cannot take any action against her? Government also cannot take.
No, I'm not that on.
They are only asking you, what was the agenda she mentioned for the meeting? And what was the matter discussed and decided?
Correct.
So even such matters do not merit CBI investigation. Agendadalli, approval of selection list, draft selection list. Everybody would have participated. Aliruvanthaddu yavudittu, what was the agenda? Kindly tell us what was the agenda.
Different agenda. That is, as last time made available.
That virtually amounts to jettisoning the KPSC institution, which is a constitutional body. What was the agenda, Prakash? What was the agenda? Which is that page?
Last time put a note.
Whole KPSC can be jettisoned by this.
If Shokas was put it, then she would have replied.
Correct, Manoj.
That is the notice of the KPC that what has transferred and what
Correct, Manoj.
made her to write a letter to accept the list.
Correct, Manoj. If your lordship, we will do that expeditiously, Manoj. There is some delay on our part to do that. Immediate actions will be taken on that, Manoj. And your lordship may monitor it, Manoj. Your lordship may kindly.
Monitor, new investigation.
There's no investigation required. That's what my
inquiry.
Your lordship will conduct an inquiry. We'll place it before your lordships, Manoj.
No, what?
Then your lordships may decide what. I'm sorry, your lordships were saying something.
No, Mr. AG. Here is an officer who prepares the agenda. Will not name her now. This appears to be clandestine. We are using a very mild English word. This appears to be clandestine instrument.
Can I do this, my lord?
No, not you.
Not, I mean, can I place one thing? Your lordship may kindly permit us to give notice to her. We'll call.
We should permit it.
No,
you are the employer.
No, the matter is pending. I should have done it when the matter is pending. My lord, I should take leave of your lordship.
No, when we have halted.
You're not.
In fact,
I stand corrected. My lord. I'm sorry.
We have never come.
I stand corrected, my lord. I'll put, your lordship, I'll give a 3 days of own notice. I'll take a reply for it. In detail, I'll place it before your lordships, my lord. We'll conduct a thing, my lord. Your lordship may kindly grant us sufficient time, my lord. Then your lordship may take.
This, but one thing we tell you.
Please.
Keep these state public service commissions or constitutional bodies.
Correct.
How they are, that very idea belongs to Baba Sahib Ambedkar. He said, a high-level commission, a body which would undertake examination of the selectees, etc., that should independently work.
Correct.
That was the object.
That was the whole object, man.
Here is an officer who jettisons the working of the very body itself. She does not mention anything in the agenda. Agenda notice nalli illela. Avrella, they are under the impression XYZ transactions are going to happen. We can very safely be at home, and they were at home. Had you said we wanted to take up matter pertaining to approval of this election list,
all the members would have
All
been.
the members would have gathered because they knew what has happened.
As your lordship pointed, only she'll be the best person. If you had issued show cause notice, the answer would have come. About that what fell from you.
And that the way that all these days, nothing has been done. The file is not open. Many morrows have come and gone. Not even open. ಇದನ್ನೇ ಒಬ್ಬ FDC, SDC ಇದ್ದಿದ್ರೆ ಹೆಂಗ್ ಮಾಡ್ತಿದ್ರಿ ನೀವು? ಅವನನ್ನ ಮನೆಗೆ ಕಳಿಸಿಬಿಡ್ತಿದ್ರಿ.
ಅಲ್ಲ, ನಾವು inquiry ಮಾಡಿ will place the report before your lordships. Kindly grant some time, we'll do it and place it before your lordship. Kindly give us some reasonable period of time, we'll.
And now we have already certified that she is an honest official and other things.
I didn't, that's why I distinguished, my lord.
Now
She may be.
Again, we have fear now. We do not know. At least you could have said, she may have some defenses which you have been making.
My lord,
this
that. Strong decision also, therefore let us not.
No, but
your lordship,
asserted.
no, my lord, that
We'll
your lordship
replay
may
that.
kindly see. Your lordship may-
Asserted that she is an honest officer.
I said from verifying, my lord, I can't give certificate to what they do behind, my lord. What I've inquired, my lord. That apart, my lord, what I'm respectfully submitting is, as your lord, what fell from my lord, my lord, if we had given a notice, if she had given a reply, the truth, it would be.
Do you have a copy of the notice with you?
Yes, the file is on that.
Buddy? Well, good. Let us see how it is drafted.
It was
So that we will know the seriousness of the government draftsman. We will know at least how serious. So if we see the draft, the draft will also say how serious you were when you, the idea lurked in your mind. ಆ ಫೈಲ್ ಅನ್ನು ಇಡಿ ಅಂತ ಹೇಳಿದ್ವಿ ನಾವು ಲಾಸ್ಟ್ ಟೈಮ್.
We'll try and get the file in some time.
Read it through WhatsApp then? If it is
Get copy of that WhatsApp. We'll believe your WhatsApp also.
Please, we'll get it right. We'll get it right. Your lordship may kindly see this. The question, as your lordship said, my lord, the question why, what the agenda was done, why should only she'll be in a position to explain? Because.
ಅಜೆಂಡಾಕ್ಕೆ ಸಂಬಂಧಪಡೋದಾಯ್ತು.
Correct.
We'll come to that point. Why chief secretary did not fully advert to this? There is a FSL report. Forensic laboratory in the report ಬಂದಿದೆ ಟ್ಯಾಂಪರ್ ಆಗಿದೆ ಅಂತ. ಅದರ ಬಗ್ಗೆ ಮೆನ್ಷನ್ ಆಗಿದೆ ನಿಮ್ ಮುಂದೆ.
In fact,
the letter addressed to you.
Please, my lord.
It was mentioned.
Correct. In fact, we have given a positive go ahead immediately within 2 days, my lord. Your lordship may kindly see, we have replied to the letter. They said they wanted our consent. We said, please go ahead. Within 2 days, we have replied. We told her, we didn't say, don't do it, ma.
You have consented to send it.
Immediately, we have done it. Immediately, ma. My lord, ಅಲ್ಲ ಅದು ಅವ್ರು ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
Really understood. We appreciate that. Wherever you have done good things, we have appreciated the government.
No, that is.
We have appreciated the government. Wherever government has done good
No
things
doubt.
for a change, we have always appreciated. But wherever government gives an impression to us,
I'll dispel that impression. I'm sure that I'll be able to dispel that.
who is this officer? Can she take the KPSC for ransack?
I have no justification.
Things of herself. This is too much. KPSC is a constitutional body. This officer is a servant, civil servant. Why is that she did not lodge the complaint? She will not say much, but it's a clandestinely drafted agenda to exclude important decision and take a decision in absentia. Who is this officer? And we do not know. We will not say she has done everything to ensure that no notice is issued. We will not say that.
No,
we will not say that. But
no, that draft notice.
Other day you said that the entire file will be made available to us.
Just coming. The file was because of the objection drafting is put up to the government. We are getting back the file. In fact, the reason is this, my lord.
Should only ensure now, you should assure us that draft itself does not undergo change after saying our age. That assurance you have to give us.
Improved also. Improved also. Draft is a draft, but taking.
In fact, Jawaharlal Nehru, in his autobiography, said, and he told it to Einstein also in his meeting. It is Einstein who wrote the blurb, the back page write-up is by Einstein on his discovery of India. He told Einstein, and he has written in his autobiography, Indian civil service is neither Indian nor service. ICS ಬಗ್ಗೆ ಹೇಳಿದ್ರು ಅವರು. So he wanted to see that there should be some change in the attitude of the ICS or IAS officers.
My lord, the only reason.
Otherwise service ಆಗುದಿಲ್ಲ. ನಮ್ದು ಏನು ಕನ್ಸರ್ನ್ ನಮ್ಗೆ ಏನಿದೆ? ಏನ್ ನಾವೇನು KPSC ಹೋಗಿ ಎಕ್ಸಾಮ್ ಬರೆಯೋದಿದೆಯಾ?
My lord, I'm not, I bow down to what fell from your lordship with regard to what, the only reason why a conditional appointment was given, my lord, just page 5, my lord, of my objection.
Page 5 of your objection statement. We'll read that also.
Before I read, my lord, I just want to show just one table for your lordship's kind consideration, then I'll go through the objections, my lord. Page 5, which I just handed over, my lord. Para 9, my lord. The lordship may kindly see, my lord, total sanction post is 184 in state of Karnataka, my lord. Only 29 are working, 155 is vacant, my lord.
How long vacancy was there?
Hmm?
How long? From how many days it was there? How long this frugal vacancy, this enormous vacancy position continued? From which date to which date?
I'll just get back on that, my lord, from the thing. Your lordship.
And what would have happened had you waited for another 10 days? Therefore, we are asking you, how long this vacancy continued?
Yeah.
Continued from which year to which year? ಅಂದಾಜೆಲ್ಲ ಹೇಳಂಗ ನಾವು ರೆಕಾರ್ಡ್ ಮಾಡ್ತೇನೆ ಇಲ್ಲೆಲ್ಲ ಹೇಳಿ. Get his name also, court officer.
From 2000.
Reach that.
2019 onwards, my lord.
Ask you.
Designation. From, I just, first I'll give the detail, my lord. In fact, my lord, the same question, my lord, in fact, I should have given that information also, my lord.
Yes, sir.
Correct.
ನಿಮ್ಮ KPSC ಹತ್ರ ಉತ್ತರ ಇದೇನು ಇದಕ್ಕೆ? Since how long this vacancy position was continuing?
We don't have that.
You don't have information.
That information we'll never have. Because we come to know of the vacancies that are entrusted to us by the indent placed by the indenting department. That's all.
These vacancies are regarding rural drinking water supply and sanitation, my lord. In 2019.
19.
I'm given to.
No, he's saying 2019. AG is saying.
20th of February or May 2020, C&R rules have been read. And I think yesterday your lordship was disposed of one matter. That is a case where 30 executive engineers and 184 AEs. These are all recruitment.
Let them start.
And options are been from PWD. Many are not given. 2020.
So 2020 to 2024, 4 years. By you, 5 years. At least going by Mr. Lakshmi Narayana's version, 4 years these vacancies remained as they were.
Approximately, if you go as of now till.
ಮತ್ತೆ ಇಷ್ಟು ವರ್ಷದಲ್ಲಿ ಏನು ಅಂತದ್ದು ಇಮಿಡಿಯೇಟ್ಲಿ ಏನು ಮತ್ತೊಂದು KRS ಡ್ಯಾಮ್ ಕಟ್ಟುವಂತ ಅರ್ಜೆನ್ಸಿ ಏನಿದೆ ಎಲ್ಲಿದೆ?
Not that. If it, your lordship may kindly, 4 years there has been a vacancy.
Correct, ಈ 10 ಜನರಿಗೆ ನಾವು ಮಾತಾಡ್ತಾ ಇರೋದು.
ಅಲ್ಲಿ ನಮ್ಗೆ 10 ಜನ ಅಂತ ಇವಾಗ ಗೊತ್ತಾಗಿರೋದು ಮಲೋತ್ 2025 ಅಲ್ಲಿ. Once the final report which they have given. Because
the first letter they have mentioned.
No, they have not mentioned any people.
One second. We'll take you to that now.
No, there are no mention of the petitioner's name.
ಅಲ್ಲಿ tainted candidates ಅಂತಿದೆ.
ಅಲ್ಲ ಯಾರಂತ ಗೊತ್ತಿಲ್ಲ ಅದ್ರಲ್ಲಿ.
One second.
tainted candidates in general it is. my lord.
ಇಲ್ಲ, our Prakash, you read the other day.
This is the-
Even your
Subject to
letter, you
correction.
stated that these tainted candidates should not be issued.
ಇಲ್ಲ ಇಲ್ಲ ಆ
upon-
ತರ ಇಲ್ಲ ಮೇಡಮ್ ಸಬ್ಜೆಕ್ಟ್
Once, we'll see that. Where is that letter?
Number 126 of the inquiry report.
Ah. List is given to you.
7.
They have given the list to you. Commission shall recommend to the government to issue posting orders in favor of non-tainted candidates immediately. List of tainted candidates is this. They have given the list itself.
Page number? This one. 22 to 2024, my lords.
This is dated which? Prakash? The committee resolution itself was sent to you.
No, my lords.
No, was sent.
I'm sorry, subject to correction, not sent, my lords.
Like, they have said that the committee resolution is sent other day.
A9, page 102 will not indicate anything. 20.
I'll just verify, my lord, subject to
23
verification, I don't.
24, not A9. Red
The
paper.
commission in its meeting held on 30 January 25, having examined the report of the subcommittee, unanimously resolved as under. One of the recommendations is the commission shall recommend to the government to issue posting orders in favor of non-tainted candidates immediately. List of tainted candidates is below.
You're from?
They have printed that also.
From the statement of objection filed now, my lord.
Yes, yes.
Yes.
Today itself they have filed.
Please.
12/1/24, the
Huh?
secretary's complaint to the Lord government is not part of the Lord report at all.
I'm sorry,
He
can
then
I
secretary.
request, my lord, your lordships are reading it.
Yes, their resolution, which have sent, they recommended issue appointment orders to all people except the tainted ones.
Either the resolution.
This is the resolution which was sent to you.
No, my lord, 30th January is not, I'll just verify, my lord. It's not.
30 January 2025.
But that is much after the appointment.
Yeah.
That is much after the appointment.
Even before that also they had said that one.
That is Lord A9, Lord. A9, page Lord 102. Will not mention in red papers. Will not mention who are the tainted or untainted.
26 of the inquiry report.
No. Question,
120.
the question is, my lord, what your lordships are asking. What your lordships are asking, whether the petition 10 people's name was communicated to the state government is the. Page 126, Annex H is sent to us, correct? The previous document is not sent to us. Thirtieth January 2025, my lords, not 2024, my lords.
That is much after the appointment.
25, it has been communicated, my lords.
25.
And before
Not
that,
24, my lords.
Page number 105, the chairman of the council wrote a letter to the chief secretary.
That-
105.
That
was
is not,
on that basis only.
no, the court is asking whether the name of the tainted candidates was informed, when was it informed for the first time to the state government? If I'm understood correctly, my lords. Unless the inquiry was done there, even they did not have knowledge as to who are the tainted candidates. Only in the inquiry report for the first time, they came to know who are the tainted candidates, which is, the report is dated in the month of 23rd January 2025, which it was communicated to us on 31st January 2025. But all this is what your lordships are saying of the 2024, my lords. Hello. For the first time, my lord, 31st January 2025, the tainted names, I mean, alleged, the tainted names of the,
Names were not available to you.
No, it was available to us in the month of 31st January 2025, my lord. And in fact, the KPSC, in the communication, when the inform was on 1st February and 22nd February, they say investigation is still in the nascent stage.
Come
I'm
to-
just on facts, my lord.
Come to 105.
Please. No, this is,
Sir, E.
very next day it was communicated. I bowed, my lord. I bowed down, my lord. Only reason is the justification is, my lord, in view of the fact that there was acute shortage of assistant executive engineer. It definitely training and things like that take considerable, at least 1.5 years before their training is done, my lord.
Any note is prepared on that in that regard?
Not known.
Your office, how decision is made?
In fact, I've stated all that in the objection, whatever,
On what basis objection is prepared?
on the basis of the file, everything is there.
Therefore, just we want to know, on file note, what is your
With
reason?
all the file note papers, everything I referred to the petition in the objections itself. Just, I'll quickly run through so that your lordships get, I'll not read the whole thing. I'll quickly run through what I've stated.
Only another thing we'll
I'm
come to that one.
Please, please.
The chairman of the KPSC said
Correct, my lord.
that,
Hold on to it.
don't appoint one single candidate.
Correct, my lord.
Because the selection list itself is not approved by this commission.
Correct.
It said what is the rule position. Rule is reproduced in that letter.
1st February.
This is given to chief secretary. It is not given to some under secretary. Chief secretary of the government of the day was informed, saying this
Hold
has
on.
happened. Therefore, do not issue appointment. Do not act upon that selection list at all. That's how just it's
Correct, that is what it says, my lord.
and they named that particular IAS officer, that lady officer. What all she has done? It is mentioned in the letter itself. Why you should not act upon such a list at all? Because it is not even approved by the KPSC under the rules which you have made.
My lord, as your lordships, my lord, insofar as that is concerned, the reason why we have gone ahead with that appointment is, my lord, the communication came on 1st February and 22nd February of 2024, my lord. Subsequently, my lord, the appointment of assistant executive engineer and junior executive engineer was in the pipeline and almost to be appointed, my lord. At that point of time, my lord, the being acute shortage of assistant executive engineer, as well as the implementation of the drinking water scheme, my lord, of this.
Urgency.
My lord, and one more thing, my lord, here the appointment is not that they've been posted. The training itself takes some time and the condition was made for, there are two aspects of looking at it, my lord.
Maybe ಅದಲ್ಲ 1/2/2024 AX ಈ ಪ್ರಕಾರ the para 2 and 3 are very much specific about the acts being done by the KPSC as well as the anomalies in the selection and audacity or high at
No, what has happened, my lord, between the secretary, if you see the letter, my lord.
Within the knowledge of the chief secretary, what made him to issue orders with condition that?
Chairman sent this letter.
No,
Yes,
there are two
the
things,
chairman
my lord.
sent this
If you read
letter.
the 1st February letter, my lord, looks like there's a total discontentment with the secretary of the KPSC and the chairman of the KPSC because it doesn't, except for in the last paragraph, he makes a lot of states that make lots of allegations or statement against the secretary saying that she has done A, B, C, D, E, F, G and things like that. And ultimately he says take and conduct an inquiry against her, for which we, as pointed out, a draft is done and we have not proceeded because she went on leave, pursuant to which she went on transfer.
At least ಅವ್ರಿಗೆ ನೋಟಿಸ್ ಕೊಟ್ಟು ಇವ್ರು ಹಿಂಗೆಲ್ಲ ಹೇಳಿದ್ದಾರೆ. ಈಗ
ಮಾಡ್ಬೇಕಾಗಿತ್ತು.
ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಮಾಡೋಕೋ ಬೇಡ ನಾವು ಗೊತ್ತಾಗ್ತಾ ಇಲ್ಲ. ಇದಕ್ಕೆ ನೀ ಏನ್ ಹೇಳ್ತೀಯಾ?
ಅದ್
What
ಮಾಡ್ಬೇಕು.
you want to say to this? ಅಂತ ಒಂದ್ ಮಾತು ಕೇಳೋದ್ ಬೇಡ ಅವ್ರನ್ನ.
ಕೇಳ್ಬೇಕಾಗಿತ್ತು ಮನೋಜ್, we will do it by the end of the day, ಮನೋಜ್.
ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಮಾಡ್ಬೇಕಾ ಮಾಡಬಾರ್ದ ಅಂತ ಅವ್ರನ್ನ ಕೇಳೋದ್ರಲ್ಲಿ ಅರ್ಥ ಇರ್ಲಿಲ್ಲ. You could have asked what you say on these
On
allegations.
this ಅಂತ.
Mr. Beyond that.
Because she herself has.
She is nobody to say anything on that.
When approval itself is questioned by the secretary.
Correct, I understand.
Chairman of the commission sent this letter. Not some member. Chairman is saying ಹಿಂಗೆಲ್ಲ ಆಗಿದೆ ಅಂತ.
ಆ ಲೆಟರ್ ನೋಡಿದ್ರೆ ತುಂಬಾ ಡಿಸ್ಕಾರ್ಡ್ ಇದ್ದಾಗಿದೆ.
Between the chairman and the secretary, except leaving this issue, it goes around saying lot of other issues also in the.
ಏನೇ ಆಗ್ಲಿ quorum ಎಂಕೂ ಇಲ್ಲ.
I'm not justifying for a
There was
moment.
no quorum at all.
Manoj,
Where is the approval to the
my submission, has nothing to do with justifying the resolution or acting on it. There are two different, my lord. One is she could not, as your lordship pointed out, my lord, whether resolution could have been passed, should have been sent. All this is entirely a different aspect of the matter, my lord. As your lordship said, my lord, it could have been definitely avoided and should not have been done.
ಈಗ ನೋಡಿ ಎಲ್ಲಾ ಸಂವಿಧಾನಿಕ ಸಂಸ್ಥೆಗಳು ಅಪನಂಬಿಕೆಗೆ ಈಡಾಗ್ತಾ ಇದಾವೆ. ಎಲ್ಲ ಸಾಂವಿಧಾನಿಕ ಸಂಸ್ಥೆಗಳು ಅಂದ್ರೆ ಎಲ್ಲ ನೀವು ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನಲ್ ಲಾದಲ್ಲಿ ಓದಿದಂತ ಎಲ್ಲಾ ಸಂಸ್ಥೆಗಳು.
One other aspect your lordship may kindly see, my lord. Out of 184 posts, my lord, only 29 people are working. No appointments have been.
Therefore, we asked, since how long they were working?
Yes, we'll just get chief engineer is coming, my lord. We'll, because fact should be, as your lordship is being recorded.
Recording. His name and this one, everything will record.
So therefore, my lord,
wrong will
my
not
lord,
leave him at all.
virtually, my lord, it had come to a standstill, my lord. If you see the number of people working as against 118 and 155 were vacant. And one more thing, my lord, and it is not that.
ಇದೇ ಆಕ್ಷನ್ ಬೇರೆ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಆಗಿ ತಗೊಳ್ಳಲ್ಲ ನೀವು.
ಅದ್ರ 3 ಆರ್ಡರ್ಸ್ ಇದೆ. ವರಾಳೆ ಸಾಹೇಬ್ರ ಜೊತೆ ಕೂತ್ಕೊಂಡು ನಾನು 2, ನಾನು ವಿಜಯ್ ಕುಮಾರ್ ಪಾಟೀಲ್ ಸಾಹೇಬ್ರ ಜೊತೆ ಕೂತ್ಕೊಂಡು ನಮ್ದೊಂದು 3 ಆರ್ಡರ್ಸ್ ಇದೆ. ಯಾವ ವೇಕೆನ್ಸಿಗಳನ್ನು ಹಾಗೆ ಇಡಬೇಡಿ, ಜನ ವಯಸ್ಸಾಕೋತ್ ಹೋಗ್ಬಿಡ್ತದೆ ಕ್ಯಾಂಡಿಡೇಟ್ಸ್ಗೆ, ಏಸ್ ಬಾರ್ ಆಗ್ತಾರೆ. ಕಡೆಗೆ ಆರ್ಡರ್ ಮಾಡಿದ್ದೀವಿ. ಈ ಅವಸರವನ್ನ ತೋರಿಸಲ್ಲ,
ಬೇರೆ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಯಾಕೆ ತೋರಿಸಿಲ್ಲ?
ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ನಲ್ಲಿ ವೇಕೆನ್ಸಿ
ಡಿಪಾರ್ಟ್ಮೆಂಟ್ಸ್ ವೇರ್ ದಿ 40-50% vacancies are there.
Not to make
this department is saying favored.
Not department.
All of a sudden,
all departments, my lord. In fact, my lord, your lordship may kindly see, we made this AE and JE on the very same day. We filled up all the vacancies, my lord. Almost all.
Same department, sir.
Yesterday, another matter came. Yesterday, other day, another matter came. There is a decision of the apex court. Highest court of the country has said, go ahead with the appointment. Which Lakshmana was there. JT was. Highest court of the country is telling you, please appoint. Nothing has been done.
In that matter, if I remember, sir, my lords have directed, ಯಾವ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಎಷ್ಟೆಷ್ಟು ಪೋಸ್ಟ್ ವೇಕೆಂಟ್ ಇದಾವೆ
ಎಲ್ಲ ಬಂದಿದೆ. ಈಗ ಇದರಲ್ಲಿ ಇಷ್ಟೊಂದು ಅವಸರ, ಅವ್ರು ಅಪಾಯಿಂಟ್ ಮಾಡಬೇಡಿ ಅಂತ ಹೇಳ್ತಾರೆ ಚೇರ್ಮನ್. ನೋ ನೋ ಅನ್ಕೊಂಡು ಏಕ್ದಮ್ ಏನು ಬೆಂಕಿ ಹತ್ತಿ ಹೋಗಿದೆ ಅನ್ನೋ ರೀತಿ ಮಾಡಿ ಮುಗಿಸ್ಬೇಕು. ಅವುಗಳಲ್ಲಿ ಒಂದು ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಮ್ಯಾಟರ್ ನಲ್ಲಿ ಪಾರ್ಟೆಡ್ ಇದೆ ನಮ್ಮಲ್ಲಿ ಈಗ. ಹಾಗಾಗಿ ಅಫಿಷಿಯಲಿ ವಿ ಆರ್ ಸೇಯಿಂಗ್ 2000 ನಿಂದ 5 ರಿಕ್ರೂಟ್ಮೆಂಟ್ ನೋಟಿಫಿಕೇಶನ್ಸ್, 5 ರಿಕ್ರೂಟ್ಮೆಂಟ್ ನೋಟಿಫಿಕೇಶನ್ಸ್ 2000 ನಿಂದ 2023 ವರೆಗೆ 5 notifications have been issued. Not even one notification is acted upon. Every subsequent notification cancels the earlier notification. That order which we made.
Yes,
yes.
Just draft was finalized, my lord. Entire thing is completed.
Everything like draft of this notice.
We filed a memo to the court.
No.
Secretary has come and undertaken to issue that notification.
That was finalized. Yes. Considering all the objections, it has been finalized.
ಯಾಕೆ ಹಿಂಗಾಗ್ತದೆ ಅಡ್ವೊಕೇಟ್ ಜನರಲ್? ನಾವು ಹಿಂಗೆ ಹೇಳ್ದ ಕಿಶನೆ ಆಮೇಲೆ ಇದು ಆ ಪಕ್ಷ ಗಿಕ್ಷ ಎಲ್ಲ ಇದೆ, ಅವಾಗಿಂದು ಹಿಂಗೆ ಇದೆ. ಇದು ನಾಟ್ ಎನಿ, we are not on any political.
No, the question does not arise at all, my lord. That question doesn't
at all.
My lord, we should not go into that. We not.
Both we are students of history. We know whichever government, whichever political dispensation, and there is no disappointment level of the people has not come down. Justifiable.
Malik Bazar case ಅಲ್ಲಿ ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
Malik Bazar ನಲ್ಲಿ there is a direction by the apex court. All vacancies in the judicial section should be filled immediately. Malik Bazar famous judgment. Of course, you have referred to that also.
The file is not closed. We are filing affidavit. All high courts are filing affidavits.
We are making up it. Why that is not being done? ಇದರಲ್ಲಿ ತೋರಿಸಿದಂತ ಅವಸರ ಇದೆಯಲ್ಲ. ನೀನು ಕೆಲವು ಪಾಪ ಮೊನ್ನೆ ನಾವು ಎಷ್ಟು ಕಣ್ಣೀರು ಹಾಕಿ ಹೋದ್ಲು ಒಬ್ಬ ಹೆಣ್ಮಗಳು. started crying in the court hall. Of course, we write our orders with a pen and ink, not teardrops. It's true. ಬಟ್ ಆಫ್ಟರ್ ಆಲ್ ಹಂಗ ಇಂಥ ಒಂದು ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನಲ್ ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಬಂದು ಕಣ್ಣೀರ್ ಹಾಕಿ ಹಿಂಗೆಲ್ಲ ಆಗಿದೆ ಅಂತ ಹೇಳೋ ಲೆವೆಲಿಗೆ ಬಂದ್ರೆ ಹೆಂಗೆ ಅಂತ. ಇದು ಇನ್ನೊಂದು ನಮ್ನಿ ಕಣ್ಣೀರ್ ಹಾಕೋದು, ಅದು ಇನ್ನೊಂದು ನಮ್ನಿ ಕಣ್ಣೀರು. ಎಷ್ಟು
Lord has
ನಮ್ನಿ
given a
ಕಷ್ಟ-
best solution.
Ultimately,
In that
my
case,
lord, now
I was in the open court.
That's what. ಹಿಂಗಿದೆ ಬಹಳ. ಈಗ ಚೀಫ್ ಸೆಕ್ರೆಟರಿ, ಈಗ ನಾವ್ ಯಾಕೆ ಇದನ್ನ ಹೇಳ್ತಾ ಪ್ರಪೋಸಲ್ ಯಾಕೆ ಕನ್ಸಿಡರ್ ಮಾಡಿದ್ವಿ ಅಂತ ಹೇಳಿದ್ವಿ, ಯಾವುದೋ ಒಂದು ಅಂಡರ್ ಸೆಕ್ರೆಟರಿ ಡೆಪ್ಯೂಟಿ ಸೆಕ್ರೆಟರಿ ಲೆವೆಲ್ನಾಗ ಆಗಿದೆ. ಹಂಗಾಗಿ ಯಾವುದೋ ಒಬ್ಬ ಸೆಕ್ರೆಟರಿ ಹೇಳಿದರೆ he will ensure that police investigation takes place. Chief Secretary was an explanation why he did not take this serious. ಇಷ್ಟೆಲ್ಲ ಹೇಳಿದ್ದಾರೆ. ಚೇರ್ಮನ್ ಹೇಳಿದ್ದಾರೆ, ಬೇರೆ ಯಾರೋ ಒಬ್ಬ ಮೆಂಬರ್ ಹೇಳಿದರೆ ಏನೇನೋ ಫ್ಯಾಕ್ಷನ್ಸ್ ಇರ್ತಾವೆ, we can understand. Chairman writes this letter. ಹಾಗೂ ಥಿಂಕ್ ಮಾಡಿದ್ರೆ ಚೀಫ್ ಸೆಕ್ರೆಟರಿ ಮೇಲೆ ನಾಳೆ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಮಾಡಬೇಕು ಅಂತ ಹೇಳ್ತಾರೆ.
ಇಲ್ಲ ಚೀಫ್ ಸೆಕ್ರೆಟರಿ ಮಾಡಕ್ಕೇನಿಲ್ಲ.
We don't know.
ಅಲ್ಲ hello,
We don't know. We are not saying anything more than this.
Because your lordship may kindly see at best, my lord, it should have been notice ought to have been issued pursuant to the communication received.
No, not about that lady.
No,
That lady is another thing.
No,
ಇದೆಲ್ಲ ಆದ್ಮೇಲೆ
the 1st February person to 1st February or 22nd February, my lord, it ought to have been done, my lord. What was falling from notice explanation should have been sought for with regard to the letter dated 1st February 2024, my lord.
ಇದು ಪ್ರೈಮಾ ಫೇಸಿ ಅಸರ್ಟನ್ ಮಾಡ್ಕೊಳ್ಳೋದು ಬೇಡ. ಚೀಫ್ ಸೆಕ್ರೆಟರಿ ಎಷ್ಟು ಜನ ಮೀಟಿಂಗ್ ನಲ್ಲಿ ಇದ್ರು, ಎಷ್ಟು ಜನ ಇರಬೇಕಿತ್ತು. ಫಸ್ಟ್ ಇಯರ್ ಲಾ ಸ್ಟೂಡೆಂಟ್ ವುಡ್ ಹ್ಯಾವ್ ಅಡ್ವೈಸ್ಡ್ ಹಿಮ್ had he consulted one. Your section says like this, number of people who attended the meeting less than that. On first principle, at least second year law.
But only thing, my lord, at that point of time, my lord, the copy of the resolution, my lord, was not with the that was not forwarded to us. Those integrate
But letter
information,
was sent.
the communication was sent to us. I brought out
Letter
1st February
running
2024.
into
It has been received to
5 pages was sent to you.
This letter includes the rule.
It has reproduced the rule. ರೂಲ್ ಹೇಳ್ಬಿಟ್ಟಾರು. ಈ ರೂಲ್ ಕೆಳಗಡೆ ಹಿಂಗಿದೆ, ಸೆಕ್ಷನ್ ಈ ರೀತಿ ಇದೆ, ಫೋರಂ ಇಲ್ಲ.
What happens, my lord, insofar as Karnataka in transaction of business rules, Rule 7, my lord, each department of secretary shall consist secretary to the government who shall be the office head of the department of such other officer subordinate to him as the state government may determine. Explanation was, secretary to the government in the department of the cabinet affairs and the department of personnel shall be the chief secretary, my lord. Except for all other, my lord, it is the secretary. Now what has happened here, my lord, this comes under the RDPR, my lord. Rural and.
But chief secretary, apex court said in Shankar
No,
Narayanan's case.
As per the,
he is
just how
secretary, your-
the appointment is done by RDPR in this, case. In this case.
Chief secretary is a secretary of all departments.
No,
under
no, how the
your-
business, transaction of business, how it, Manoj, how the transaction of business, how it functioned, Manoj. As your also said, Manoj, the letter 1-2 has gone to the chief secretary, notice and action calling for explanation is that one aspect, Manoj. Insofar as this appointment is concerned, Manoj, it is the concerned secretary, Manoj.
Okay, but it is
No.
directly addressed to the chief secretary,
No, that is
not
the
a
first-
copy is sent to him.
No, the copy is not sent.
Directly a letter is sent to the secretary.
Chief secretary.
Chief secretary, letter is sent to the chief secretary.
ಹೌದು.
Manoj. Insofar as appointment order, what I'm saying is, Manoj, the appointment.
ಸೆಕ್ರೆಟರಿಗೂ ಕಳಿಸ್ಯಾರ,
ಅವ್ರಿಗೂ ಕಳ್ಸಿದ್ದಾರೆ.
ಸೆಕ್ರೆಟರಿಗೂ ಕಳಿಸ್ಯಾರ. ಅವಾಗ ಏನು ಆಗಿಲ್ಲ ಅಂದ್ರೆ ಚೀಫ್ ಸೆಕ್ರೆಟರಿ ಕಳಿಸ್ಯಾರ.
ಇಲ್ಲ.
One letter is addressed to the secretary, 2 letters are addressed to
No,
secretary.
Your Lordship, 22nd February is to the RDPR, my lord. 22nd February. That is different from what is sent on 1st February.
ಅಂದ್ರೆ ಚೀಫ್ ಸೆಕ್ರೆಟರಿಗೆ jurisdiction ಇರಲಿಲ್ಲ ಅಂತ
ಹಂಗಂತಲ್ಲ. What has with regard, why the appointment order? Because what insofar as the 1st February is concerned.
ನಂಗೆ ಇಷ್ಟು ತೋರಿಸಿ ಸ್ವಲ್ಪ ನಮಗೆ. ಚೀಫ್ ಸೆಕ್ರೆಟರಿಗೆ ಲೆಟರ್ ಹೋಯ್ತಲ್ಲ, ಅದ್ರ ಮೇಲೆ ಏನ್ ನೋಟ್ ಮಾಡ್ತಾರೆ ಅವರು?
I'm getting the file. No, notice to issue notice to her, my lord.
ಚೀಫ್ ಸೆಕ್ರೆಟರಿ ಹೇಳಿದ್ರು.
Notice to, but it was not acted upon. It was drafted and kept in the file.
Even ಚೀಫ್ ಸೆಕ್ರೆಟರಿಸ್ ನೋಟಿಗೂ ಬೆಲೆ ಇಲ್ಲ.
Then, my lord, she went very next day. She went on leave. my lord.
ಆಯ್ತಲ್ಲ, ವಾಪಸ್ ಬಂದಾರಲ್ಲ ಅವ್ರು ಆಮೇಲೆ.
ಆಮೇಲೆ ಬಂದಿಲ್ಲ ಅಂತ didn't come back to
ಅವ್ರು
this.
ದೇಶನ ಬಿಟ್ಟು ಹೋಗಿದ್ರು ಅಂದ್ರೆ ದಟ್ಸ್ ಅನದರ್ ಥಿಂಗ್. ಈ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಇಂದ ಇನ್ನೊಂದು ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ನಿಮ್ ಗವರ್ಮೆಂಟ್
Asked in Bangalore.
you should have called her. You should have called her and asked her. You owe an explanation. Your hands appear to be soiled. You owe an explanation. How is that your hands are soiled? Chief Secretary directs, issue should cause notice. Yeah, we want, if you, can we request you to show us? Can we request you to show us the original file?
No.
We request, we do not
No,
know.
no,
You are
we-
entitled to say no.
No,
Then
the
we'll try it.
No, the question does not arise, my lord.
Then kindly give us the file.
They're getting it, my lord. Till then, my lord, can I permit?
Yes.
To your lordship,
Very
can kindly. From page 3, my lord. Para 4, my lord. It is, my lord's got it, my lord. Page para 4, my lord. It is submitted in the facts of the present case, the respondent number 2 issued 2 notification on 3/9/2022, calling out the application to fill up the post of Assistant Executive Engineer Grade 1 in the respondent number so and so. It is submitted 1 notification.
1 second, 1 second. Yes, sir.
My lord's got it, no? Page 3. Para 4, my lord.
Submit that.
Basically, it's saying there are 2 notification, my lord. One was for 18 posts, second is for 77 posts, totally 25 posts, my lord.
Yes.
Then para 5, my lord, it is submitted on 31st January 2024. The then Secretary of KPSC forwarded the final selection list to the first respondent department for further action. In pursuance of the same, the first respondent department called for selected candidates for document verification on 19/2 at 11 a.m. Accordingly, all the 24 candidates submitted their documents for verification on 19/2/2024. Copy of the final selection list dated 31st January are produced as annexure A5 and A6 to the writ petition, and copy of the notice dated 12/2/2024 as annexure A8 to the writ petition. Then para 6, my lords, page 4. It is submitted that on 1/2/2024, the chairman of the KPSC writes a letter to the Chief Secretary of the Government of Karnataka requesting the Chief Secretary to take appropriate disciplinary action against so-and-so, the then Secretary of the Commissioner, and to reject the various selection lists published by her in violation of the rules as they do not have constitutional validity, and instruct the Secretary KPSC to submit them after obtaining the approval of the full commission as per the rules and return them. It is submitted that such letter of the case did not specify the limit itself to the facts of the present case, and on the contrary, various issues as alleged by the chairman was brought to the notice of the Chief Secretary, Government of Karnataka. Copy of the letter dated 1st February 2024 is produced as annexure E, page so-and-so of the final inquiry report dated 23rd January 2025. It is submitted that the file was processed for further action in this regard. However, she so-and-so went on leave on 7th February 2024, and so-and-so was placed in concurrent charge of the post of Secretary KPSC during the leave period. It is submitted subsequently on 4th March 2024. So-and-so was transferred, and so-and-so was Commissioner so-and-so was placed in concurrent charge of the post of Secretary KPSC. It is submitted that on 22nd February 2024, the Secretary of the KPSC wrote a letter to the first respondent department intimating the objection have been received regarding the provisional select list, and the commission has formed a subcommittee consisting of honorable members of the commission with mandate to review the matter and submit a report in view of the objections received regarding irregularities in the JE recruitment process. It was further informed that the inquiry is at an early stage and the final report is yet to be received. In this background, the Secretary of the Commission requests the government to withhold the issuance of the appointment order of final selection list dated 31st January 2024. Copy of the letter dated 22nd so-and-so is produced year's NXH of the final inquiry report dated so and so. It is further submitted the following charts depicts the vacancies in rural drinking water scheme and sanitation department at the time of issuance of the notification for recruitment. It is submitted due to such status of vacancy, implementation of rural drinking water supply scheme like Jala Jeevan Mission, Jala Dare rural sanitation works were suffering. Therefore, the members of the Legislative Council and the Legislative Assembly and the Legislative Council were raising the issue during the legislative session to fill the vacancies. It is submitted on account of the dire need for filling up the vacant post of the Assistant Executive Engineer and for the reason that the process of appointments of AE is a time-consuming process as it involves...
One second. Come to para 10, revert to para 10.
Please, Manoj.
You said there was discussion in the Legislative Council. We are not entitled to call for. But if you say that there was such a discussion, that for that at least minimum
place it.
material you have to
To
place.
place it, definitely, I'll make a note. I'll definitely place it, Manoj.
If you want us to believe this much.
No, we'll place
We
it.
have no power to call
No,
for anything
Manoj,
from the
we'll-
legislature.
Anything, well, we will place it, but probably if possible by end of the day itself. Manoj. And just we will place it, Manoj.
It is whether a discussion in the House was with regard to filling these vacancies or vacancies in general, because it is not specific.
I'll just subject to correction 99%. I think these vacancies itself. I'll place that also before your lordship. Within during the course.
Any
Star questions.
Please.
Star questions in the assembly.
Must be, Manoj. I'll just WhatsApp. I'll assist your lordships, Manoj, whatever information your lordships are. Correct, no? We have the file, that also, Manoj, because while preparing the objection, we went to ask this specific question, Manoj, but I didn't go deeper. Start question, who has asked the question, what it
just
is.
we wanted to, whether ಏನೋ ಒಂದು ಹೇಳ್ತಾ
ಇಲ್ಲ. ಅಲ್ಲ ಇದ್ದಿದ್ದು ಅಲ್ಲ ಇದ್ರಲ್ಲಿ ಮಾಡುವಾಗ ಇದ್ದಿದ್ದು ಹೆಂಗೆ ಇದೆ ಆ ತರ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ನೋಡ್ಬಿಟ್ಟು ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಪ್ರಕಾರ ಬರ್ತಿದ್ದೀನಿ. ಇಟ್ಸ್ ಕೋರ್ಟ್ ಆಫೀಸ್. Correct, no? This is what questions with regard to this itself. Is it regarding this itself? Post here. Allah, post here. Sure. AW there. ಎರಡು ಕಾಪಿ ಕೊಟ್ಟಿದ್ದಾರೆ, ಒಂದು ಕಾಪಿ ಇನ್ನೊಂದು ಕಾಪಿ ಕೊಟ್ಟು
ಎಲ್ಲದನ್ನು ಒಂದು ಮೆಮೋದಲ್ಲಿ ಸರಿಯಾಗಿ ಮಾಡಿಕೊಡಿ, ಇಲ್ಲ ನಾವು ರೆಫರ್ ಮಾಡೋದಿಲ್ಲ.
ಇಲ್ಲ ಮಾಡ್ಕೊಡ್ತೀನಿ. I'll do that by end of the
ಮಾಡಿ ಅವರಿಗೆ ಒಂದು ಕಾಪಿ ಕೊಟ್ಟು ಏನೇನು ನೀವು ಕೊಡ್ತಾ ಇದ್ದೀರಿ ಅದನ್ನೆಲ್ಲ ಅವರಿಗೂ ಕೊಡಿ.
ಅಲ್ಲ ಅದಕ್ಕೆ I'll do that. Court will verify because I just handed it over as I got.
We'll read that. Afterwards compile ಮಾಡಿ ಕೊಡಿ ನಮ್ಗೆ.
ಮಾಡ್ಕೊಡ್ತೀನಿ.
ಒಂದೊಂದು ಕಾಪಿ.
Index ಮಾಡ್ಬಿಟ್ಟು compile ಮಾಡ್ಕೊಡ್ತೀನಿ.
That's what.
It is submitted on account of dire need for filling up of the vacant post of Assistant Executive Engineer and for the reason that the process of implementation of AE is a time-consuming process and involves several stages of verification and certification like police verification, Sindhutva certificate of medical witness, rural certificate, degree certificate, marks card verification. The file concerning the appointments to the post of AE to the respondent one department in person to selection list dated was submitted for perusal of appointing authority and appointing authority after considering the work pressure and the requirement and further considering the point that it was clearly indicated in the letter
dated 22 to 24 as written by Secretary of KPSC.
Correct.
You believe Secretary, but you don't believe the Chairman.
Allah, same different Secretary, Manoj. We believe the Secretary saying withhold. This letter also says withhold, Manoj. It doesn't say appoint. Your Lordship may kindly see this letter also says withhold, Manoj. So therefore, first the Chairman and the subsequent Secretary says withhold. It is not that we are saying that.
Hiding anything.
I thought I'll clarify, my lord. This is Secretary that inquiry was at the early stage and the final report is yet to be received, directed to proceed with the document verification process of the candidate. Further, the appointment orders relating to the post officer and junior engineers and the response was issued on 21/6/2024, and therefore it was incumbent upon to fill up the post officer so and so. In this regard, the file was received by ACS RDPR on 11th April 2024 for further actions, and the applications of the petitioner therein were set for obtaining the aforesaid verification and certificate letter between 3rd April 2024 to 23rd April 2024. It is submitted that on 18th May, Secretary KPSC wrote a letter to the Secretary Government of Department so and so that a subcommittee was formed by the KPSC on 18 December 2020 to inquire into the matter, which was reconstituted subsequently. Such reconstitution constituted committee held several meetings, and on 26th March 2024, the Commission considered and approved the proposal of the subcommittee for scientific investigation of the matter. In the said letter, Secretary KPSC sought for permission of the government to continue with the investigation after obtaining expert FSL report opinion regarding OMR and CCTV footage of the candidates. In reply to the said letter, the Department of Personnel and Administrative Reforms, while letter dated 27th May 2024, granted permission for obtaining expert FSL report opinion regarding OMR and CCTV footage of the candidate. However, such interim report and formation regarding submitting of the matter of scientific investigation was not furnished to the appointing authority, being the respondent number 1 department. It is submitted para 13. It is submitted the interim report of the subcommittee was not communicated to the first respondent herein, being the appointing authority. Therefore, the first respondent being
Just we want to ascertain whether interim report of the subcommittee was shared with the government.
Yes, my lord. This inquiry report shared on 2/2/25.
Interim report of the committee. Any interim report was there?
According to our, as per our,
Can
instructions, no interim.
Take instruction and answer. There was no interim report. Which is that interim report you are referring to?
no, not the interim. Actually, that what is being referred to is the earlier communication, my lords, to the chief secretary. That is what, because what they are trying to tell here is, my lords, they have communicated to the chief secretary. The appointing authority is the principal secretary, RDPR, my lords. So therefore, except for the letter dated 22nd February, there's no other communication is what they're trying to explain. As there's only a final report. The interim report is that FSL report, my lords. That is what they're referring to. That's not an interim report. It should have been a communication seeking approval, my lord.
First, the FSL report appears to have been received on 29/10/2024.
Correct.
Till then, there was no interim report or any report.
There was
In
no
fact,
such thing.
No such.
1st February
Perhaps
2024.
the learned AG says it must, they may be referring to that letter.
That letter.
It is-
That's
there was no
wrongly
report.
worded, my lord.
On the other hand, they say clearly, it was in a very nascent stage on that. Because as up till 31/1/2024, only one meeting of the subcommittee had taken place. The 2 members, they refused to participate in the meeting.
It was then 5 members, it was made later at a later point of time.
After it became 5 members, these 2 abstaining members also participated.
The subcommittee was not to the early stage. No, this was the inquiry is at the earlier stage, and the final report is yet to receive. Issued an appointment order of 15 so and so as follows, my lord. Copy of page 8, paragraph 14. It is submitted thereafter. Appointment orders were issued by the respondent for remaining 9 posts periodically between so and so, making such appointment also subject to the aforesaid conditions. That is condition is which I mentioned here, my lord. Karnataka Police also request with para 15.
Correct.
It is submitted that the respondent 1 department issued the letter 1911, thereby requesting KPSC to provide the respondent number 1 the final report of the committee constituting for inquiry before sending such candidates for training. That is 19th November 2024. However, no report came to be furnished to the first respondent department KPSC. According letter dated 5th January 2025 and 30th was issued to the director report so and so in regard to deputation of appointees for training as on 3rd February 2025. A memorandum was issued by the director RWSSB deputing all the AEs for training. Accordingly, the candidates have been deputed on training from 4th February 2025 to 29th March 2025. It is further submitted salaries of appointees have not been paid from the date of appointment till today, and KGAD number has not been allotted. It is submitted the final inquiry report of the subcommittee as constituted by KPC was received by the Department of Personnel and Administrative Reforms in a sealed cover. When action of the inquiry report was under process, this honorable court by order dated so and so and so directed not to precipitate. In the light of the aforesaid, it is submitted the respondent one being the appointing authority was neither provided complete information status of inquiry so and so date of appointment or other. So that's being the case. Ultimately, Malot, as pointed out earlier, Malot, this is only the whole process was being going on, Manoj. Therefore, Manoj, they neither been paid only till training, Manoj, so that we could save time. Ultimately, Manoj, if they are not eligible as per the appointment letter itself, Manoj, they can be relieved, Manoj.
Have you anywhere indicated? Because in our order, we said you have to make your stand clear as to the proposal for CBA. Anywhere?
Yes, Manoj, we have made our clear by appointing, accepting the proposal and issuing a document number 1, Manoj.
No, whereas it is not a case for CBI investigation at all.
We have already.
Did you say one sentence?
Allah, now CD ಕೊಟ್ಮೇಲೆ it means that only. Now CD inquiry ಮಾಡ್ತೀವಿ ಅಂತ ಹೇಳಿದ್ದೀವಿ.
CID inquiry. ಎದರಲ್ಲಿ ಹೇಳಿದೆ?
ಇದರಲ್ಲಿ ಇದೆ ಮೇಡಮ್. Page document number 1, page 12 ಮೇಡಮ್.
Now, it is only now.
Yes, ma'am. ನಾನು ಬಂದಿರೋದು ನಮಗೆ 31st January 2025 ಮೇಡಮ್. The recommendation is dated 31/1/2025. We have received it, ma'am. We received it on 2nd February, ma'am.
CID inquiry you are going to do.
Please.
ಇತ್ತೀಚಿನ 5 ವರ್ಷದಲ್ಲಿ ಎಷ್ಟು CID ನಮ್ಗೊಂದು ಇನ್ಫಾರ್ಮೇಶನ್ ಕೊಡಿ, ಸ್ಟಾಟಿಸ್ಟಿಕಲ್ ಡಾಟಾ ಕೊಡಿ. ಎಷ್ಟು CID ಎನ್ಕ್ವೈರಿಗಳನ್ನು ಮಾಡಿಸಿದ್ರಿ, ಎಷ್ಟರಿಂದ ರಿಯಲಿ ಟ್ರುತ್ ಹೊರಗೆ ಬಂತು? ಲಾಸ್ಟ್ ಪ್ರಿಸೀಡಿಂಗ್ 5 years ನಲ್ಲಿ ಹೌ ಮೆನಿ CID COD ಎನ್ಕ್ವೈರೀಸ್ ವೇರ್ ಕಾನ್ಸ್ಟಿಟ್ಯೂಟೆಡ್ and how many resulted into any positive steps for the preceding 5 years?
Please, ma'am. I'll place it before.
In fact, we very carefully gone through each of the pages. The subcommittee has done great work. Nobody would have done this. The subcommittee members, they stood tall, they took a decision. Nothing should be allowed to happen.
One other thing, state, whenever we assisted, we gave consent within 1 day or 2 days. They asked us consent once. Within 1 day or 2 days, we said go ahead. And one more thing, we are not paid salary. We have only put them to till the process of training, and it's subject. I understand, there are certain things. It is not that we wanted to favor. Your lordship saw the numbers,
Out of committee members, yaru ಹೆಸರಿಲ್ಲಿದೆ?
That is in the last page, of the. No.
5 ಜನರ ಕಮಿಟಿ ಇತ್ತಲ್ಲ, ಯಾವ್ದದು?
No, page number 9.
I make one submission. Permit.
R. Girish, can I read?
12/1/2024.
One second. Who are the members of the
Can I
committee?
read it out? Page 92.
92. ಓದಿ. ಅದೇನ್ ಚಲೋ ಕೆಲಸ ಮಾಡಿದಾಗ ನಾವು ಓದ್ಬೇಕು. ಅವ್ರ ಹೆಸರು, ಕೆಟ್ಟ ಕೆಲಸ ಮಾಡಿದವ್ರ ಹೆಸರು ಹೇಳ್ಬಾರ್ದು. ಅದು ಎನ್ಕ್ವೈರಿ ಪನ್ಕ್ವೈರಿ ಆಗ್ಬೇಕಾಗ್ತದೆ.
Vijay Kumar Kuchanur.
Vijay Kumar Kuchanure.
Kuchanure, page 92.
Chairman of subcommittee.
Chairman subcommittee.
R. Girish. MB Heggannanavar.
Doctor.
Geeta BV. Mustafa Hussain SA.
Geeta BV and Mustafa Hussain were part of the 3-member committee also, my lord. Subsequently, these 3 members was sought to be.
Really, we appreciate at least even ಅಂತ members ಎಷ್ಟು ಒಂದು boldly ಇಂತ ಎಲ್ಲ ಡಿಸಿಷನ್ ತಗೊಂಡಿದಾರಲ್ಲ, we should appreciate that. Otherwise ಎಲ್ಲ ಹಿಂಗೆ ಹೋಗ್ಬಿಡ್ತಿತ್ತು, ಎಲ್ಲರೂ ಹಾಗೆ ಕಳೆದು ಹೋಗ್ಬಿಡ್ತಿತ್ತು. ಇವ್ರು ಬಿಗಿಯಾಗಿ ಇಷ್ಟೆಲ್ಲ ಮಾಡಿ, they really deserve appreciation.
Page 84, one paragraph ಓದ್ಬಿಡ್ಲ.
84.
Just above paragraph 75.
ಎಷ್ಟು ಒಳ್ಳೆ ಕೆಲಸ ಮಾಡಿದ್ದಾರೆ ಕಮಿಟಿ ಅವರು.
Detailed report with, in fact, whatever our
70,
it's
84,
83, my lord.
83.
Para 73, my lord. As stated supra, the selection list of all the candidates was forwarded by the government to the government by secretary to further action. However, the chairman of the committee through letter dated so and so requested chief secretary withhold the selection list on various grounds. The government did not act on the selection list but immediately, but however, on so and so, the government issued notification appointing 16 candidates so and so. I'll just skip that, my lord. After the perusal of this notification revealed that the government though has issued appointment orders either to, no posting orders are issued in favor of such candidate, perhaps due to the pendency of the present inquiry. There is a clear distinction between the concept of recruitment and appointment. The term recruitment connotes and clearly signifies enlistment, acceptance, selection, or approval for appointment. In contrast, the word appointment means an actual act of posting a person to a particular. Recruitment is just an initial process and they may lead to eventual appointment in service, but that cannot tantamount to appointment in so and so. Therefore, hitherto the government has not issued any posting order to this candidate. Therefore, the finance is not acted upon so and so. Spirit in the letter and spirit even today, and it is the stage of recruitment, not stage of appointment. So therefore, my lords, in the commission is the constitutional body established. Sir.
ಇಲ್ಲ, that they really.
They have gone in depth, my lord. My lord,
You honestly, do you not feel they have done good work?
excellent.
That's true.
I'll place this before your lordships, my lords.
Original file on ನೋಡ್ಲಿಕ್ಕಿತ್ತು ನಮಗೆ.
But even during the end of the thing, I'll give it to you, lord.
ಈಗ ಮುಗಿಸೋಣ, ಯಾಕಂದ್ರೆ ಅವರಿಗೂ ಟೈಮ್ ಕೊಡಕ್ಕಲ್ಲ. ಪಾಪ ನಿಮ್ನಷ್ಟು ಕೇಳಿದೇವೆ ನಾವು. ಅವ್ರದ್ದೇನೇನ್ ಸ್ಟೋರಿ ಅಂತ we don't know. But one thing, ಏನೋ ಹೇಳ್ತಾ ಇದ್ರಿ.
12/1/2024, the then secretary made allegation against very members of this committee to the governor as a chief secretary. That is why, Lord, the government, though drafted the show cause notice, probably will not.
How you will know all these things?
That is what, Lord,
take up that
came to know that. He came to know that.
You are engaged.
That's why, Lord, I asked your lordship, Lord, to bring that letter 12/1/24. Nothing else. It's a part of the. It is not part of the committee.
The Advocate General has said whatever is consistent with the records.
But kindly see the report. It doesn't contain the letter date 12/1/24. The then secretary. That letter will.
Heard learned senior advocate Mr. Rajgopal, P.S. Rajgopal, appearing for the KPSC, assisted by senior panel counsel Mr. Prakash. Sem. ಅದಕ್ಕಿಂತ ಬದಲು heard learned advocate general for the government of Karnataka. First, the statement of objections filed by him or by the AGA or is taken on record. Next, the heard learned senior advocate appearing for P.S. Rajgopal appearing for KPSC, assisted by Prakash, panel counsel. Full stop. The statement of objection filed by him is also taken on record. Full stop. Shri, next paragraph. Learned Advocate General, on being requested, graciously agrees that the original file will be shown to the court on the tomorrow. When, how much time you want to file objections?
Lord, today we have received the copy. May I give 5 days time next week, Lord. Next week, by 3rd or 4th. Before 4th, we'll file it.
Next week, about 10ನೇ ತಾರೀಕು ಬರ್ತದೆ. First of February. ನೀವು ಹೇಳಿದ್ರೆ 5 days ಇನ್ನೂ ಜಾಸ್ತಿ ಕೊಡ್ತಾ ಇದ್ದೇವೆ ನಾವು.
3rd or first date on bit to convey.
You have said
first time out of station.
Nothing like
the second day.
Learned senior advocate Mr. M.S. Bhagwat and learned senior advocate Mr. Lakshmi Narayana appearing for the petitioners want to file the rejoinder to the statements of objections filed by the government and the KPSC. First. That took place today for a long time. We again went through the 5-member committee proceedings, and we shall be failing in our duty if we do not appreciate the way these 5 members, namely, conducted the proceedings that being taken, at the hands of whichever quarters that be. We really appreciate them. We appreciate you because you are so fair. When we ask, you said yes, sir. Good thing. Good thing.
My lord has to examine the committee report. But we do not
examine
have
every ಬಹಳ ತಲೆ ಕೆಡಿಸುತ್ತಿರಲಿಲ್ಲ. ಇದು ನಮ್ಮ ಯುವಕರಿಗೆ, ನಮ್ಮ ಯುವತಿಯರಿಗೆ ಸಂಬಂಧಪಡುವಂತ ಕೇಸ್ ಇದು.
we are wrong, my lord.
ಇದರಲ್ಲಿ ನಾವು ಸ್ವಲ್ಪ extra mile we have decided to walk.
My request to your lordship is, my lord, the letter dated
ಮಾಡಬೇಕು ಅಂತ order.
As your lordship said, whatever is recorded is part of it. I'll supply. Whatever your lordships are during the
Departments heard. All departments.
All the departments.
By the government on the government. By letter dated 21/3/2025, addressed to the secretary of KPSC. ಅಲ್ಲೂ ಸರಿ ಇಲ್ಲ ಪೊಲೀಸ್ ಸಮಸ್ಯೆ. At least the CID, that is the reason we requested panel counsel for the CBI to be sitting here. ಅಲ್ಲಿ ನೋಡಿ ಅಲ್ಲಿ ಅಲ್ಲ ಹೆಚ್ಚಿನ ತನಿಖೆಯನ್ನು ಪೊಲೀಸ್ stroke CID.
What happens in the FIR, we have to, it has to be recorded before the jurisdictional police. Then it will be transferred to CID for.
At least ಹೇಳ್ಬೇಕು. ಇಷ್ಟು ಮಾಡ್ಕೊಂಡು ಏನೋ ಒಂದು ಪೊಲೀಸ್ ಸ್ಟೇಷನ್
page
ನಾವು ಫೈಲ್ ಮಾಡುವಾಗ
column 3 ಅಲ್ಲಿ
ನಿಮ್ಮ COD
CID ಅಂತ ಬರ್ತಿದೆ.
SOP ಇದೆ ಅಲ್ಲಿ.
Correct.
How matter will go to COD? How matter will go to
first the complaint is
SOP ಇದೆ.
ಇದೆ.
ನೀವು ಇದನ್ನ ಹಂಗೆ ಹೇಳ್ಬೇಕು. Learned Alberkadi, sir, having in principle agreed with the recommendation of the committee, I'll put forward the steps. First off, when we drew attention of learned AG to para 3 in the table as to entrustment of the investigation to police stroke CID, They may do. First, if not done, right to file, that stands absolutely forfeited.
But instead of first plot, second, 1 day.
Second ರಜೆ ಇದೆ ಅದಕ್ಕೆ.
ಇಲ್ಲ ರಜೆ ಇಲ್ಲ.
Second, all right. Second. All right. That's day ಇದೆ ನಮ್ಗೆ. ಮುಂಜಾನೆ ಅಷ್ಟು actually ಮಧ್ಯಾಹ್ನ ಏನಿದ್ವಿ at 2:30 ಮಾಡ್ಕೋ. Further hearing at 2:30. Yes, thank you to everybody. All right. ಅಲ್ಲಿ interim order to interim arrangement to continue till 2nd of April only.
Sir. Matter was ಯಾವ ಕೊಡಿ ಅಂತ.
ಯಾವುದೋ ಒಂದು ಕನ್ವೀನಿಯಂಟ್ ಇರ್ತದೆ. ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಕೊಡಿ ಸರ್ ಒಂದು ಡೇಟ್ ಕೊಡಿ. ಎಲ್ಲಿ ಕೆಲಸ ಅಲ್ಲ ಡೇಟ್ ಹಾಕಿ ಸರ್ ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ, ಇಲ್ಲಾಂದ್ರೆ ಮತ್ತೆ ಬರೋದು ಬರೋದು ಮತ್ತೆ ನೆನಪು ಬಂದಿದೆ. ಆಫ್ಟರ್ ವೆಕೇಶನ್
ಎಲ್ಲ
ಫಸ್ಟ್ ವೀಕ್ ಆಫ್ ಜೂನ್ಗೆ ಮತ್ತೆ ಬರಲ್ಲ, ಇಲ್ಲ ಮತ್ತೆ ಮೂವ್ ಮಾಡ್ತೀನಿ. ರಾಘವೇಂದ್ರ ಸರ್ ಜೂನ್ ಸರ್ ಓಕೆ ಸರ್, ಥ್ಯಾಂಕ್ ಯು ಸರ್. ರಾಘವೇಂದ್ರ ಸರ್ ರಾಘವೇಂದ್ರ ಜೂನ್ 4th ಸರ್ ರಾಘವೇಂದ್ರ ಸರ್ 25 ಸೆಲೆಕ್ಷನ್ ಇಬ್ರು